A bar association resolution has been circulated to the judges which says that we should take up only urgent matters and not take up expertise matters, and also so that the matters retain their position in the list. If we add any matter, that will pile up the list. So we are not taking up any inclusion on the resolution days. Please come back on a non-resolution day, we'll take up inclusion.
Only application.
Nothing.
My lord, may I be allowed to?
No, we are not taking up inclusion matters.
No, not inclusion. My lord, may I be allowed to mention virtually, because I had undergone.
Yes, what are you mentioning, Mr. Sengupta?
Madam, only for leave may be granted to file the memo of appeal without certificate copy.
Where is that? That has
Madam, that my junior is there.
No, nobody is there.
Is there. Yes, he is, my lord. My junior
not
is
your
there.
Junior, some person who is not an advocate is there. We can't grant in this manner. An advocate has to
kindly, my junior, my lord, kindly.
Your junior is not there, Mr. Sengupta.
Somebody kindly. My lord.
Extremely urgent matter is appearing in the list, my lord.
No.
Lordship, may I be permitted to pray for upgradation?
One, accordingly, FAT number 443 of 2023 is allowed on contest, thereby setting aside the judgment and decree dated December 6, 2023, passed by the learned additional district judge Khatra, district Bankura in matrimonial suit, and decreeing the said suit, thereby granting dissolution of marriage between the parties by way of divorce. No rest to cost, formal decree be drawn up. Accordingly, FAT 469 of 2025 is allowed on contest, thereby setting aside the impugned judgment and decree dated such and such, whereby the plaintiff of the said suit was rejected. The learned trial judge shall now adjudicate the said suit on its own merits by way of a regular and full-fledged trial on evidence. While doing so, the learned trial judge may frame and decide issues on the identity of the subject properties involved in the present suit and title suit number 17 of 2002 and or res judicata, if necessary and permissible in terms of the pleadings of the parties, and decide the same prior to the other issues involved in the suit. We make it amply clear that this court has not entered into the merits of any of the questions raised before us. It would be open to the trial court to come to its own conclusions upon trial on merits by taking evidence and, if necessary, by appointing a survey past advocate commissioner to compare the properties in the context of the title deeds of the parties and the schedules of the two suits.
I'm grateful.
Congratulations.
My lord, I am
Trying for the respondent wife, my lord. We are not made informed, my lord. This matter has suddenly come up.
Why is it appearing?
my lord, for release, my lord, from my lord's list.
So kindly
Is
do not
appearing.
release this matter, my lord.
Who is appearing? Why should I release? We should release.
My lord, we have tried multiple times for mentioning this matter, but this bench, we understand this bench is very much overburdened, my lord. As I made my client understand, and my client has instructed me to release this matter, and we might try.
How do you know? Learned, you are for the petition appellant.
Yes, my lord.
Learned, counsel for the appellant seeks the bench to release the matter on the ground that hearing of the appeal is not being included in the list. However, since this bench has determination to hear such matters, and it is not possible only due to the heavy load of matters pending in the list to include the matter, we do not deem it a fit ground to release the matter merely because it is not being included in the list at the present. Accordingly, such prayer is refused. Grateful, my lord. Give your appearance. Next.
Lord, this is for filing of the written notes. It's lying ready, but I'll hand it over to your lordship's officer. My lord may record it.
For the respondent.
I'm for the respondent. I can.
No, the appellants are in any event not there.
But I can. I will within 5 minutes. I'll deposit it.
You will deposit, but the appellants also have to deposit. We will put it tomorrow. Learned counsel for the respondent seeks to file the written notes of arguments during the course of the day. However, the appellants are unrepresented. Accordingly, let the matter stand adjourned for the day.
Or my written notes is.
No, keep it with you. We'll take it together. Tomorrow it will appear under the same heading.
Lord, I'm sorry, Lord, I could not.
I'm extremely sorry, Willard.
Yes, 6 to 8 who is appearing.
Lord,
I'm appearing for
I'm extremely sorry, Willard.
Yes.
Read.
Yes, Mr. Mukherjee.
Well, this is my application under Order 41.
তোমার কি মাথাটা খারাপ হয়ে গেছে নাকি
Your Lordship, I appear for the respondent.
Application under Order 41, Rule 27, my lord.
Yes.
My lord, for some additional documents which, my lord, we intend to rely on.
So you want
And
us to direct this to appear along with
My lord,
Only
I
that.
was also praying, my
Lordship,
lord,
I
if you could seize, my lord, the matter, my lord, seeking some precedence in the matter also, my lord.
it's
Yeah, my lord,
appearing in
your
the
lordship will
list.
see.
Appearing in the
It's
list.
appearing in the list. My lord, if your lordship sees one of the previous orders, your lordship, my lord, there was an urgency. This was a LRTT appeal. The matter was heard day-to-day basis. And my lord, there's an order of injunction also which we are suffering right now, my lord.
No.
I am the
70
petitioner, my lord. Here. My lord, there's a
70 years.
my lord,
Lordship, I appear for the respondent number 6 in this matter.
Yes, we
Your
direct
Lordship,
only the
taking
order
up this-
41 rule 27 to appear along with the
Your Lordship, I would like to file an
number.
affidavit.
my lord, can one is the application. My lord, these are appearing as item number 6, 7, and 8 right now.
My lord, there is a direction to file the affidavit in opposition, my lord. Let me file that.
Is already a direction to file affidavit to what?
In the main
Written
petition.
application, writ petition. That is
So
WPL.
when we take up the matter for hearing, we will file that.
My lord, kindly allow.
They are already
Not
enjoying
hearing
an
the
interim
matter.
order of
Its
stay.
appearance to be mentioned.
My lord, another thing, my lord, this can, my lord, they have brought some records, the
Well,
documents which
we
are.
will direct you to file written objection to that.
Opposition. yes,
Written
my lord.
objection can
Yes,
be
my lord.
filed, my lord. If your lordship fixes a date, I was requesting if
sir.
it's possible, my lord. If
Because
your lordship sees
this-
your lordship's
Lordship, these are
previous
voluminous
orders also,
documents, Your Lordship. They
Matters
they
are already
taking
appearing
on
in the
record.
list
We'll like to file an
for hearing. Full stop next para, learned counsel appearing for the. You are for which party, Mr. Mukherjee?
Well, I'm for the petitioner in the
In both.
my lord, item number 6 and 6 and 8. 6 and 8, I'm the writ petitioner.
I'm appearing for the-
Your Lordship, I appear for the
Counsel for
respondent number
the-
6.
Petitioner in WPLRT 126 of 2025 and WPLRT 140 of 2025 seeks an upgradation of the matter and a direction for the connected applications under Order 41 Rule 27 of the Code of Civil Procedure to be directed to be heard along with the main writ petitions. First of next para, since the matter is already appearing in the list, comma, there is no scope of immediate upgradation of the matter. Full stop next para. However, comma, the respondents are directed to file their affidavits in opposition to the applications under Order 41 Rule 27 of the Code of Civil Procedure within a week from date.
My
Full
lord,
stop.
kindly allow 2 weeks.
Within a fortnight from date. Full stop. Reply if any shall be
Your Lordship,
filed.
within a week, Your Lordship, kindly give us 2 weeks time.
Reply if any shall be filed within a week thereafter. Full stop. The said applications bearing can 1 of 2026 shall be listed along with the main writ petitions as and when the latter are taken up for hearing.
Great, Your Lordship.
My lord, your lordship had previously noticed, my lord, there is some urgency.
No, they are already enjoying an order of stay.
No, my lord, my lord, there's a-
Already.
You cannot oppose a
Order-
prayer for urgency.
buildings
No,
are
Lordship, I am
being
saying that
constructed,
they are already, they
constructed
have
and,
got
my
a
lord, we're
stay
not
order.
being able to sell, my lord.
Other matters
Every
also
day there is
matters.
a
Impugned
No,
order has been stayed.
Next
Item number
matter.
7, my lord, also opposition.
Keep it with you. Keep it with you. Yes. When you hear the matter,
Appear
fine.
on behalf of the respondent.
Yes.
Lordship, on the last occasion, we have filed and connected application, my lord.
Why is it
recording
appearing as
that,
to be mentioned, Mr.
my lord, because of the fact that terms of settlement has already been entered into lordship. Now, whether we have made payment or not, lordship has kept it for ascertaining that, my lord.
Yes, yes, yes.
My lord, we have already made over the sum that has been agreed upon on Friday, my lord. My learned friend will perhaps not counter that.
So if they have paid, then what remains?
Your lordship may kindly takes up the matter on after
If they have
1
paid
week.
the amount, you have
Lordship.
got a receipt.
Yes, my lord.
They have paid the amount. It is
You are agreeing
reflected-
that they have paid.
Yes, it
Very
is
good, then
reflected
they
in our
record that.
account, lordship. But
So then we'll this challenge is against a divorce decree.
lordship,
So we'll dismiss your appeal as for non-prosecution in view of the payment having been made in terms of the agreement between the parties. We'll say that. Learned counsel for the respondent submits that the agreed amount of permanent alimony to the tune of rupees 25 lakh has already been paid to the appellant wife by the respondent husband. Full stop. Learned counsel for the appellant agrees to the said submission. Full stop. Next para. As such, comma, since the parties have arrived at a mutual settlement to part ways, comma, on the prayer of the appellant, comma, FA 161 of 2025 is dismissed for non-prosecution in the light of the agreement arrived at between the parties. Full stop. Next para. Can 3 of 2026 as well as can 2 of 2025 are also disposed of accordingly. No order as to costs. Next. আগের দিন রেকর্ডই করেছি অয়ন বলেছিল যে কি জন্য আছে জানেন? এটা কি লিস্টে এমনি অ্যাপিয়ার করছিল না, ডিফেক্টিভ রয়েছে। কি ডিফেক্ট দেখি? Although the matter is appearing in the list under the heading to be mentioned, upon being mentioned by learned advocate for the appellant, comma, none appears at the time of call, full stop. It transpires from the report of the stamp reporter that there are several defects in the matter, full stop. The learned advocate on record for the appellant is granted liberty to carry out the necessary corrections to the memorandum of appeal in order to rectify the defects. Full stop. The appellant shall also file the certified copies of the judgment and degree of the trial court as well as the decree of the first appellate court in the department at the earliest, full stop. Upon such certified copies being filed, comma, liberty is given to the appellant to mention the matter for inclusion in the list under the heading Order 41 Rule 11. Next.
My lord, I appear for the respondent. My lord, as per your lordship's last direction, my lord, we've prepared our written notes. My lord, only one thing, if I may just indicate. My lord, just I did not want to repeat my whatever I had given in the chart. So, my lord, I have already filed a chart at the time of making my arguments with regard to the point of suppression. My lord, I have not
Just file your written notes.
Yeah. My lord, I have indicated the chart also. My lord, that is with your lordship.
The written notes of arguments filed by both parties on the alimony application be kept on record, full stop. The matter is reserved for orders on the alimony application. It will appear as for orders when we decide.
My lord, may I make one prayer, my lord, for expediting the appeal?
No, not now.
Very-
First, let us decide.
Very.
এটা ওনার কাছে পাঠিয়ে
Item number 12.
Your time for the appellant, it has come for direction to file informal paper books and bringing LCR, PCR for by special messenger possible. Otherwise,
deficit court fee of 19180 is
What?
there. There are deficit court fees of 19,180. You have to put in that.
I think proper court fees is paid. This is the order.
No, but there's a report.
Oh, then I shall
Subsequently, have deposited.
I will put in.
No. This report is there. You have handed up this.
Yes, thereafter, a deficit court fee is paid.
Are you sure? We'll say that.
Yes, yes.
No, but
Out of this I paid.
where is that receipt or entry number?
My problem is not this.
Clerk is not there.
It is wrong file has come. It is another file. Office copy
Oh,
has
acha,
come.
Yes, you are right.
I
No,
personally
there's a note also. Subsequent note. No, Mr. Chakoti, there's a subsequent
Personally,
note
no.
also that you have paid the deficit. My learned brother rightly points out. Very well. Thank you. We find from the office report that deficit court fees have since been deposited by the appellant. Full stop. Next para, learned counsel for the appellant seeks directions for expeditious hearing of the appeal. Full stop. Accordingly, the appellant is directed to put in postal costs, requisites, and written up notice form
That has
within a
been
week.
paid. That also notice has been served.
Notice has been served. So what remains, Mr. Chok? Records are to come.
Direction to file informal paperwork and LCR, TCR has to be brought.
Very good. আচ্ছা
Putting special messenger.
তাহলে লাস্ট সেন্টেন্সটা করবেন না লার্নেড যেটা বললাম লার্নেড কাউন্সিল ফর দ্য অ্যাপিলেন্ট সিক্স ডিরেকশনস ফর ইয়েস ফুল স্টপ we are also informed that the notice the requisites for service of notice of the appeal have already been deposited. Full stop. Next para, accordingly the trial court records be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
Special messenger passed by
1 week.
1 week.
1 week.
Lord, in item number 13, I appear for the appellant, my lord.
Yes.
I have oral instructions to withdraw this appeal with the liberty to file afresh, my lord.
Why liberty to file
My
appeal?
lord, the grounds that are set in, my lord, that are not satisfactory to us.
Very well. Learned counsel for the appellant submits that the appellant seeks to withdraw the appeal with liberty to sue afresh on the self-same cause of action, comma, since the grounds mentioned in the memorandum are not adequate. Full stop. Next para. In such view of the matter, comma, FA 36 of 2026 is dismissed as withdrawn with liberty to the appellant to file a fresh appeal with the fresh appeal on the self-same challenging the self-same impugned judgment and decree. No address to cost. But
Only-
file it immediately, otherwise you will be hit by limitation.
My lord, only one liberty may be given to get
Take
the
back.
certified copy, my lord.
The learned advocate on record for the appellant is granted leave to take back the certified copies of the impugned judgment and decree from the department for the above purpose,
Grateful.
upon furnishing photocopies of the same.
Grateful.
Item number 14.
Yes, Mr. Thakur.
Very narrow scope of review, as in all review applications. Very narrow scope, but I think there is a scope, my lord. Very short scope, my lord.
Yes.
Admittedly, I am 1/6 owner of a building which is used for residential purposes in North Calcutta. Joint family ownership, I am 1/6 owner, admittedly, there's no dispute about that. My lord, on 2nd of February 2022, an order, 2nd of February 2022, an order was passed by the municipal corporation under section 412A, declaring it as a condemned structure and giving directions for building, rebuilding, renovation, whatever is required to be done has to be done. Now, my lord, as is common these days in joint families which are no longer that joint, my lord, 5/6 of the co-partners sell the property off to a builder, sell off their undivided 5/6 share to a builder. The schedule also records this is undivided 5/6 share of a building which is declared as a condemned structure or an unsafe structure. The conveyance also records that. Now the builder becomes owner of 5/6 share of a condemned structure. Now the building is tenanted. As all builders are required to do, they try to have the tenants evicted, of whom I also have a share, undivided 1/6 share. Tenants have atoned tenancy to me. We are all joint owners, joint landlords, so to say. Now, with this, in this position, I filed a suit for declaration and injunction.
You are a tenant.
I am the owner.
You are
1/6 owner.
That 1/6 owner.
I am 1/6 owner.
Yes, right.
I am the one of the co-partners, owners of 1/6. 5/6 co-partners sell off a building, undivided 5/6 share, the conveyance records.
You are now joint owners with the developer.
I am joint owners with the developer.
Right.
Now, what the developer is trying to do, as he wants to develop, it's understood, he tries to change the owners, the occupation status of the building, tries to displace the tenants. I am aggrieved by that because the tenants, I am 1/6 landlord of the tenants, so to say.
All right.
Now, my lord, so I file a suit for declaration and injunction. That this cannot be done without there being a partition, tenants have to atone tenancy, OLT, whatever has to happen, has to happen. In that suit, my lord, an order is passed, ex parte ad interim order is passed. I challenge the deed of conveyance also, claiming rights of preemption, whatever, that is a separate matter. And I file this suit, my lord, in that suit, an ad interim order of injunction is made, restraining change of nature and character of the building. The developer comes, the builder comes, he takes out a vacating application. Simpliciter praying for vacating on the ground that this building requires to be rebuilt under the court because of the corporation order. And he files an affidavit in opposition also. The injunction which I was enjoying is vacated. I come up in appeal before your lordships.
Injunction application is kept pending.
No, both disposed of. Vacating allowed, injunction application also disposed of. Both heard together, disposed of on the ground that there's a suppression. The corporation notice was there of 2012, and there are subsequent notices also which require the building to be redeveloped. On that ground, short ground of suppression, that is vacated. I come up in appeal before your lordship. Your lordships are also pleased to hold that yes, this was suppression, material suppression. And on that ground, the order was rightfully vacated. Matter ends there, my lord. I have no difficulty. What your lordships go on to do is, my lord, your lordships pass directions in the nature of, if I may say, with all humility, my lord, mandamus, directing compliance of corporation directions.
Which part?
Kindly have, my lord, the operative portion of the order.
You say that is beyond jurisdiction.
With the greatest of respect, there was no prayer. My lord, why I say beyond, my lord, your lordships, the High Court has, my lord, all the plenary jurisdiction.
No, otherwise we have, but
in a suit, yes, my lord, in a suit, and from an refusal of an interim injunction. And my lord, kindly also bear in mind, the vacating application did not have any prayer. I could have understood that the developer made prayers. In the vacating, he made a counter prayer or positive direction seeking a positive relief that the owner plaintiff be directed to comply with KMC, etc. That would have been beyond the scope of my suit without a counterclaim. But even if I take it that he could have made such a prayer in the vacating, that could have come up for consideration before your lordship if a cross appeal was there. But there was no cross appeal. My appeal was limited to this. There was no pleading in the suit for compliance or no relief sought in the suit for compliance with KMC directions. My lord, the KMC statute provides a scheme. That section is like a complete code as to what is to be done if the owners do not comply. The corporation frames a scheme for development, taking into interest the accounts of taking into account the interests of the owners as well as the occupiers. That is the complete scheme. Now, my lords, by this order, now what has happened is subsequently, with your lordship's order granting a kind of a positive mandatory injunction, giving a builder the free hand to do everything he wants. The builder goes and files a boundary declaration and submits plans for development of a new structure there, thereby affecting my 1/6 right, affecting the rights of, my lord, third parties who are the occupants who are not heard. Because my lord, rebuilding is a common ground under the Premises Tenancy Act, but there has to be a reinstatement agreement.
But you cannot espouse the
No, I'm just saying it affects rights of third parties also, of whom, my lord, I owe as a landlord, my lord, yes. These are tenants who have atoned tenancy to me. So, my lord, not only is a party affected, but a third party is also affected. Third parties are affected. Their reinstatements agreements are not there.
Could there be unilateral atonement to you?
No, atonement is to all the landlords.
Yes, all the
grateful, my lord.
To you also, yes.
To me also, yes. So now, my lord, obviously, my lord, I am an old landlord. This is a developer who comes in. Your lordship understand the practical situation where the loyalty lies. And this is a developer who's bought it after it's a condemned structure. He has come in for the business of developing the property.
Obviously,
yes.
Since it's a condemned.
Yes, that is how it happens, my lord. Developers get.
So let us see the
just kindly see that portion of the order.
16 onwards.
Kindly give me a minute.
Yes. Page 28. Page 28.
Page 24, your lordship's
so just
order start.
Internal paragraphs.
Yes, kindly have
16 probably onwards.
16 onwards. Yes, 16 onwards. I'm so grateful, my lord. Appellant as well as the respondents are permitted, KMC Act, permitted to jointly apply for sanction plan in terms of the order under 412A within a fortnight. Upon such application being made, KMC shall expeditiously process the same in accordance with law. In order for the parties to make joint construction in terms of the order of the KMC and as per the approved sanction plan. So, my lord, these have been taken as directions of the court upon KMC to pass the sanction plan, even if I do not participate. Now, kindly see 18. In the event the parties do not or cannot come to a consensus and file a joint application for such sanction plan immediately upon the expiry of a fortnight, the respondents by themselves will be at liberty to file such application for making constructions in terms of the KMC order. Now, this is not what the KMC Act contemplates. Kindly have the KMC Act once. Can you see 412?
Yes.
4, please, my lord. This is the situation which your lordships contemplate. 412A4, please, my lord.
Yes.
In the event of disagreement or disinclination on the part of owner or owners, as the case may be, to avail of the opportunity contemplated under subclause 3, the owner or owners, as the case may be, keeping the building in dilapidated condition, which may likely cause the environment pollution, fire hazards, etc., shall be subject to such action as provided in the law for the time being in force. So the KMC takes action. Then kindly see, subject to the provisions of this section 5, the corporation may cause development work in respect of the dilapidated building in such transparent manner and on such conditions as may be prescribed by scheme by the corporation. Similar, if the owners...
Mr. Thakur, 2 questions to you. One
Please.
is regarding the first portion, we are permitted to jointly apply. So
Please,
that's optional. Second part may hit you. Because if you don't agree to that, then there's no joint application.
Then
in terms of 16.7. But 18 onwards may hit you. So 18 is a liberty to them to file an application. If they file an application, KMC shall duly process the same as expected. This duly process the same has to be in accordance with law.
No, my lord, then the...
So we have given the liberty to them. We have not passed any direction on the KMC to do anything.
No,
beyond the law at least.
What happens, my lord, that with this order, my lord, they have applied, we could not agree on the development.
So first part goes.
Which goes.
So
Now
they have the liberty as per our order to file an application for making construction in terms of the KMC order.
KMC. Now,
if that is applied for
now, my lord, this with the
this is
greatest
a liberty given to them.
with the greatest of respect, my lord,
Yes.
liberty given to them to file an application, my lord. An application will not be entertained by KMC without sign of all the owners. But because of the liberty given,
it will be processed by
well, it has already been processed.
The same as expeditiously as possible.
It has already been
now,
processed.
Duly process has to be in accordance with law. We can clarify that.
You kindly provide.
I mean, in this review,
your
clarify that this will be this. What we meant is that this duly process, this will include in terms of law, in accordance with law, whatever the law provides. If law provides,
my lord, if your lordships provide them the liberty to file an application,
yes,
then your lordships contemplate that he can independently file such an application.
That is the terms given by the KMC notice.
With the greatest...
Because we have said we will be at liberty to file such application for such application that relates back. Because if you come to
the KMC order,
yes, clause para 16 of our order,
yes, please,
in terms of the order dated February 2, there is already an order of the KMC.
Yes, that is the 412 order. Now, that order itself on the section, that is why I troubled your lordship with the section. The section itself provides what happens if the order is not acted upon. The KMC...
KMC will say that the law does
no, my lord, because but your lordship has given them the liberty to carry out the construction. By themselves apply for...
No, we have not said that.
No, my lord, your lordship has given them the liberty to make application.
We have given them the liberty. If you don't agree, they will be at liberty to file such application for making construction in terms of the KMC order.
So, yes, so my lord,
there is a KMC order. In terms of that, they can make an application, and in such event, the KMC shall duly process the same.
So, my lord, this...
Where is the, direction on the KMC? There is no direction on the KMC.
No, my lord, the 2 things, my lord.
They won't be prevented from filing an application in terms of the KMC order.
My lord, with the greatest of respect.
So the KMC order was the primary material fact which was suppressed.
I'm grateful, my lord.
I mean, that is the plinth of the
I follow, my lord. That is the plinth of the order. That is...
It's a natural fallout of this order.
With the greatest, kindly, my lord. With all humility, I say, my lord.
You need not give the adjectives,
no.
At least before us.
My lord, these directions, my lord, kindly contemplate a situation whether these directions fall within the relief sought in the suit or the relief sought in the vacating application.
These are not directions, these are liberties.
My lord, these are observations of the High Court. Even if I say these are observations, my lord, an observation of the High Court on a statutory authority granting liberty to a party to make an application which otherwise the party does not have, my lord. Owners have to apply together. all owners have to apply together, otherwise it is not accepted. Now your lordship gives.
Does it say in the
Yes,
prospectus?
your lordship sees disagreement between the owners for in the event of disagreement on the part of the owner or owners. So it's contemplate. The act contemplates that all the owners may not agree to this. And then what does the KMC do? The KMC itself forms a transparent scheme. This is the remedy given in the act for an order made under 412A, which your lordship says.
No, this says that they shall be subject to such action as
Correct.
provided in law.
Yes, so that is, my lord, penal action, punitive action, where this respondent would have the defense that I was ready to do, this owner was not ready to do. Whatever his defenses are, my lord, that is the KMC to decide.
You are even
This-
agreeable to the building being demolished by the corporation
And doing,
not to make an application for construction.
my lord, the application has to be in agreement with the. Now your lordship sees what happens. He makes the application, he gets the right to develop. He gets the right to develop. It decides a partition suit, it decides an action for OLT, it decides everything, my lord. He gets away with development, which is what he
You
wants.
say this liberty also is beyond the scope of 4.
My lord, I say with the greatest of respect, the liberty is beyond the scope of the suit, beyond the scope of the appeal. There was no relief sought in this regard by either party. My lord, it was kindly contemplate, man, what the suit is for: declaration, injunction, and for cancellation of the sale deeds. In the scope of that suit, an application for vacating is filed, saying simpliciter vacate the order. There's no mandatory injunction sought that direct the owner plaintiff to comply with the KMC order. There was no.
Mr. Thakkar, probably this joint application liberty, you have up to this you have an option not to agree.
Yes, please, my lord.
But after that, if we said that
We disagreed.
In the event you disagreed, if the parties do not and cannot come to a consensus,
Then, my lord, the law takes its course.
so that would suffice.
The law takes
That
its
would
course.
not be.
No, the law would take its course. Your lordships perhaps were thinking of doing complete justice, that both parties can be protected. Whatever was falling through your lordships.
Apparently that, because
Yes.
otherwise
Yes.
it will be demolished.
It will not serve anybody's interest. I follow that, my lord. The
Demolished
developer,
by the corporation.
the developer wants to develop. It's for him. It's a commercial project. I have no difficulty there. But, my lord, then the partition has to happen. My share has to be the.
Undoubtedly, though.
Yes, so, my lord, these.
Open also.
Yes, now, my lord, when he develops it entirely on his
We
own.
have also that probably is not a good ground, Mr. Thakkar, because please come to para 20 and 21 of the order.
Yes.
We have said that we do not enter into merits. That apart, 21, none of the parties shall be entitled to claim any special equity.
I am grateful, my lord. Your lordship
That
has
is very
protected.
clear.
Yes. I'm sorry, my lord, I missed 20.
By the construction, nobody
Hold
will
on.
get any special equity.
But
Your
my-
partition suit won't be
Yes.
affected.
So, my lord, now
But at least you'll get at least the building can be constructed before the corporation demolishes it altogether.
my lord,
It's like that story, Mr. Thakkar, that a dispute between the whose child and
Yes,
the
the
king
child.
said that let the child be divided in half, and the person who said yes, agreed,
is
not
gone.
given.
Yes.
I mean, it's like that. You are asking for the child to be divided in half.
No,
You are
my lord.
asking for the building to be demolished before
No, my
they
lord,
can.
your lordship works.
I-
Kindly sees it from the commercial angle. That's all I'll leave it to your lordship.
What commerce if the building is demolished
the
without
commerce-
any liberty?
Commerce is
But
that.
we have not given them a right. We have just we have
No,
not
my
opened
lord,
up a right. also.
18 up till 17.
So 18, you may say, Mr. Thakkar, that law does not contemplate such an application being
Yes.
made unilaterally.
Unilaterally. And the consequences of 412A, which your lordship is troubled by, is given in the act itself. The KMC will construct, taking in a transparent manner, so all the stakeholders will be involved. Well, not only me, the tenants have to be reinstated if the building is constructed. The rehabilitation of the tenant has to be. They have all that area has to be.
Tenants' rights, they are protected by law, Mr. Thakkar. The tenancy rights do not go automatically. That's settled.
So that is why, my lord, now all that has to
This
be.
does not open that up.
No, my lord, that has to be an agreement with all the tenants. They have to be.
But that is
Transferred.
what is meant by duly process the same.
Correct. Not a
Duly process may also be rejection.
No, my lord, your lordship says application right
This
to.
may go in a different way to the.
Yes.
Very
And it has been accepted. My lord, my contention has been.
applied
Yes,
and
yes,
it has
they've
been
applied. They've got the boundary declaration done, which is the first step for starting construction.
Let us hear Mr. Baswan.
My lord, on the scope of review, if your lordship wants just one, my lord. Your lordships are well aware, my lord. It might be argued that this is.
No, this is error apparent on the face of record.
Yes, my lord.
If this is an error, it is
Yes.
apparent on the face of
Yes, my lord, and it.
We are not required to look into anything else.
You're not. Yes,
So this says that.
this says that, my lord, and granting a relief which none of the parties have pleaded.
Oh, no, that cited. Yes.
My lord, 54 to SCC 42, if your lordship will kindly have. my lord, one of the golden era. Kindly have, my lord. Every time I read this, my lord, it comes up with more propositions. Kindly see
Yes. Which, any paragraphs in
45, if your lordship kindly have. Yes, sir. Sir, ke dao ekta copy. I'm sorry, kindly have, my lord, 48 at page 80. It will be noticed, your lordship has it.
Yes.
It will be
yes,
it will be noticed that this agreement issue 11 related only to certain specific powers of the patriarch. The findings of these issues by themselves do not lead to any result. Then all these issues are there. Then kindly the majority judges, kindly say after Placitum, the majority judges have however certainly gone into 3 matters which were then agreed to be left out. All these things are there, has the right to approach. Then kindly see these matters at the next page. These matters are not averred in pleadings, and no specific issues have been raised, and in the circumstances should not have been gone into. The suggestion is that these points are covered by other issues. It is said that the learned judges this, and kindly see the next paragraph. These points are said to be covered. Assuming it is so, it is clear that the learned judges also found themselves so and so which do not appear to fall within any of these issues. To decide against a party on matters which do not come within the issues on which the parties went to trial clearly amounts to an error apparent on the face of the record. It is futile to speculate, and this was in entertaining a review, my lord. Then kindly see 49. We accordingly allow this appeal, set aside the judgments of the High Court, and admit the review. The matters were remanded to the High Court to be heard on review.
Yes.
Well, that is the short point, my lord.
Yes, sir. Please confine yourself to 18 onwards.
Yes. This
18 and 19.
Only thing, my lord. But kindly consider what is the situation by which your lordship, the model was vacated. Vacated on the ground that building is dilapidated for 412 invoked, meaning thereby the any moment building can be collapsed. The technicalities, whether this is pleaded, not pleaded, court when the approach is made to the court will not shut his eyes to this fact. If today there is no injunction granted, then building will collapse. There will be dangerous thing, person will lose their life. Tenants are there. In that juncture, my lord passed this order. What is the order? My lord has read out 412A, the complete code by Mr. Thakkar said. This complete code specifically says, my lord, what is to be done. Kindly read 3II. Simultaneously with the making of the declaration under clause 2, the corporation will serve a notice upon the owner or owners, as the case may be, and paste it on the outer of the building of the provided in the option of the owner or owners, as the case may be, of the building, to reconstruct the building according to the plan to be sanctioned by the corporation with such expedition as possible, and providing for maximum floor area necessary such and such. So, my lord, notice was given to them also. They chooses not to, my lord, construct. Then, my lord, comes in Roman 4. In the event of disagreement, on the part of the owner or owners, as the case may be, to avail of the opportunity contributed under 3, the owner or owners, as the case may be, keeping the building in dilapidated condition which may likely cause the environment pollution, the hazards unable to save safety, such and such shall be subject to such action as provided in the law for the time being in force. Then question comes in, how to be constructed. What my lord has directed?
No, it only says shall be subject to such action as provided in the law.
Corporation
so the
can
law,
do.
Corporation can.
The corporation can come 5. Now, in this context, my lord has granted the liberty to the owner, one of the owner, to apply.
That is not contemplated in 412A.
I know that. This is troubling, my lord. But my lord has not said that on my application, he will grant sanction.
We carved out that leave for you, Mr. Basu, which is beyond the scope of the statute.
No, the leave, even if, my lord, there is no leave, then state 5 will apply.
We'll make it clear that
5 will apply.
We'll delete that leave.
It cannot be in limbo, my lord. The condition is
cannot
the
be in
tenants
limbo,
are there.
but then law will take its course.
Right. Even if, my lord, I apply.
But by saying this in conjunction with 18 and 19, I mean, we gave you liberty, and if filed KMC will duly process the same, may create difficulty.
In accordance with law.
We have not said that.
My lord, can you make that in accordance with law?
But if you direct the corporation to process your application, unilateral application, which is not contemplated here, the law does not say that one of the owners can make an application even. Law says all the owners can together.
In case of disagreement, obviously 5 will come
Corporation,
into play.
corporation will do it.
5 will come into play.
So then this unilateral liberty to you is beyond the law also.
My lord, even if it is beyond the law, even if beyond the law, my
It
lord,
was not paid for by you also. That was.
no, that I say why the suppression was the basis for vacating the interim order.
No, we have to be careful. For ends of justice does not begin for end of justice.
No, not end. This is ends. The justice will be ended there.
It's beyond the law. What
My lord,
our
cannot-
direction in 18 and 19 is
cannot
beyond.
say, my lord, I cannot say that your lordships as this part is not written in the statute. This much I can say.
Generally, it's written in the statute.
Not written. But what my
This
lord,
parts of the
why my
statute.
lord has passed this order?
No, we cannot. We could not. We might have been reasons. Might have been justified reasons. We understand the reasons also.
My lord has not said that you, if I apply, you can be sanctioned to me.
No, but you don't have a right to apply even under the law unilaterally. That's the difficulty, Mr. Basu. We don't have the right to apply.
Then
This is in ignorance of law.
kindly consider the situation today. If today, my lord, nobody applies,
Corporation will
and, and corporation is also not taking any steps.
4-5.
4-5. Then if my lord direct to take steps under 400 rule 5,
Then you
again,
can take out a writ petition and
again, my lord,
by the writ court, not by us.
no, then again they will be saying that your lordship cannot pass this order.
This
The
was a-
corporation my lord, 5 to be invoked.
This was their suit for partition also.
No.
Preemption right was claimed.
Yes. No partition. There is another point.
Partition, there is no scope.
After
preemption right was claimed.
preemption right was asked for. But what benefit? Well, this is the dog in the backyard policy. I will not eat. I will not allow it to eat.
Not dog in the manger exactly. The corporation can do whatever it likes as per law. 18 and 19 cannot do it.
Well, that's true, but no right has been created. Only to leave to file. That's all. Not to grant. That my lord has not said.
We'll record your argument, but this.
Not grant, my lord, that you should sanction it. Sanction it.
Saying you have a liberty to file is also contrary to the law. You don't have a liberty to file in law, and we have granted you that liberty. That liberty is also beyond the law.
That, my lord, for the ends of justice, my lord, I passed this order.
Because
my lord, because of the situation as the building is dilapidated condition.
Ends of justice, we cannot flout the law, Mr.
There's not so many words, my lord. I
cannot flout the law. If there is no law, if there is no law, we can carve out something.
It is not flouting. There is no law. Yes, my lord is perfectly correct. Here is not said that you cannot apply. Had it been said,
law provides a course of action,
right,
which does not contemplate it. Rather, it clearly contemplates, Mr. Basu, in 3 that all the owners have to. If they don't, corporation does it.
Right. But so that's why I am not. It is not, my lord, written in so many words that one owner cannot apply. Allow me to argue this. This is not prohibition that one owner cannot apply. In that event, my lord, that is, my lord, separate thing, my lord. My defense is rightly pointing out. I do not want to. Ravi Lord said, 6 there, 5 is with me. 1 is putting the spanner. That it happens in commercial matters. I am not saying it cannot be happened. But if my application is not prohibited in law, expressly not prohibited, then my lord,
impliedly prohibited.
My lord, that interpretation from my lord. But I say, my lord, it is not prohibited in a situation like this. If the corporation thinks that so here, my lord, corporation can do it. So corporation can do it by any agency. If corporation thinks that I can do it without affecting partition this, that, then also corporation can give it to me also, or to my learned friends clients also. Corporation himself will not do. He will appoint agency to do it. Because of the fact, my lord, tenants are deciding there. Any moment
an agency of the corporation doing it, and one of the warring parties being given the liberty by the court, Mr. Basu, are entirely different.
I last time I will repeat.
And you are the developer because you want this only.
Yes.
So we are granting you a relief which is.
No, I am not asking for relief. My lord, is this court is
you
not
are
giving
rendering
me
the suit infructuous almost.
No, this court is suit, nothing to do with the suit. Nothing to do with the suit.
Very well.
Can you see the prayer in the suit?
Preemption right must have been.
So preemption, if today it is developed, if ultimately preemption, my lord, granted by the court, you will get it. We are taking that risk.
Get a different thing.
That,
he may not want what is built up there.
I know that. I know that. He may not be. He may. That my lord has said that child to be divided. That's the. He may ask that in the middle I will get my share.
No, let the midwife do it.
But
Let the corporation do it.
kindly.
Says it clearly. This is passed in ignorance of law. Absolutely.
No. At that moment, it is not stuck, your lordship. My lordship was read that order. It was placed by the council before my lord. It has not stuck, your lordship. Lordship's mind was on that date that it is a condition of dilapidated
Yes,
building. It
you
should be
understand the
protected.
premise on which this was given.
It was protected.
But this is contrary to law.
And my
It's
lord, the
equity cannot override the law. If there's a specific law, equity cannot override it.
I am not saying my.
That's our opinion. I mean, you may differ on that also.
Kindly
If
allow
there
me
is a specific legal provision, equity, it's crystallized in law.
my lord, I repeat, my lord, I am not been prohibited. None of the order is prohibited. That I am saying. But a prohibition does not mean that your lordship granted liberty. Liberty means grant. I am not saying so. I cannot say this. Grant will be on the basis of the statute. I applied, that's all, this much. Then whether the corporation will grant it, do it on himself, do it through other agency, that is with the corporation. Because 412 is a complete code. Capital A. So according to my humble submission, there is no, my lord, apparent illegality on the order of your lordship's court, where your lordship was specifically directed with granted liberty to apply and to corporation to stakes in accordance with 412A, because 212A is the subject matter which was suppressed. But kindly see those 16 to 20. This is the subject before my lord, nothing else.
Yes, Mr. Vasu, passing.
Nothing more.
Supplementary be kept on record. Malad, this is the registered.
What is this?
This is a supplementary showing the registered boundary declaration, Malad, which is
I'm not taking it.
Not. Your lordship will also, your lordship had rightly pointed out that it has to be by agreement. 412, kindly see 3, which my learned friend was
Yes, you have seen
the last sentence. In the event, the owner or owners, as the case may be, so agreeing and apply.
You have seen that.
It has to be by agreement.
There has to be a consensus.
Yes, I say, if
So
not
that Mr. Basu is also saying. He's saying there is no prohibition.
This is
And that
no
two things. He's saying two things. One is there is no prohibition. Secondly, that this was also within the subject matter of the vacating application and the.
Yes, the vacating
And
application also.
your lordship
the
has not
price.
granted the director corporation to grant it to me.
That also.
Would your lordship want to see the pages prior of the vacating application? It's only for this.
That is your lordship mind that we purchased the fifth share. One is Smiler left out. So probably that was also in your lordship's mind.
Might
to
have
give
been.
complete justice.
Might not have been.
Might have been.
Might have.
And when might have been is there, always might not have been is there.
Might may not be right.
So that was probably passing through your lordship's mind, so that the problem is sorted out, but without affecting the right he has claimed in the suit.
The appellant in an appeal preferred against an order passed by the trial court in connection with a vacating application as well as an injunction application has preferred the present application for review of the order dated December 23, 2025, passed in the said appeal. Full stop. Next para, learned senior counsel appealing for the appellant submits that the premise of the suit filed by the appellant stroke review applicant, comma, from which the appeal emanated, comma, was relief in the nature of rights of preemption exercisable by a co-owner of a property. Full stop. It is an admitted position that the appellant is 1/6 shareholder of the 1/6 owner of the suit property, whereas the respondents developers are at present the owners by purchase of the rest 5/6. Full stop. Next para. However, comma, it is submitted that while this court disposed of the appeal, comma, it went beyond the scope of the prayers made in the vacating application and or the written objection filed to the temporary injunction application in the trial court by the respondents, comma, by issuing directions in the nature of mandamus. For some next para, by specifically placing paragraph numbers 16 to 19 of the order under review, comma, learned senior counsel argues that this court granted liberty to both parties to apply for joint sanction plan in terms of the order dated February 2, 2022 under section 412 capital A of the Kolkata Municipal Corporation Act, 1980. Full stop. Not stopping there, comma, the court had observed that in the event there is no consensus between the parties in making such application, comma, the respondents would be at liberty to file such application for making construction in terms of the KMC order, comma, in which event the KMC shall duly process the same as expeditiously as possible. Next para, learned senior counsel submits that the said portion of the order under review is not only dehors the law as contemplated in the different clauses of section 412 capital A of the KMC Act, comma, which is a self-contained code, comma, but also beyond the prayers made in the vacating application itself by the respondents. For sub next para, learned senior counsel cites নামটা দেখে বসিয়ে দিও, reported at 1954 to SCC 42 in support of the proposition that in the event issues are decided beyond the averment in the pleadings and beyond issues which are actually raised before the court, comma, the same tantamounts to an error apparent on the face of the record coming within the purview of Order 47 of the Code of Civil Procedure. For sub next para, learned senior counsel appearing for the respondents, comma, while controverting the arguments of the review applicant, submits that no specific direction as such was passed in the order under review, but merely liberties were granted to the parties, comma, first to make a joint application and upon failure to do so, comma, to file for the respondents to file an application for making constructions, that too in terms of the KMC order. For sub next para, thus, comma, it is argued that neither any direction was issued nor any right was created by the said order. For sub next para, moreover, comma, it is contended that there is no specific prohibition in section 412 capital A of the KMC Act in one of the parties making any application, comma, on the failure of consensus between the parties to do so, comma, for making constructions in terms of the KMC order passed under clause Roman 3 within bracket of the said section. Full stop. It is further contended that since on failure of an agreed application by the owners, comma, it is open to the Kolkata Municipal Corporation itself to undertake the development work, comma, either by itself or through any agency, comma, there is no specific prohibition in the corporation deeming one of the parties to be such an agent for the purpose of carrying out the construction. Full stop. In the absence of any bar, comma, it is argued that it cannot be said that the relevant portion of the order under review was dehors the statute. For sub next para, insofar as the argument of the review applicant that the said part of the order was beyond the scope of the prayers made in the vacating application, comma, learned senior counsel for the respondents points out that the very premise of the application under Order 39 Rule 4 of the Code within bracket vacating application bracket closed was the suppression of the material fact of an order being passed on February 2, 2022 by the Kolkata Municipal Corporation under section 412 capital A of the KMC Act. For sub next para, it is further pointed out that the observations in question were made by the court for the ends of justice, comma, within the contemplation of the subject matter involved in the LIS, before the court. Full stop. Thus, comma, it is argued that there is no scope of review within the contemplation of Order 47 of the Code of Civil Procedure. Full stop. Next para. There are two parts. Upon hearing learned counsel for the parties, comma, this court is of the opinion that there are two parts of the offending portion, offending double inverted mode, offending portion of the order under review, comma, the first being comprised in paragraphs 16 and 17 of the same, and the second, comma, paragraphs 18 and 19 thereof. Full stop. Next para. In the first of the aforesaid two paragraphs, in the first two paragraphs, comma, that is paragraph 16 and 17, comma, permission was given to the parties to jointly apply for sanction plan, comma, which is well within the contemplation of section 412 capital A within bracket Roman 3 of the KMC Act. Full stop. On the other hand, comma, the second part, comma, comprised of the liberty given to the respondents, comma, on the failure of any consensus between the owners, comma, to unilaterally file an application for making construction in terms of the KMC order is evidently beyond the scope of clauses Roman 3 and Roman 4, comma, read with clause Roman 5 of the said provision. Full stop. The said provision, the section 412 capital A of the KMC Act is set out below. It একটু পুরোটা set out করে দিই। Full stop. Next para. Under clause Roman 3, comma, it is contemplated that the corporation may serve a notice on the owners providing an option to them to reconstruct the building according to the plan to be sanctioned by the corporation with such expedition as possible, comma, stipulating certain yardsticks therefore. Full stop. In the event the owners agree and so apply, comma, the corporation is empowered under the said provision to allow a building plan submitted for the purpose to be sanctioned with additional floors and floor areas so as to provide for the recovery of the expenses to be incurred. Full stop. Next para. Conspicuously, comma, however, comma, in clause 4, comma, it is specifically stipulated that in the event of disagreement or disinclination on the part of the owner or owners, as the case may be, to avail of the opportunity contemplated under clause Roman 3 within bracket, comma, the owner or owners, comma, as the case may be, shall be subject to such action as provided in the law for the time being in force. Full stop. The said clause is immediately followed by clause Roman 5, which provides that subject to the provisions of the section, comma, the corporation may cause development work in respect of the dilapidated building in such transparent manner and on such conditions as may be prescribed by capital S scheme by the corporation. Full stop. Next para. Thus, comma, although there is no within double inverted prohibition, double inverted clause, in any party making a unilateral application, comma, the specific modality in the event of disagreement between the owners to make a joint application and the modality thereof has been unambiguously provided in clauses 4 and 5, Roman 4 and 5 of section 412 within capital A. Full stop. Within the four corners of the said modalities, comma, there is no provision whatsoever for one of the owners or some of the owners to unilaterally make an application as contemplated in clause Roman 3 in the event of disagreement. Full stop. On the contrary, comma, in the event of such disagreement or disinclination on the part of the owners, comma, the statute specifically provides that it is the corporation which shall cause the development work in respect of the dilapidated building in terms thereof. Full stop. Next para. Thus, comma, the so-called liberty double inverted, carved out by this court in paragraph 18 of the order under review, is patently dehors the law. Full stop. Next para. The apprehension of the review applicant is also justified to the effect that in the event the court specifically observed, comma, as done in paragraph 19 of the order under review, comma, that if a unilateral application is made, the KMC shall duly process italics করে দাও, the same as expeditiously as possible, comma, there is every possibility that the KMC shall act on such application, comma, although such a unilateral application is not contemplated in law. Full stop. Next para. Thus, comma, it is clear that the liberty granted to the application to the respondents in paragraph 18 of the order under review and the consequential direction on the KMC to duly process such application in consonance with such liberty in paragraph 19 of the order under review are comprised of error apparent on the face of the record, comma, bringing the same within the purview of interference under Order 47 of the Code of Civil Procedure. Full stop. Next para. However, comma, with regard to clause paragraph 16 and 17 of the said order, comma, this court is of the opinion that the same does not contemplate any uh, infraction of the statute, as the same comes within the broader ambit of clause Roman 3 of section 412 capital A of the KMC Act. Full stop. Even otherwise, comma, although it is contended by the review applicant that the said observations were beyond the prayers made in the vacating application, comma, since the underlying refrain of the vacating application and the specific subject matter involved in the appeal was the suppression of an order dated February 2, 2022, passed by the KMC under the said provision, comma, it cannot be said altogether that the issue was not raised before this court, or that or that there was, or that the court was not in season of the necessary necessary incidents of the said provision. Full stop. Next para. In view of the above discussions, comma, the observations made in paragraph numbers 18 and 19 of the order under review cannot withstand the scrutiny of scrutiny under Order 47 of the Code of Civil Procedure. Full stop. Accordingly, RVW 19 of 2026 is allowed in part, comma, thereby deleting paragraph numbers 18 and 19 of the judgment and order dated December 23, 2025, passed in FMA 1867 of 2025, bracketed with IA number CAN 1 of 2025, bracket closed, full stop. There will be no orders as to cost, urgent certified copies. Arakta line add kore no order as to cost age. Any action, comma, if taken in terms of the said paragraphs which have been deleted above, comma, stand hereby reversed.
Anything an observation that the corporation should take steps in accordance with 1412 immediately.
Don't want to create scope for another review.
No, not on that. Again,
No, this time you will come up in review.
why I am saying, my lord, the building is in dilapidated condition. If in the process, my lord,
File
building
a
collapse,
writ petition for that. Mr. Thakur is right on that. We agree with you.
petition,
But
the
this
petition
is-
for hearing, it will
Mr.
take time.
No, Mr. Basu,
Agreement-
that comes within the mandamus scope, not this limited scope of this misappeal against them.
It's taken to the cognizance of the order passed by the corporation.
Grateful, man. Deeply
Up to an extent is fine, but not beyond that.
As you know.
grateful, man.
Error is error, Mr. Basu.
No.
We cannot defend that.
Hey, my lord, what
No,
I'm saying,
we were-
it is not error. I see
We
that
did not.
purpose.
We did not bring this to your lordship's notice, my lord, when the matter was heard. Well, perhaps counsel was taken
Thanks
off.
for the ointment.
Well, it's
Mr. What is an error is an error. Come on.
Great.
Next. Yes.
deeply obliged.
Yes. এই বইটা নিয়ে নিন।
I appear in 16.
Yes.
And I am in 15. So it's connected from same order.
Well, this is
Let Mr. Thakkar start because it's from the same
Party is the same or different party?
parties are different.
they are
Same order.
Same order.
Your interests are similar.
No,
No, no, no.
I tell your lordship, this is in a suit filed by an
Read.
executor. Suit filed by an executor for protecting
Yes.
the assets, purported assets of the deceased, which the deceased died seized and possessed of. An ad interim order of injunction has been made.
Executor means the will was
Plaintiff, executor of a will. The
probated.
no, unprobated. Unprobated will, testamentary proceedings we find from the plaint, testamentary proceedings pending before this honorable court. And now from the appeal number 15, I find that
One second, Mr. Thakkar. If they are the executor,
they are the plaintiff executor.
so they have filed taken
They
up
have
a
sued.
probate proceeding.
They have taken out a probate proceeding for
Which is pending.
probate of the will, which is pending before this High Court. I have no problem with that. Now, my lord, from 15, which is Mr. Banerjee's appeal, he has served on me. I find that similar reliefs were sought before the Honorable High Court, which were turned down. I am not concerned with that. Similar reliefs were
This
sought.
suit is for?
This suit is now for protecting the estate, which the deceased purportedly died seized and possessed of.
The Banerjee says no.
Mr. Banerjee's, well, the estate, that is the issue. What is the estate?
What is that relief sought? Declaration?
No, my lord.
Sorry.
Mr. Banerjee can.
May I just
Let Mr. Banerjee, you are the senior of the two,
Yes.
then you start, then
Yes.
we'll hear Mr. Thakkar on the other.
Twist is different. Twist is different.
My lord, I am my lord, the defendant number 1, my lord, in the suit.
Right.
My learned friend, I am my lord, the son of my lord, Mr. N.L. Todi. My learned friend, my lord, is the grandson from the daughter's side. He also claims to be my lord, executor of my lord, a will of N.L. Todi, my lord, giving, according to him, my lord, giving everything, my lord, to the grandson. That will, my lord, is in probate, my lord, before the Calcutta High Court. My lord, there, my lord, he also files an application for the purpose of what he says, my lord, are my lord, properties belonging to the estate. That injunction, my lord, is refused to him. And my lord travels, my lord, to the division bench, that is not there.
No, he seeks a declaration of title.
No, here, my lord, what he does, he challenges, my lord, a memorandum of understanding where he is not a party between, my lord, the other two sons, defendant number 1 and defendant number 9.
Between the two sons, because he is the
Yes.
grandson.
He is the grandson, my lord, from the daughter's side.
But apparently in the capacity of an executor to protect the
My lord,
estate.
two things, my lord. First, my lord, the properties all belong, my lord, to incorporated companies. First. Second, my lord, whether, my lord, he can challenge, my lord, an instrument which he is not a party to.
All right. Yes.
And, my lord, thirdly, my lord, on the question that, my lord, first, therefore, my lord, suppression of acts, my lord.
Ad interim has been granted to them.
Yes. Ad interim, my lord, in respect of the same properties.
What is the nature of the injunction granted, Mr.
My lord, not to, my lord, deal with.
Basically, not to deal with.
Yes. My lord, that's if my lord looks at, my lord, the impugned order. And, my lord, what is interesting is, my lord, the order also relies, my lord, on the will. In the sense of, my lord, saying he is the executor. So you can't go to, my lord, another forum. First, my lord, you go to one forum where an application is pending.
Succession একটা দিন
Pending আছে
Indian succession
Pending আছে তো এখনো, GA3.
I need to protect the testimonies.
That's right. Correct. My lord, in the memorandum, my lord, will
yes we have found
kindly
the order.
Yes. My lord, kindly see, my lord, and this was, my lord, an ex parte ad interim order.
Yes.
And sorry, my lord, before I, my lord, take, my lord, to the order, it relates to, my lord, declaration of, my lord, memorandum not being, my lord, lawful of 31st March 2019.
Yes.
And which, according to him, they came to know in, my lord, according to him, according to us, my lord, he was aware, but according to him also, he came to know in May 2025 from the High Court proceedings.
So if you go according to him, then it's within time.
No. He obtains the order, my lord, January 2026, ex parte ad interim order.
On the urgency.
Yes. So on the face of it, my lord, I want to show, my lord, there was no ground.
So your first one ground is no urgency is one ground. The third party challenging a memorandum is that second ground.
And, my lord, suppression, my lord, with regard to, my lord, that the properties, my lord, belong to companies. Fourthly, my lord, that it is, my lord, already the subject matter, my lord, they made it the subject matter of, my lord, the probate proceedings and did not get orders.
Similar injunction was spread there.
Yes. We have annexed, my lord, GA3.
All right.
Now, my lord, looks at, my lord, the order It appears from the marginal note, paragraph 2,
Yes.
that no caveat is registered in connection with the subject matter dispute involved in it.
Is that in bold letter? That is the most important part of it.
Yes, no, but that's not a ground.
It was very concerned with that. Probably
Yes.
suffered in some previous yes. In spite of caveat, probably some order.
Must have not.
Must have been asked,
but
the High Court done something.
And what is but that's no reason. No caveat not being filed is not the order 13 and requires an exception when you will grant.
So why is it in bold letter? That's right.
I'm making my point. I've understood that.
Yes, Mr. Please continue.
Hence, this court does not find any legal impediment to consider the prayer of granting ad interim relief on dispensing with service of notice at this pre-trial stage. Well, I'm sorry, Malad, I'm joining issue. This is not a ground.
No, to consider.
Yes.
To pass.
So, Malad, why notice should not be given? This is not a consideration, Malad, that in bold letters, Malad, no caveat.
No, since there is no caveat, I can take up the matter, consider the matter.
Malad,
don't be too hypothetical.
Very well, Malad. Accordingly, concern representing the being permitted to move the temporary injunction application ex parte ad interim form showing urgency, move the application heard at length when attention to the court has been drawn. Mainly in respect of memorandum of family settlement dated 28th September 2009. That is not what they claim under. They said under 20th September 2009.
This is the will.
No, this is Malad, the memorandum of family settlement under which, according to them, Malad, Mr. NL Todi got lot properties.
So
that's the original. They want to protect that.
You don't dispute this?
No, because after this, Malad, testator himself has dealt with the properties. In contrast with the memorandum of recording settlement printed on non-judicial stamp paper bearing, this is what we are concerned with, 13 March 2019. And also in contrast with the interim order of injunction passed by the Honorable High Court in testamentary intestate jurisdiction original side on 15 July 2024 in IA number GA2 arising out of TS number 26 matter of Nandlal to deceased and Neeraj Bajoria and such. So, in this testamentary proceeding, someone else had obtained an order, which is not what is being referred. Peruse the plaint, temporary injunction petition, as well as the documents filed by the plaintiff. Upon hearing submission made on behalf of the plaintiff, simultaneously with perusal of the documents repeatedly referred and relied upon course of such hearing, simply understood that the plaintiff, who happens to be the grandson, come direct descendant of the testator, as well as the executor of the will and testament made by Nandlal Todi prior to his death, has come up with the allegation made against defendant numbers 1 to 13 and defendant numbers 17 to 23. Prima facie that by creation of an instrument in the form of memorandum recording settlement dated 13th
Mr.
March.
Banerjee, give us half a second. Mr. Harindam Banerjee, there is no scope of filing an affidavits in this because ad interim stage all have been annexed here.
Some additional papers have been given which were not before the trial.
That you can argue. I mean, there is no scope of filing affidavits to bring on record further documents.
He's for the executor. I am for the supporting respondent.
Who are you?
I am not one of the supporting.
We are impersonating each other.
No, Mr. Rai or Mr. Banerjee, whoever. There is no scope. Then we'll because
yes, here
then we'll take up the appeal.
Here
These papers.
On these papers on ballot. The only thing
yes.
is,
what is your objection?
The objection is documents which were not before the learned trial court, and the pleadings there to may not be looked into.
No, Mr. Rai, that is superfluity. You make your argument on that. We are saying, is there any other document? That is what we are saying.
They have
that is your argument. One will be one of your arguments. But then we'll dispose of the appeal itself, because there is no use deciding the stay application at this. Yes. Yes.
Remember, in the middle, recording settlement dated.
Hear you, both of you.
One point,
this has been extended. I think.
Yes,
This has now been extended by an original. Original order has now become infractions.
But there should have been an appeal from that.
Huh?
There is no appeal.
The original order has now become
an undertaken to file written objection.
And there they went and they filed their application for filing written objection.
You argue these things when your turn comes. Yes, sir.
Memorandum recording settlement dated 13th March 2019 fraudulently are trying to create third-party interest in respect of properties belonging to late Nandlal Todi in repugnant to the terms of family oral settlement so reduced in writing in form of memorandum of settlement dated 20th September 2009. Prima facie found to be also the case of the plaintiff as reasonable apprehension that despite being aware of valuable rights of NL Group in the 4th and 14th floors of Todi Mansion recorded in oral family settlement dated 20th September 2009 have in the settlement dated 13 March 2019 dealt with the said Todi Mansion. So dealt with the said Todi Mansion to the exclusion of NL Group by RK and PK Group and defend numbers 1 to 13. PK Group and RK Group. But I am PK Group. RK Group, succeed to create third-party right in that plaintiff would suffer an irreparable loss. It is also primarily found to be the case of the plaintiff that in the event of raising disputes and differences between respondent numbers 1 and 9, we are the two sons, of during lifetime of Nandalal Todi regarding various assets and properties belonging to both family, memorandum of family settlement, that a strong prima facie case to be decided trial can be said to have been emerging out from the averments of the plaint, as well as from the temporary injunction application under consideration. Moreover, this court is also the opinion that so far as the balance of inconvenience is concerned, having taken note of the apprehended facts and circumstances, as well as the allegations made in the body of such temporary injunction application, taking note of the status of the plaintiff, the Mullah says, as executor of the will, holding on behalf of the beneficiaries of it, as well as the pendency of application for grant of probate, being PLA number 283 of 2022 in contentious form, it can be said tilting in favor of the plaintiff. And so far as the question of irreparable loss is concerned, this court is all considered opinion that not only the plaintiff but also other beneficial will and testament made by Nandalal Todi since deceased who would suffer an irreparable loss if the defendant respondent succeed in the alleged apprehended acts as stated by the plaintiff. This court is also of the opinion that in order to honor the last will and testament of Nandalal Todi, properties as described in Schedule A1 of the injunction application must be protected during this intervening period and before disposal of the PLA matter by the Honorable Court. With great respect, my lord, this can't be, my lord, a reason to, my lord, pass an order, my lord, in a civil suit, where, my lord, the challenge is, my lord, to the memorandum of, my lord, memorandum of understanding of 13 March 2019 between, my lord, two different parties. On overall consideration of the attended facts and emergent circumstances, this court is of the considerable view. At this stage, it would be expedient enough to issue ad interim rule to restrain the defendants from dealing with the suit properties, wherein not only the plaintiff but also other beneficiaries of the will have certain right, title, and benefit to get in any manner whatsoever, which would be amounting to creation of third-party interest until adjudication of disputes raised in the instant suit. Moreover, this court is also of the considerable view that prima facie the alleged facts is apprehended by the plaintiff are prima facie well suggestive of circumstances wherein there is imminent necessity for issuance of ad interim rule to stop the respondent 1 to 13, defendant 7 to 23, defendant 25 to 27 dealing with the properties and assets described in Schedule A1, body of injunction, application from dealing with any manner leading to creation of third-party rights. And this court is of considerable view. Instant order would be not be detrimental on any legal right, title, and interest of those respondents over the schedule mentioned properties. Now, my lord, we have learned, my lord, this is the last reason why you should pass any ad interim order, saying it will not harm the defendant. That's not a ground, my lord, to pass any ad interim order or, my lord, any order. And today, my lord, he says, with great respect, my lord, to, my lord, the learned, my lord, trial judge, he seems to be, my lord, protecting pendency of the proceedings in the High Court. The High Court is, with great respect, competent enough to protect if required. Protection is required. And this line particularly, says, no, এখানে যেখানে দেখলাম of the opinion that honored the last will and testament. That's one of the paragraph there, and then says, testamentary suit. No, এখানে
not beneficial.
Correct. But also other benefits.
Yes.
This you have marked those two.
Yes, and
honored the will and also other benefits.
Yes. And then, therefore, prayer for ad interim relief under Order 39, Rule 1 and 2, dispensing with service of notice upon the defendant numbers 1 to 13, 7 to 23 are considered allowed. Said interim order, when agents are hereby directed to abstain from dealing with properties described as Schedule A1 of the temporary injunction application filed in instant suit so as to create third-party rights. Same pursuant to memorandum settlement dated 13 March 2019 until further orders shall be remain enforceable.
Sir, Banerjee, please show us two things. One, the prayers of this plaint.
Yes.
Release. And secondly, that injunction being refused, that order.
Yes. Malad, first, Malad, page 37A, Malad, is the plaint and volume 1.
This is FMAT, which one?
Oh, sorry, my lord, FMAT 64.
Oh,
Please, I'm so sorry.
that is your matter.
The companies, my lord, have preferred, my lord.
That should have been taken
appeal.
first, actually. Anyway.
Sorry, my lord, before I
No difficulty, sir.
intervene, my lord.
No. The
Page, my lord,
prayers,
37, my lord, may I just show 37A first, which is, my lord, the beginning of the plaint.
Yes.
And, my lord, kindly look at, my lord, the cause title. My lord, see his title suit 120, Neeraj Bajoria. Then, my lord, Pawan Kumar Todi, my lord, I am different number 1. And then 9, my lord, is the other son, Raj Kumar Todi at 37B. And then, my lord, sees from 38 are all, my lord, incorporated companies. From, my lord, different number 17 onwards. Right up to, my lord, paragraph, page 41.
These companies were also parties to the memorandum of agreement.
No, 2019.
The impugned agreement memo.
Yes, perhaps, my lord, I'll just
Otherwise,
check.
why are they parties?
Yes. Some of them were, my lord, parties. I'll just check, my lord, whether all are parties. 2019 actually. My lord, I didn't, my lord, check, my lord, whether then page 41. I just wanted to show, my lord, kindly look at, my lord, the paragraph 1. Plaintiff is the executor of the last will and testament of late Nandalal Todi since received dated February 17 and is a legal representative of all purposes. All the properties are said deceased vests in him. Then plaintiff, as the executor of the last will and testament, deceased is entitled to collect all the property of the deceased with due diligence. Plaintiff is also the grandson of testator, direct descendant of the testator. So that's, my lord. And then, my lord, kindly come to paragraph, page 68. Paragraph 66, my lord. That's why, my lord, I say, my lord, according to him, my lord, when, my lord, he had knowledge. And kindly see from on which different number 1 filed an application being J number 4 arising out of TS, which was served upon executor. Plaintiff come to learn, alleged settlement dated March 13, 29 disclosed. And then, my lord, sees the relief in 69.
So the suit is entirely based on the rights emanating from the will.
Yes.
Under the will.
Absolutely.
So you say that this relief could be first granted by the probate court itself.
Yes.
And has been refused to them by the probate court,
Yes.
but granted to others.
Yes, correct. Absolutely correct. 2, my lord, obtained an order in respect of that, where, my lord, we have filed, my lord, there's a
so after
vacating
filing, the
application.
suit was filed after that refusal.
Yes, yeah, now. Suit is, my lord, of 2026.
That was much prior.
Yes.
March 25.
My lord, 69, my lord, will see, my lord, the delivery up all prayers ABC relate to March 13, 2019. Then, my lord, D is perpetual injunction.
But the injunction prayer made before the probate court probably was not related with, linked with this memorandum.
No.
It was independent injunction prayer.
But, my lord, claiming as, my lord, assets or, my lord, of the deceased.
Premise of the claim was same, but this
Yes.
memorandum was not the focal point of
he's
that.
not a party. My lord, we showed, my lord, this memorandum quite naturally because they relied, my lord, of family settlement of 2009. We came and said that the injunction you have obtained or the probate application is in respect of properties which belong to companies.
But the injunction basis may be memorandum, but the injunction which they are seeking, you are saying virtually is similar.
Same, correct.
But the injunction is not to give any effect or further effect to the alleged memorandum. Not a blanket injunction from transferring. Although that is also there.
Yes.
That is also there.
Are hereby directed to abstain from dealing with the properties disturbed Schedule A1.
Yes, yes. That has also been brought.
Yes. Now that the Schedule A1, my lord, will find, my lord, at page 71.
Immovable properties.
Yes. Now, my lord, they also do not disclose, my lord, that this is owned by, my lord, companies. in page 71. This is schedule A1.
But they must have stated somewhere, otherwise the companies would not be impleted.
Well, at page 55 is where page 66, sorry. Page 66. 60. 63 থেকে প্যারাগ্রাফটা বলো না আমাদের 55 my lord. Schedule 1 is A1 is described. And my lord, the properties are described, my lord, from paragraph 54, page 63. Sixty-three, my lord, that
is not there in our copy.
Not there.
No.
Internal page 28, my lord, para 54.
No, 63 is not there. 63 is not there. 61 is not there.
Checking. Plain tail copy.
61 and 63 immediately you can see that it's not there. Not even afterwards. Sometimes it happens that it gets mixed up. 61 and 63 are not there. Yes.
Lord, may I just
Is it there in your copies?
hand up a copy, my lord? I'm sorry, my lord. We'll also have that, my lord, corrected, my lord. My lord, in both copies, my lords, are not. আমাদের দিয়ে শুধু হবে না
You have the page 61 and 63.
But
we are the only.
I don't know, my lord. My lords are the ones, my lord, who should have, my lord, got it, my lord, instead of, my lord, us.
At least from your point of view.
Yes.
Anyway, 63.
63, my lord, is the description of, my lord, the.
Yes. The mark. Can you send somebody in the meantime, Mr. Banerjee, to just because in any event we'll rise soon for 10 minutes to get photocopies of page 61
yes,
and 63
we'll
only.
just have it.
Two copies each of page 61 and 63.
61 and 63.
That will suffice for the present.
Very well, my lord. We'll have that done, my lord.
So very well. So
my lord, I'm just then, my lord, may I just skip over that, my lord? Just
yes,
sorry,
for the
my lord.
timing, yes. It a handicapped.
My lord, can
keep it with the, I mean, very so. How do they link the companies in the cause of action pleaded in the plaint? That is what we want to see.
My lord, at page that, my lord, that is, my lord, the
what have they pleaded about the companies? How do they implead the companies? Must be something there.
Well, that isn't there in 61, but then I'll just see, my lord. My lord, page 43, my lord, will kindly come to.
Yes.
Sorry, my lord, just kindly, I hope, my lord, that page is there. 42.
Yes, it's there.
Thank God. My lord, paragraph, my lord, 5.
Yes.
My lord, 5.
17 onwards are the juristic
SCs, they say.
Very well. Yes.
Then 24 here in Stargood Private Limited. Shares in different number 17, Tivoli Park.
That's very well.
Then, my lord, paragraph 7, different number 25. Yes, here, my lord, they say, different number 25, earlier known as Akshay Vinima, is the owner of one of the properties of the testator. I don't know how, my lord, company can be owner of one of the properties, my lord, of the testator. With great respect, my lord, that defies, my lord, at least, my lord.
If they're the owner, then how can the property be of the testator?
Yes. Are share below, how does it matter? Then, my lord, kindly see 8, paragraph 8, different numbers 26 and 27, developers of one of the properties tested as situated 12 by Sansa, data Sansa. Then, my lord, that's what, my lord, they describe. And
Mr. Banerjee will take the break. You go through the
My lord, I'll
go
just
through the plaint in the meantime.
I have not gone through, my lord. I'll just show my lord the two paragraph pages.
Yes.
I'm grateful
Please,
for
yes.
permitting Mulad that.
Yes, yes, please.
It was,
Thank you.
we're just giving it line, Mulad. We'll have it stitched in my lords.
Step in, step in.
Step.
No, don't staple actually. Don't staple. জায়গা জায়গা ঢুকিয়ে দেবো। Yes.
Mulad, I was showing Mulad page 42 I've shown.
42, yes.
Then Mulad 43 also I've shown Mulad up to paragraph 9. Then Mulad straight away kindly come to paragraph, sorry, page 59, paragraph 50.
Yes. They are parties, yes.
Yes. The similar different numbers 1 to 13 and 17 to 23. Parties to the alleged memorandum, so not all of them, I think it's the 27, are attempting to give effect to the purported settlement, fraud, sunset, assigned, then effect to such settlement dated March 13, 2019. Then Mulad kindly come to now Mulad paragraph page 61 Mulad, again Mulad they say what they call.
Any particulars of fraud pleaded, Mr. Banerjee?
Yes, Mulad, that is at Mulad page 60, paragraph 53.
No, but why is it fraudulent? Cannot be returned because furtherance of the fraud. Achha. They say it constitutes a document in furtherance of a fraud in the previous paragraph, paragraph 51.
325, 420, 325, 325. This is what they say.
Why is it fraudulent? Oh, paragraph 48 probably. Sole intent to defeat the express wishes of the testator. Page 59, paragraph 48, they say this fraudulent concocted and fabricated apparently because it's with the sole intention to defeat the express provisions of the.
And Mulad, page 60, paragraph 53, they say fraud, the result of public understanding, the evident different 1 to 9, there's fraud particulars whereof, that's Mulad where they try and Mulad enumerate. No, Mulad, very important, they are not parties Mulad to this memorandum.
No, they are not. They are not.
And then Mulad, page 63, paragraph 54. So this Mulad, with great respect, Mulad, I do not understand Mulad, paragraph 54. Purported settlement dated March 39, 2019 between the RK group and the PK group. So it's Mulad between two other groups. Has resulted in valuable rights of NL group being usurped by the other two groups. You're not, if you're not a party, you're not bound by it. How do you have a cause of action so far as someone else has decided? Then the said terms of the statement clearly admits the fact.
No, they have asked, they have sought for a declaration that this is not binding on them.
They're not parties.
No, but if you and Mr. Banerjee go and deal with my property and you enter into an agreement.
But how will my lord be affected at all?
But other specifically fact, if there is some document which if stands affects your rights to a particular property, that property that I mean, if it deals with.
Sorry, Mulad, I'm sorry, Mulad.
No, if it deals with the property, your property, or to a property to which you have a direct interest, if two other persons enter into an agreement between themselves and say that you will be in possession of the first floor and I am in possession of the ground floor, don't you have a right to seek a declaration that that instrument, if it stands, will affect my rights in the property, and I seek a declaration that it is not binding on me?
Mulad, legally, Mulad, perhaps yes, in some circumstances, yes.
I was specifically factor given.
Section 31. Mulad, here we are talking about Mulad, the two other groups entering into a memorandum of settlement Mulad, of 13 March 2019.
Section 31 of specifically
31, yes.
Yes.
But kindly look at what
Broadly, if left outstanding, may cause him serious injury.
kindly look at the prayers,
Be a party.
declaration, then delivery of and
Must have
cancellation.
sought that it's not binding on them. Must have sought.
That's the declaration.
No, not binding. Yes.
Not binding. That's the declaration first. And then
Anyway, but that's the point. But they're not parties even to the memo.
Yes.
We'll take that point. Yes.
now, my lord, more importantly, my lord, kindly come to my lord, the memorandum. My lord, may I just show the memorandum? That's a 325. That's volume
325.
2. T25. I'm just showing, my lord, who the parties are here. 13 March 2019. Rajkumar Todi. That's one of different number 9 in the suit. Then my lord at 326, my lord will find Pawan Kumar Todi, who's my lord different number 1, and my lord the appellant before my lord, and Tivoli Park Apartments Private Limited, and my lord PS Group Realty Private Limited, and Amalgam Knowledge Services Private Limited. So first document. So here, my lord, so the parties are, my lord, really, apart from, my lord, those, the individuals, there's 1, 2, and 3 companies. Now, kindly come to, just keep it that, my lord, I'm just showing the parties, and then, my lord, I will not, then kindly come to, my lord, the GA3 which they file, which is, my lord, at 533. I'm sorry, my lord, volume 4. I'm page 150, 161. Well, 5. I'm to 161. One, my lord, 533, my lord, will find. Neeraj Bajoria, my lord, is the plaintiff petitioner, and my lord 534, that's his application. At 540, my lord will find, my lord, the prayers.
This is that application where the injunction was refused.
Yes, GA3. And prayer B, my lord, is with regard to assets and property received as specified in the affidavit being annexure A. 569 is the order, right? Now, my lord, 569, my lord, is the order.
Deemed refusal.
Affidavits, yes, my lord. 5 affidavits are given. This is, my lord, for my lord's paragraph.
No specific refusal, but deemed refusal.
Yes, GA3 at the top, my lord, it says.
Ah.
Then, yes. Then, my lord.
That J is still pending.
Yes. They're pursuing it. Then, my lord, kindly look at, my lord, the division bench at 597. In fact, I find, my lord, it's not sure.
Sorry,
597. In fact, my lord,
Division bench against Justice
my lord, before my lord.
Rouse. Achha. This is the this is the appeal against that order
Yes,
of
my lord,
Justice
will
Rao.
find, my lord, at 598.
Yes, yes.
The appellant, paragraph 3, filed a probate application,
Right, right.
contentious, objector suit, GA3, suit appellant sought injunction, both temporary and ad interim. Upon hearing sunset, appearing for the party to find impunity somewhere in between, the sense that GA3 has already been moved previously, no ad interim order was granted, not yet been finalized. As such, the impugned order cannot be issued the first occasion when there is deemed refusal of the ad interim prayer made in GA3. Impugned order barely regarded finding, can the matter we inform the learned past impugners and laws determinations as that could not be heard.
This is, I mean, not a merger. I mean, doctrine of merger is not applicable because it was held not to be a judgment.
That's right. But I'm only on the question, Mullah, that they have already, Mullah,
exhausted this.
Yes. They have
Ad
asked
interim
for,
stage.
that's right. They have asked for, Mullah, this order. And ad interim stage, Mullah, not granted.
Prayer C was ad interim.
So ex party, Mullah, to go and, Mullah, have an order there is, Mullah, what, Mullah, I'm objecting to. Then, Mullah, will kindly look at, Mullah.
So, Banerjee, have you brought any of those judgments which say that even if otherwise in ad interim, at the ad interim stage, only plaint and injunction application is required to be looked into, but appellate court still can look into suppression,
Yes, Mullah, yes, Mullah, I've got the division bench judgment.
One or two will do. Any one of those judgments will do.
Yes. Mullah, now kindly look at, Mullah, the affidavit of asset. I'm sorry, Mullah, I have to take my lord to paragraph 160, page 161. Like the 161. 161, volume 2 at 191. It starts at 182, affidavit of asset. And kindly come to Mullah 191. These properties, Mullah, are also described. 191, Mullah finds.
Yes, yes.
Peleghata Road, name of Akshay Vinimay.
1, 2, and 3 are common.
Yes, correct.
There is a fourth property also. I don't probably we saw in the schedule of this plane. Is there any fourth property or these three?
No, there's Mullah. Schedule ta kothay galo? 71.
Auto dimension is also there
Yes, yes.
in the previous chart.
Yes.
These are all family companies.
No, my lord, there are outsiders also. Outsiders also. So any event, my lord, if properties, my lord, are owned by companies, then perhaps, my lord, according to me, at least, my lord, that would be my submission, my lord, can't be, my lord, subject matter of individual asset. Now, if you own shares, that's a different issue. Then you have right to those shares. But otherwise, my lord, the whole corporate jurisdiction, jurisprudence, my lord, will be turned, my lord, in its head.
Yes.
And it would have been very convenient, my lord, for the other, my lord, two, my lord, litigants, my lord, the Billas and the Lodhas, my lord, to get hold of, my lord, everything possible, my lord, then to say.
Obviously, simultaneously, an individual and a company.
It can't. Because the first thing, my lord, we know is that shareholder doesn't really own the property of the company.
Obviously, yes.
And can't be, my lord, individual. And what they say, my lord, in this also they say, page 204, they say that he has shares, 204 total. NL Group, PK Group, RK Group. All this is, my lord, with great respect, my lord, doesn't give them a right, my lord, to have an injunction, my lord, in respect of those
company assets. Page 204, they are described as shareholders.
Yes. And that's right. And here also, my lord, will find, like, my lord, Beleghat at item 3.
Yes.
Akshay Vinimay Private Limited owner company.
50%.
Yes, then
Todi
family ownership 50%. My lord asked me whether outsiders, my lord. So Todi family ownership is 50%. In that, my lord, they say NL Group is 25, PK Group 50, RK Group 25. I am not sure, my lord, and that's what we are arguing there, to say it can't be included as properties of the deceased. That's one of the grounds taken there.
Must have been.
Yes, which is, my lord, being argued in GA3. When they ask, my lord, for administrative penalty and, my lord, injunction, we are urging there, my lord, that you can't have, these are not, unless you show that these properties belong to the testator, you cannot make it the subject matter of the will.
Unless otherwise it can be. There are situations where a company can be a co-sharer with an individual.
Yes. Yes.
Definitely.
Where
the asset.
Yes, correct. Where the individual also has to be the owner.
Has to be the owner of the asset.
Yes.
Yes, obviously.
Individual can have 25%, correct. Along with 75% held by a company. Or they can be
in the asset.
50% in the asset. Your ownership can't be through a corporate entity of the company. And that is one of the...
They have not stated within the four corners of this probate that he is owner otherwise by any purchase deed or something.
No, my lord, subject to, my lord, correction, my lord, I don't think. What they rely upon, my lord, they say 2009, my grandfather had some rights.
But this is the affidavit.
That's right. So they rely on, my lord, that memorandum of 2009.
Are you sure you have not done the same thing in the memorandum of agreement? Do you have a hunch that you have also done the same thing? Otherwise, that could not be included.
No, my lord, we have, in the sense, my lord, to say, my lord, that the property is...
Yes.
No, my lord, let's, my lord, look at, my lord,
something like that. I mean, must be there something there in your agreement.
My lord, with great respect, I can, my lord, show the memorandum. Since, my lord, we are not dealing with it, but the fact of the matter is that property is, my lord, not individually owned, can't be the subject matter of, my lord, the will.
Cannot be.
If it is not, and secondly, my lord, that issue, my lord, is being really looked at by the probate code itself.
So in the first place, he as an executor does not have the locus standi even to ask for
yes,
whatever may be in your agreement.
Yes.
All right.
So he as executor
has to establish his right first. Then get an injunction.
Correct.
Right.
Because he comes in, my lord, according to my lord, he comes in as a grandson and as an executor.
Yes.
Of that will. Probate proceedings pending. You also made an application there.
Is he a beneficiary also in the will or only an executor?
No, my lord, he is only an executor. Thank you.
He himself is a beneficiary.
No, my lord, he's not the beneficiary, my lord. I am told, my lord, father is the beneficiary.
Yes.
Father is the beneficiary.
Father is different.
Yes. Father means the son-in-law.
Too confused.
Because
father means son-in-law.
No, my lord, I'm sorry. Son-in-law, my lord, NL Todi. Because, my lord,
all right.
He's from the daughter's side.
All right.
The
yes.
grandson
Father
is, my lord,
father
from
is
the
the son.
daughter's.
Right.
Daughter's side.
Yes.
So, in fact, my lord, But that's again, my lord, I don't want to bring it here because that's a subject of the probate. While, my lord, it was pending, my lord, there was another settlement which was arrived at with him also, my lord, agreeing to everything. And then, my lord, it was some cases were withdrawn again, my lord. But that is going on there. But you can't have an individual right to file this suit, suppress the fact that all these orders were passed. And that the point has been raised with regard to the whether, my lord, it belongs to, my lord, the testator or not, whether it can be made the subject matter of the will, and then, my lord, come and file the suit and obtain an ex parte ad interim order. My lord, that's, my lord, what, my lord, we are on. Now, my lord, actually, so, my lord, just, my lord, to summarize, and then I'll show, my lord, the judgments. My lord, I am still on the issue, my lord, whether, my lord, this particular, my lord, executor plaintiff can challenge, my lord, the memorandum of understanding of, my lord, 13 March 2019. Because that is, my lord, between different number 1 family and, my lord, different number 9 family, with, my lord, those 3 companies, my lord, being parties. It's, my lord, really a misconceived suit in that sense. Second, my lord, I submit, my lord, that he's already, my lord, taken a chance, my lord, with GA3 before the probate court. And, my lord, there, my lord, it is being contested. And that is very important. It is being contested. The same issue has been raised there. So you can't run away from there and obtain an ex parte ad interim order by really overtaking that proceeding,
opening up a new
yes,
new avenue.
And you knew suppression is on him.
Yes.
You knew what is happening there. So, and by saying that, no, here I'm only challenging the memorandum of settlement and their memorandum of agreement, and there
injunction of the same nature, blanket injunction.
Then, my lord, thirdly, my lord, on GA3, my lord, I've already said. And, my lord, now kindly, my lord, look at, my lord, on suppression.
The suppression is about the previous that injunction being refused in the probate and the pendency of the probate.
Yes, refused and pendency of the issues in that proceeding.
Yes, yes. Pendency and also
pendency of the issues, because, my lord, I found, my lord, in somewhere, my lord, he has mentioned GA3 without disclosing, my lord, the orders. I'll just show, my lord, how he has mentioned, because that's also, in fact, my lord, I remember I remember, either, my lord, saying that the disclosure, well, disclosure has to be fair. Just by mentioning it is not good enough.
Oh, yes, absolutely. You can mention anything and everything.
Yes. So 2 things, my lord. First, you have to properly mention it. Second, you have to bring it to the court's attention.
You have to argue that. I mean,
yes. Saying that I have also filed it, it has refused, but you still grant me an order of injunction.
True.
My lord, kindly, my lord, just look at in the page 59, injunction petition বলেছে সেটা সেটাই দেখা
পড়া আছে
এখানেও বলেছে page my lord, in the plaint they mention this at petition to দেখাচ্ছি para 49 page 59.
Yes.
Very interesting. Look at how the plaintiff has also filed an application about March 3, 2025, bearing J number 3 being an application for appointment of an administrator penalty over the entire assets of Sunset forming part of the proceeding, without Malad saying that the second prayer was injunction. And the same thing, Malad, they repeat, Malad, at page 100 in the petition, para 49. And, my lord, he is the executor. He also has, my lord, a duty, because he is really stands in the position of, my lord, a trustee in that sense, my lord, to protect the will. He also come and say that I filed a application where I've asked, these are the issues raised, whether it's a property of the testator or not.
Because his locus is dependent on that, the status as an executor. But he has disclosed about the will, obviously, because that is the premise of.
And that's the basis.
That's the basis.
That's the basis. And that also I do not understand, my lord, with great respect, that how can you pass an order to say I am now protecting the will in respect of which a probate proceedings is pending.
Right.
And which is a contested proceeding. Because our courts have held, my lord, the court is also empowered.
Probate court.
Yes, probate court.
Yes. To the corporeal rights of the property.
Yes.
Also, yes.
My lord, right from 51 Calcutta to, my lord, the last judgments, my lord, on the which has been, my lord,
court is not powerless.
My lord, on the, my lord, suppression point.
Even administrative pendability, you are touching the
That's right.
immovable properties and movable properties also. So,
so you say administrative pendability, which means also affecting the rights so far as the properties are concerned.
Yes.
That is being contested. And you go, my lord, with great respect, my lord, if I may use the word, really behind the back.
Open up another.
Yes. Of the court and the party.
And the party, definitely, yes.
To file a civil suit and obtain an ex parte ad interim order.
Why didn't you take out a 39(4) application? It would take more time.
It will take more. Well, this is, my lord, on the face of it, my lord, my lord, came.
39(4) would be the appropriate remedy. You could have disclosed all this and got
suppression. I'll show, my lord, even suppression.
You could have come up against the ad interim as well as
with great respect, my lord, to the learned, my lord, trial court, my lord, the order on the face of it, my lord, does not stand. There is no iota of reasoning as to why you are passing an order in the suit. By saying that I'm protecting the probate proceed, the will, and the probate proceeding is not a reason. And to say that the defendants will not suffer anything again is not a reason. And the plaintiff, my lord, plaintiff doesn't deserve any order, my lord, with great respect. In suppression, my lord, if one has to go back, then, my lord, that means, my lord, it's being really a premium, my lord, on, my lord, dishonesty, that the fact that he managed to suppress, my lord, he's getting a premium. My lord, kindly look at this 2002-3 Calcutta High Court Notes 322. My lord, I was relying on, my lord, paragraphs for.
Justice Ganguly.
Sorry.
Bengal Cup. This is the one side.
Yes.
Which paragraph?
46 and 47. 40, yes. 46, 47, 48.
Yes.
No, and I think, my lord, the principle, my lord, there can be, my lord, with great respect, my lord, there cannot be, my lord, any doubt on the principle. A party can't be heard to say that, yes, very well, I've suppressed, but then you go back again and raise all this suppression point before the first court. Till then, I'm going to have the order. If I can show, my lord, on the face, and, my lord, I'm disclosing, my lord, court orders, I'm disclosing his application. Copy of his application and court orders, which are, my lord, all on record, which he should have brought, my lord, to the notice of, my lord, the first court. So, my lord, sees. Lord, same page. What, my lord, see, therefore, because here, my lord, supplementary affidavit was produced, my lord, to show, my lord, those facts. The court cannot ignore this. This court finds that not a case of suppression of facts unknowingly. Plaintiff respondent, paragraph 48. Something happened on 5th June, paragraph 41. Facts have been proven to such an extent, real state of affairs are not disclosed. So,
order 41-33 was also taken note of.
And look, in fact, In fact, my lord, that's not the subject matter of this. Another suit, my lord, which he filed, telling another settlement, we had appeared, my lord, he did not get any order. Then, my lord, this was, my lord, okay. My lord, I think, my lord, those are, my lord, the orders should be, my lord, set aside, my lord. I'm very grateful, my lord. I'm sorry, my lord, I overtook the. No, no. Oh.
Resolution.
What was?
Sequence because Mr. Validi's matter was before mine on Monday.
Assets.
So mine was before
Yes.
at some point.
He has honored precedence. Mr. Thakkar has honored precedence.
Seniority, my lord, obviously. That has to take precedence.
Chronological precedence also.
Yes.
Yes.
My lord, I am defendant.
His memo would have to be amended, perhaps.
What is not there? There is some.
What has been given to us.
What is there?
The memo straight away has list of dates and round 1, round 2, round 3. I don't.
মেমোটা কোথায়? হাসারে মেমোটা দেখছি।
এটা কি?
আজকে পাওয়া গেছে? দেখছি। নেই মেমোতে।
I hope all it is.
Valuation statement has to be given.
Mine doesn't have a cost title or preamble. Straight away starts with ground for that ground.
हमारा मेमो ठीक है हम लोग का मेमो देखो हम लोग का मेमो
Probably you have not been given the
entire copy.
complete
हम
copy.
लोग का मेमो देखना ऊपर में ही था
No, but the cost title is important.
There's not going to be the cost.
हम लोग का
No, that has been corrected also. Valuation statement has subsequently been put in.
Cost title আছে তো?
Show it to. Do it behind the back of Mr. Thakkar. Yes. So let us hear Mr. Thakkar in the meantime.
मतलब
Yes.
I am
You are in FMT 59, Mr. Thakkar. Yes, yes.
59 please my lord 59
It is not, they'll hand up right now if they can. First few.
I am my lord
Yes, they will.
I am defendant number 25
Do that, please. Hand over the. Even at 25, yes.
25 your lordship would only keep volume 4 my stay application.
First, let us keep aside the
that
volumes of Mr. Banerjee's this thing.
Yes.
May I have my lord?
Yes, yes, absolutely.
Put in the plaint and the petition twice over. That is why it becomes slightly voluminous.
No, no difficulty, but we'll just have to mark yours. Are there any common arguments?
Just
very well. You make your arguments.
Just two common arguments.
Very well. You need not just pinpoint those. Yes, Mr.
But I am defendant number 25. Your lordship will find my name at page 472.
What is the name, please? Just
Akshay Vinimay LLP.
Akshay Vinimay, very.
Erstwhile company Akshay Vinimay Private Limited. Now, my lord, kindly see paragraph 9. Nandlal Todi, the testator, passed away on 15th November 2021.
This is page?
Page 475, volume 4, please, my lord. My lords, we only keep volume 4 and 3. The rest of the volumes I will not trouble your lordship with, my lord. 4, 3 and the memorandum of appeal.
Right.
Volume 4, if your lordship kindly has, which has the application, please, my lord.
475 is a part of the application.
Yes, please, my lord.
Right.
So 475, paragraph 9, kindly make a note of. Nandlal Todi, the testator, passed away on 15th November 2021. This date is of some significance. Now, my lord, as your lordship has already been told, they are espousing the cause under an oral settlement recorded in 28th September 2009. By this oral settlement,
28th September or 13th of March?
13th of March is assailed.
Yes. Oh, they rely on us. Sorry.
They are relying on 28th September 2009.
Yes.
By which, my lord, the testator, Sri Nandlal Todi, was to have 25% share in this company or hold 25% of the shares of this company.
Yes.
I am the company. Now, my lord, from 2009, and what they disclose now, apropos me, kindly have page 509 once, please. Is my registration data before the file with the Ministry of Corporate Affairs. Kindly see page 509, please, my lord.
Yes.
Akshay Vinimay LLP, your lordship has.
Yes.
And kindly see the date of incorporation, 31st March 2016. So, my lord, the private limited company, Akshay Vinimay Private Limited, which they referred to in serial 25 of the array of parties at 472, was then converted to a private to this LLP in the present form in 2016. LLP was incorporated, which took over the business of the private limited. And my lord, the returns would show, kindly see page 511, please, my lord, the documents which they disclose. It has two designated partners, only two partners. Tushar Jhunjhunwala, Rishi Todi. So there is only one member of the Todi family and one is an outsider. This Rishi Todi holds 50%, one of my partners, Tushar Jhunjhunwala, holds 50%. So these are documents in the public domain. To make out a prima facie case, the least which was required to be shown over he could only have got an injunction over the shares. What Mr. Banerjee said, madam.
These were annexures to the injunction
Yes,
application?
yes. Page 511 is an annexure to the injunction because this is in the public domain.
Yes.
So to make out a prima facie at the highest, my lord, what could he have got an injunction on? The injunction which he gets, I'm so sorry, my lord, kindly see schedule A1 over which the injunction order is passed. Kindly have page 5051, please, my lord. 505. These are all part. I'm not showing your lordship anything apart from the injunction application. Kindly see 505. This is the property on which the injunction is made. And B is the Beliaghata Road property. Municipal premises number so and so, economic interest thereof. Now, my lord, kindly see how this is pleaded. The pleadings apropos this property. Kindly have paragraph. Oh, plain में mark किया हुआ है. Yeah, 1 second. Kindly see the pleading apropos at 25. Oh, I marked it in the plain. 1 second. Kindly come to page 477, please, madam.
Yes.
This they say is Akshay Vinimay Private Limited. Presently, Akshay Vinimay LLP being so and so were vehicles for collective ownership of the three Todi groups for the respective assets held by them, which were intended to be owned so and so by the Todi groups, and shall no means be construed to function independently or represent it. So, madam, from the document which he himself disclosed, it shows there is 150% shareholders other than Todi group. Prima facie case we are on, my lord. Then kindly come to paragraph Beliaghata property, my lord. Kindly come to paragraph where they show the urgency, which is there, my lord. Yes, I'm sorry. Kindly come to page 496. Beliaghata property. The petitioner has ascertained that after execution of the settlement dated 13th March 2019, to the exclusion of the NL group, the PK group and the RK group have jointly with the respondent numbers 26 and 27 developed a real estate project named The Crown at the said property. Can you see? Completion certificate for the project has been obtained. It's not something which has happened overnight. Akshay Vinimay is the developer. He has developed the property. Completion certificate is obtained. And it is apprehended that the sale proceeds from sale of the units in the said project, of which the Todi family enjoys a 50% share. Now again, he is not espousing the cause of the Todi family. He can only speak to the extent of 25% shareholding, which NL Todi would have got under the settlement of 2009, if at all. Cannot have 50%. Have been siphoned out to the complete exclusion of the NL group. Incorrect. The petitioner therefore humbly submits that this is a fit case wherein orders of injunction should be passed responding 1 to 13 and more particularly from creating third-party interest on the units developed at the said project and release of any amounts comprising 50% share of economic profits or profits to the RK group and PK group. So NL Todi under the 2009 was to get 25% of my shares. Now, they disclose my particulars which are in the public domain, which don't show any share of NL Todi.
No, but if the Todi group, their case is that this comes from another the joint nucleus sort of.
No. Malad, kindly see the 2009 settlement once, please, which he says that the 2009 settlement is valid. NL Todi. That's all. Now, he's not concerned with Todi group. He's the executor of NL Todi. And he says that by the 2013 settlement, the 25%.
NL Todi got 25% of the entire Todi estate or what?
He was to get, I'm not concerned with the entire Todi estate.
25% of what?
Of this shares of this partnership. Under the 2009, his share was limited to 25%, if at all. Now, why I say, my lord, prima facie case, when they come to an ad interim court seeking an ad interim relief, they disclose my current returns, which doesn't show anything to do with NL Todi. Now, in the stay application, my lord, I have disclosed my annual returns from the.
It has become a company now.
Yeah, it was always. It was a private limited company converted to LLP. Company previously taken over by LLP. That is admitted was uncontroversial because that is what they say in the cost title itself.
At the relevant juncture, it was a company.
It was a company in which Shri NL Todi.
He got 25% shares in that company.
That is all. He was supposed to get under the 2009 settlement, but now I am on the prima facie case when he discloses my returns of 2026 because these are in the public domain. This LLP is formed in 2016. The gentleman passes away in 2021. From 2016 to 2021, my returns are also in the public domain. If the 2009 settlement was acted upon, NL Todi would actually get 25% shares at the highest. Then during his lifetime, he would have become 25% shareholder of the LLP. I have disclosed now returns, my lord, at pages 43 onwards. From 2016, from my date of incorporation, NL Todi never became shareholder of my LLP during his lifetime. Shareholder is a wrong term, my lord, never became a partner of the LLP. During his lifetime, for 5 long years. 2021, he passed away. 2016, the LLP was formed to establish prima facie case which could be limited only to 25% of the shares of Sri NL Todi. You would have to show that during his lifetime, NL Todi became partner of the LLP.
So that portion of the agreement memorandum was not acted upon.
Was not acted upon. As far as I am concerned, I am the LLP. I am showing my return.
Only your share.
I am only, yes. I am not concerned with the rest.
But for that, you are relying on certain documents which were not part of the trial court.
That is why, my lord, I say they ought to have, when they try to make out a prima facie case on my constitution, on my shareholders, nothing prevented them to show the documents which are these are not my private documents. He shows one of the current, which doesn't show. He doesn't show something which is there during the lifetime. During the lifetime, there are 5 such returns. From 2015, I'm incorporated. That the document itself shows, which he has filed. So he knows I'm there since 2015. He doesn't show anything during the testator's lifetime. The testator came on board as a partner to the extent of 25%. Nothing. My returns, my lord, are at pages, if your lordship will kindly make a note only. Pages 43. Starts at 43, ends at. Starts at 20, but the first is of 2015-2016, starts at page 43, volume 1. Shri NL Todi is not there. And this position continues till date. NL Todi never became a partner. So on prima facie case of 25%, with the greatest of respect, there is no case. And that to 25% of Todi group, which was 50%. So it comes down to only 12.5. See, NL Todi would have become partner of 25% of Todi group, which is only 50. So 25% of 50 is 12.5. Now to all that with the greatest of respect, if a prima facie case had been made out that during his lifetime the testator became partner, only till the extent of 12.5% of his partnership share could have been injuncted and nothing more. But what the learned judge has done, he has injuncted an asset of the partnership firm. Now, my lord, perhaps, my lord, the learned judge lost sight of the fact that I am a limited liability partnership. I am not an ordinary partnership. A limited liability partnership is a corporate entity now. That is, my lord, just two sections of the Act, my lord. I'll just give you a lordship, my lord. 2(1)(d) and 3 of the LLP Act. May I just hand over, my lord? It's fairly, I just make a reference to the sections for the sake of completeness, my lord.
Absolutely, yes.
2(1)(d), your lordship kindly sees. Body corporate.
Yes.
Body corporate means a company as defined in clause 20 of section 2 of the Companies Act and includes a limited liability partnership registered under this act and read with section 3, my lord. A limited liability partnership is a body corporate formed and incorporated under this act and is a legal entity separate from that of its partners. It shall have perpetual succession. Now, my lord, your just two decisions apropos what Mr. Banerjee had submitted is settled law. My lord, there cannot be any dispute. It goes back to Bacha Guzdar. Shareholder has no right over the assets. He is only entitled to dividend. Apropos his shares in the company, and a fairly recent decision of our court also, my lord. Paragraph 10, please, my lord, of Bacha Guzdar. Company is a juristic person. It is a company which owns the property, not the shareholders. Fairly settled. Kindly pardon me, my lord, fairly recent judgment of our court on the same point.
Citation is not important.
I've given the judgment. My lord, your lordships have held that same. My lord, our court has held. Paragraph 22, kindly see, my lord. However, as per the admission in the plaint itself, the plaintiff is yet to be declared as a shareholder of the company. Can you see 22, please, my lord? And that is the fact situation here also. His document shows he is not shareholder. The estate is not a shareholder and or recorded as such. Even if the plaintiff were to be declared as a shareholder in the D1 company, the position of law is well settled that a shareholder cannot claim any right, title or interest in the assets. And then 25, he seeks to be exactly in this schedule, which is annexed here to the affidavit of assets filed in the testament. In the same breath, the plaintiff seeks to be a shareholder of the company and a partial owner of the immovable property described in the plaint. Thus, there is palpable non-disclosure of the right of the plaintiff to the suit property from an essential component of the bundle of facts which comprise the cause of action for the suit.
This is Order 7 Rule 11 or something.
Well, this is...
That's very... No problem.
Yes.
Anyway.
Order 7 Rule 11. 3940, the decree was justified, not interfered with. Appeal from decree.
Right. So it's the same principle relating.
Yes. So, my lord, now, my lord, the serious consequence, now kindly have the order once, please, my lord. My lordship has seen the order. The serious consequence of this order is, my lord, I am restrained
dealing with your assets.
Yes. Now, he avers on oath that the completion certificate is been granted. Now, my lord, I am bound under the RERA to execute conveyance. Kindly see the provisions of do copy though. It's my statutory duty to execute conveyance. Now, my lord, kindly see 11(4)(f) of the Real Estate Regulation Development Act. Chapter 2, Section 11, please, madam. Functions and duties of promoter.
Yes.
And then kindly see 4, the promoter shall. And kindly see F of this. Execute a registered conveyance deed of the apartment, plot or building as the case may be in favor of the allottee along with the undivided portions of the common areas to the association, allottees or competent as the case may be as provided under section 17. So it's a statutory duty to execute conveyance. And then kindly see 17 prescribes the time frame. Transfer of title. The promoter shall execute a registered conveyance deed in favor of the allottee along with the undivided proportionate title in the common areas, so and so, as the case may be. Then can you see proviso? Provided that in the absence of any local law, conveyance deed in favor of the allottee or the association competent authority under this section shall be carried out by the promoter within 3 months from the date of issuance of occupation certificate.
There are penal provisions.
There are penal provisions. So, my lord, and not only penal provisions, my lord, the flat owners, my lord, are breathing down my neck. So, my lord, now, apropos the order, as far as I am concerned, my lord, no reasons as to how any asset of 25 can be deemed to be an asset of the estate. No prima facie finding that, my lord, the MOU of 2009 was actually acted upon to even to the limited extent of 12.5%. That NL Todi was inducted in the partnership even to the limited extent of 12.5%. So in the absence of a prima facie case, my lord, balance of convenience, irreparable injury cannot stand for any consideration. And there are no reasons. Order is especially perverse, my lord, as far as 25 is concerned. Those are my respects. Yes. Urgency, and your lordship has urgency, Mr. Banerjee has already addressed your lordship, my lord. Yes. They have come to learn of these facts in 2025 and
May 25 and
yes.
January 26.
And completion certificate is there. The building has come up. Yes, my lord, I've given particulars of all the agreements which I have entered into, and all this is also, now kindly bear in mind, he knows completion certificate because it's put up on the RERA website. It's my document. I have
completion certificate they have referred to in their application.
That is what I showed you, lordship. That is
49 was that.
Mischief. That is the mischief.
That was which
I'll just show you, lordship, my lord. Kindly have paragraph again.
Or the page number.
Yes. No. Beliagata property is yes, page 496.
496, yes.
Completion certificate for the project has been obtained.
Yes.
So this comes in the public domain under RERA. So this is the mischief. Grateful.
Yes.
The first point, I will first deal with Mr. Banerjee's appeal, and then Mr. Thakkar's appeal, because Mr. Thakkar's appeal, he is referring to pleadings and situations and facts, which is beyond the scope of the plaint as well as the petition. Now, both of them have a common submission that there's been some suppression. Now, first of all, obviously, Mr. Banerjee is very well aware that, and that's why he showed Bengal Club, The Bengal Club judgment.
He asked for Bengal Club, actually.
Your lordship's asked for him, but there were two other judgments which were considered. Was Hitesh Pandey
was distinguished in Bengal Club.
Yes, but
dealt with.
It was distinguished, but
it was dealt with in subsequent prevails.
Yes, but for what reason it can be shown before the appeal court, is whether and that is where I fall. Today, your lordship will have to see what is the genesis of the suit. First things first, it's very important that we have a look at the 2009 memorandum. That has not, I believe, I had to leave court for some time, I don't know whether that has been shown to your lordship. That is the most important document, both for my learned friend, Mr. Thakkar, as well as Mr. Banerjee's client.
2009 document.
Yes.
Yes.
Mr. Thakkar's client, as a company, is a party to that memorandum. And in that memorandum, they have said that we will be bound by this 25, 50, and 25. And they all.
You said that you would be addressing Mr. Banerjee's.
Well, it's because that is the same thing. Mr. Banerjee also not placed 2009. So therefore, 2009 is the genesis. Because Mr. Banerjee is saying, how can I be a party?
No, you deal with their substance one by
first point. Okay, first point, Mr. Banerjee has
for us because you have recorded their arguments separately. So your
one
things will take note of.
So Malad is with Mr. Thakker.
Whichever
your lordship wants. I'll leave it to your lordship. Whichever is in before your lordship, I'll deal with
whichever is shorter first.
Malad, shorter Malad would be Mr. Banerjee.
Yes. That first.
Now, Malad, let us understand.
No, not 9 document not placed.
Not placed.
What is the relevance in Mr. Banerjee's matter regarding?
Yes, I'm just coming to that, Malad. And what is the suit for? Let me not go to the entire plane, but the suit reflects that this person is the executor. He has filed the execution proceedings before this, probate proceedings before this court, Malad, where Malad, he has set out affidavit of assets. In that affidavit of assets, Malad, properties have been disclosed of the testator, which is NL2D. Now, Malad, NL2D in 2009, Malad, along with my learned friend's client, Mr. Banerjee's client, as well as Mr. Thakker's client, Malad, had entered into a family settlement. The company also says it's a family company and enters into a family settlement. There are several Malad companies, Malad, which has been identified as family company. These companies have been made parties to this settlement and they have been entered there. Now, Malad, according to that settlement, Malad, which was there, Malad, the settlement is very clear that it will not be changed. It will be binding on all parties. And Malad, it also has some kind of an affirmative vote which is required for the purpose of changing any of the nature of any of the companies or Malad, the firms or the trusts or whatever it is. So, Malad, 2009 agreement is the place where Malad, the properties were divided. And from where Malad, NL2D's properties, Malad, devolve, which is including the affidavit of assets. Now, Malad, in this affidavit of assets, Malad, your lordship will find, I'll show the 2009, Malad, it talks about 4 schedules. 3 are schedules where Malad, NL2D's group has something independently, Mr. Banerjee's client has something independently, and Malad, Mr. Raj Todi, Malad, the other son, Malad, he has something separately, independently. And there are where Malad, there are joint understandings and joint holdings where all 3 are parties and they would have to act in unison. And Malad, 25, 50 and 25 was the share which was admittedly agreed upon in that agreement. Now what happens, Malad? I have...
What is the page number of 2009?
Yes, yes, Malad. Malad has which, Malad, they are in...
Either of the 2, if you,
Malad, yes,
whichever you are prepared, just take a note of that.
Yes, I'll just give me a moment, Malad.
In mine, it is 301. The second document is 301.
301.
205. 205, I'm told, Malad, in mine.
Yes, yes.
আমি তো এটা খুলে পাচ্ছি
59 FMAT 59 it's 301. Yours is
205.
205.
भाई इंग्रजी करते अक्षर भिन्न whatever it is, Malad, it's 205. I'll read from that.
Got the pages.
Yes, I'll read from that, Malad.
Yes, yes. We'll come to that.
No, I'm just giving the genesis.
Yes, absolutely.
Now what happens, Malad? I am here before this court. I say that these are the properties. My learned friends obviously come up and take the same points, saying that, look, these are companies. How can they form a part of the estate of NL2D? That properties are owned by companies, therefore, part of that property cannot form a part of the NL2D affidavit of assets. Now, Malad, when I filed this suit, the probate application, Malad, I was not aware of this 2019 document. And what is this 2019 document is very important. Before that, Malad, in 2018, Raj Todi and Malad Pawan Todi decides to enter into an agreement whereby they deal with all these properties. And there they say that agreement will be binding notwithstanding anything contained in the 2009 agreement. So NL Todi and whatever assets he had is wiped out by this agreement.
The subject matters were common in both.
Yes, well, it refers to the 2009 agreement. It refers to the 2009 agreement.
That is impugned here, or it was a previous agreement between them.
No, this is the agreement. 2019 agreement also speaks about the 2009 agreement and saying that this 2019 agreement will be the agreement which will be binding notwithstanding whatever there is in the 2009 agreement. Now my learned friends come and say that, look, you have suppressed. Let us take the point of suppression at the very first. I'll try and deal with it because what have I suppressed? According to Mr. Banerjee, I have suppressed an order where I have not got an interim order for an injunction in an application for administrative pendant. Sorry,
sir.
I know, dear lordships have got a larger bench.
Not so large, but as larger. So we'll continue with this after 2. I mean, from 2. Yes. Yes, yes. Even if you don't have anything else, you have to show that you are busy.
No, I
come back at 2.
Yes. I don't know why would I do that.
এগুলো সাইড করে
এখানে চলছে
আবার পুরোটা খুলতে হবে, এটা হচ্ছে মুশকিল আবার।
তুমি এতক্ষণ বললে কেন বলো তো, প্রথম শেষ করতে হবে।
ঠিক আছে, খুলে করবো তখন যাবো। আমার দিকটা সাইড করে হ্যাঁ, সাইড করে লিখে দিন, আবার চাট করে দিয়ে দিতে পারবো, 2টোর সময় দিয়ে দিতে হবে।
আমি আছি, আমি আজকেও আছি।
Today. Continue. We are not passing any order.
Yes, great.
Yes.
Great.
The district judge, Andaman and Nicobar Islands, has the unlimited jurisdiction to hear all appeals from orders of civil judge junior division, irrespective of the valuation of the suit.
Obliged, Lord. My Lord, I am appearing for the petition.
ওইখানটাতেই আছে বুঝছি, পেছনটা দেখাতে জমি একটি এখানে আবার কি করেছে? ও আচ্ছা আচ্ছা আচ্ছা, হ্যাঁ হ্যাঁ আচ্ছা আচ্ছা।
যেতে হবে আমাদের আচ্ছা তো যেটা করেছিল স্টুডেন্টের আমি তো বারবার দিতে পারি না দাঁড়া নিজে এই ম্যাডাম এটা একটু চেম্বারে পারি না
Thank you.
Grateful.
Yes. Yes.
Which as I was saying, Malad, so the scope of the suit, Malad, is that, Malad, we came to learn about this 2019 Malad, document, Malad, after, Malad, an opposition was filed in, Malad, GA number 3. And what is GA 4, which is, Malad, a vacating application which had been filed by my learned friend Mr. Banerjee's client, to which Mr. Raj Todi had filed an opposition, from where for the first time we come to learn about this agreement.
That was in May 2025.
May 2025. Now, Malad, at that point of time, Malad, kindly appreciates, Malad, I had proceeded on the basis as an administrator pendentity. I'm entitled to, Malad, have the security of all the properties which are of the testator. Therefore, I sought for an injunction. Now, prior to that, Mr. Raj Todi had already got an injunction with regard to one of the properties, which was part of the memorandum of settlement of 2009.
So, got it in which proceeding? The probate?
In that probate. Well, very interesting. The contentious cause was raised by both the brothers. There, one brother files an injunction application against the other, supporting the executor. And the executor also fights for the entirety of the assets. Where Mr. Banerjee's client takes the point, this is testamentary jurisdiction. How can you get an injunction here? That is the point taken there.
That's not reflected in the order. That is a difficulty.
No, it is not, because
it's a deemed. There is nothing.
There is nothing. I did not get an order. That is what they are trying to say. All the cost papers are part of the list of documents in the plaint also. Today, what was submitted before the court, the case made, I'll just point out the paragraph, just 2 minutes I'll take. The case which has been made out is 2019, I get to know about this. Why was the settlement entered into? The question was that Mr. Raj Todi filed a suit against Pawan Todi with regard to another property, where they decided to settle between themselves and withdraw the suit, and Raj Todi would withdraw the suit on these terms. And in these terms of the 2019 settlement agreement, which is there now, there, the memorandum of agreement of 2009 is being dealt with and is being superseded. So when I come to know about it, I am excluded. I've given specific paragraphs of each of the properties how have been excluded by the 2019.
So Banerjee raised a question of urgency in the matter because you came in January 2026. Although you learned about this in May.
I came to learn about it in 2025, by that time, what I found, I had filed, my application was pending here. The other one, which is probate is pending here, Here there is an administrative pending application. This is under 211 of the Indian Succession Act. There I find, now that they, as it appears now, though I was saying that they should not be allowed to rely on those statements, but in their application they are saying everything has been sold off. Only 18 flats left. That is the reason I came as quickly as possible, that when I understood that they're dealing with it. Now they are only saying in their petition that out of 175 flats, all have been sold. Only 18 left.
That you came to know after you filed this appeal and they made this application.
We got to understand.
Rather, after they preferred this appeal.
The numbers, yes.
But what prevented you from coming to court between May 25 and January 26?
I did not. I'll be very candid to your lordship. We were here before this court. Probate court for an administrative pendentity. But I have challenged this document as a fraud on the estate of the Nandalal Todi, the testator. So it's a fraud which I am challenging, There, if it's a fraud, it's always a fraud. So, my lord, if I,
So he's on the injunction.
but again on the injunction, I meant I
But
must,
at any point of time, the suit is within limitation.
obviously, suit is within limitation.
But why should it be constituted to be your player should be constituted? Why do you have urgency? I mean, if you had urgency, you would have come earlier.
My lord, I have come to know about it. Now I find that they're dealing with the property. Now, kindly seize my pleading. Can you take the petition, my lord?
Which one should you take up?
That is with the Akshay Vinmay LLP. My lord, FM 8059 is with your lordship, my lord.
Yes, both are with us.
Volume 4, my lord.
Yes.
Page 468, my lord. Madam, kindly see, my lord. Paragraph 61 onwards on page 500, my lord.
Yes.
And I have said that, my lord, by using this, they are now dealing with the para 62, my lord. By relying on the aforesaid alleged memorandum of settlement has dealt with and is attempting to further deal with or transfer and implement the transactions. And which is true now according to their petition also. Though they have not filed anything before the trial court, my lord. But that is the truth now. And where, my lord, on the face of it, my lord, with humility, I say, my lord, the rights, my lord, what has the trial court held? The trial court has held that I am the executor, I am supposed to protect the estate. And it appears that, my lord, these are from the memorandum of settlement of 2009, these are being superseded by the 2019. So 2019 not to be given effect to. And if 2019 is given effect to, my lord, these properties are sold. So that is
premise of his suit, Mr. Rai, is that in the 2009 agreement, both of them were admittedly
yes,
were admittedly parties. One. Secondly, they knew therefore that 25% went to NC. And they're
not once, my lord. Thrice they have said this. There are two supplemental agreements also in 2009 and 2010, where they endorse it again.
Now but subsequently they want to defeat the will by this.
Yes.
Or at least even if there was no will, even then this 25%.
The memorandum of settlement, yes, that is being defeated. That is being defeated. Malad, kindly.
Not entirely based on the
will.
But also the.
Malad, the settlement of 2009 is the basis of the affidavit of assets in the will. So today, Malad, the executor stepping into the shoes of the testator is trying to establish that yes, these are the properties because they are disputing the affidavit of assets. Malad, there are several points are being taken. Once you dispute the affidavit of assets, whether he can challenge and contend that the will is not correct or will is bad, that is also a question. Caveatable interest, those are questions all there.
So therefore, Mr. Banerjee was trying to link the will with this your suit. So the injunction has been granted on the premise of that will, apparently. But although there is a probate pending, you could have asked for this injunction.
That is what he's saying.
Yes, but you are saying no, it is not merely on the will, irrespective of the will, also on the 2009 document.
Because the main prayer in the suit, Malad, kindly sees. It talks of the 2019 and how do. Malad, the will was mentioned because I am the executor. Therefore, I can challenge it.
So what about non-disclosure in detail of this the refusal by the probate court of your injunction application.
My lord, yes, may I come to that now? My lord, when it was, my lord, when we moved it, my lord, order gulo daw na. Bollam copy ante ki korcho toমরা? My lord, when it was moved, my lord, then
You actually tell him.
no, I did, my lord.
Yes, yes.
এই ওটা বলেছি নাকি বলিনি?
Yes, sir.
I cannot
There's a saying in Bengali, but we need not. Regarding this one
okay,
being
what
witness of the other. Yes.
No, I did because, my lord, the point is, my lord, when it was moved, I was not aware of this 2019 document. It is obvious, my lord, because it was filed in an opposition.
But the injunction you seek is similar.
As a pendant elite, yes, I am trying to protect the probate proceeding, yes. But here, what am I trying to get, my lord, is the 2019 document I am challenging. Why am I challenging? My lord,
Right, Mr. Rai, we can appreciate your submission that this challenge is separate from
Yes.
the probate proceeding.
my lord, it's on whether both the prayers are same.
The injunction you seek ultimately is what was refused at the ad interim stage, at least not granted by the probate.
One of the companies would not be here.
Companies
One of
in the probate proceeding.
in the probate proceeding, the defendants are not there. I wanted an administrator pendant elite, my lord. And that Pawan and RK, those who have been the contentious cause, the defendants, to be injuncted only. That's the maximum I can get from this court, my lord. Now, my lord sees who has preferred the appeal and asking for vacating. And my lord kindly appreciates. In the will, my lord, I cannot make them a party. Because, my lord, the affidavit of assets.
No, Mr. Banerjee's client has also preferred this.
Yes, yes.
Pawan Kumar.
Yes,
He is
yes.
a party to
Yes. But, my lord, why I am saying this, my lord? I am trying to get an injunction out of that memorandum of settlement. But here I am saying that the affidavit of assets which I have given, of those properties, I should be appointed the administrator pendant.
So the premises are different.
Premises are completely different. My plaint is on a different.
Yes, yes.
So, my lord, today to come, my lord, now I am being a bit technical, my lord. Now, my lord, to come and say, my lord, because if Bengal Club is, but if Bengal Club is given, my lord, full, my lord, recognition, then, my lord, Order 30 and Rule 4 goes.
Do we have an option? It considered Jitesh Pandey. Jitesh Pandey was
Jitesh Pandey, my lord, said otherwise.
Pandey was the prevalent view, but if considered and discussed and then contrary is held by a subsequent bench, then that is binding on us.
No, no, I'm not saying, my lord, kindly appreciate. I'll place Bengal Club. Bengal Club
have our reservations to some extent, Mr.
My lord, Jitesh Pandey.
Not in law of precedence diverse.
I understand, my lord. My lord, that is also because, my lord, that is
because that was
a divisional court.
You have a very strong point in arguing, Mr. Rai, that then Order 30 and Rule 4 is used up by the appellate court at this stage.
My lord, I also say
That
this.
too, without Order 40 and Rule 27, in Bengal Club it was held on affidavits by invoking Order 40 and Rule 33.
Yes. But where?
Anyway, but that has been
But
held,
where?
that is the law now.
Whether, my lord, yes, I'm going through that, my lord. Bengal Club has not made it as a general rule. My lord, kindly see Bengal Club, my lord.
Suppression.
No, my lord, what suppression? What kind of suppression?
All right.
My lord, today saying anything, if I don't say even us.
No, it has to be material.
Yes. So, my lord, kindly takes Bengal
Doubt on
Club.
that, yes.
And a 46 onward. Question is, my lord, who is suppressing? Coming and delinking oneself, my lord, from the 2009 agreement completely and saying that 2019 you are not a party, my lord. Wouldn't that be a suppression? I'm asking myself this question. And it's a pertinent question. My lord, kindly see para 46 onwards, my lord. My lord talks about what was the suppression, my lord.
Yes.
But this fact, my lord, kindly says, but this last sentence. has not been stated clearly in the injunction petition. The statement made in paragraph 41 of injunction petition is quite misleading and does not disclose the real facts. The court cannot ignore this. This court finds that it is not a case of suppression of facts unknowingly. Now, my lord, I pause here for a moment. Kindly consider the plaint case. In my case, my lord, kindly consider the plaint case. The plaint case is, I have come to know about a 2019 agreement, which is affecting the testator's rights under a 2009 agreement. It has got nothing to do with the probate, my lord. Nothing to do with the probate. But, my lord, I must say, the plaint, in the plaint, my lord, all these have been mentioned, that there is a suit, there is a contentious cause, there is an order taken by Raj Todi where there is a vacating, from where I came to learn about this opposition, from there I came to learn. So, my lord, saying that I have completely suppressed, that is not correct. And, my lord, again I say, my lord, the injunction which was refused was, was refused only because it's the first time I came up to the court, it said that after affidavits. It is not that injunction is refused, it's still being heard. But what is the matter? The matter is I wanted appointment of an administrative pendability. And pending that I wanted an injunction. The scope of this plaint is completely different, my lord. Now your lordship kindly appreciates in light of this, my lord, can I be told that I knowingly I suppress this? Because my case is that you are trying to overcome an agreement. This court, my lord, if I may...
You may also have a subtle point. I mean, regarding suppression, that injunction in the probate ad interim refusal of injunction, it was held by the division bench to be not to be a judgment deciding the rights of parties. So therefore, reinforcing the fact that the merits of the injunction was never considered.
Never considered.
It was not an adjudication. The principle of prejudicator probably may not apply.
No, it won't apply. It won't, my lord, with humility, it won't apply. And my lord, kindly appreciate, my lord,
Deemed refusal is
even res judicata, my lord. If it's a question of res judicata, my lord, there has to be the parties' commonality will also.
That too. That too.
So today, my lord, I couldn't have, my lord, taken it away like that. But may I just read the order, my lord? I don't have.
Yes, yes.
Oh, it's annexed. So, oh, my lord, it's part of the other appeal, my lord, page 569, volume 4, my lord. I'm just reading it out, my lord, if your lordship. But it only says that someone moved the application for appointment of administrative pendability and interim order. Counsel for the defendant number 1 prays for time to file affidavit and affidavit directions. Then, my lord,
give us the page numbers.
My lord, this is 569 of the other appeal, my lord. Appeal number 1. 110.
64.
Pawan Todi appeal number.
Pawan Todi is 64, yes.
64, man. Page 569. And my lord, the division bench is at page 597, man.
Yes.
And it talks about the history. I am reading para 4. Upon hearing the learned senior counsel appearing for the party, find that the imprint order is somewhere in between, in the sense that GH3 has already been moved previously and no identity was granted, but the application has not yet been finally decided. This is the appeal court. And therefore, we are informed that the learned court lost determination and could not be heard. On a number 9. However, on a careful perusal of the imminent court fell from your lordship.
Judgment. So that we saw when Mr. Banerjee was speaking.
We find no rights of either of the parties and decide whether said order, nor can the same be to be a judgment under the latest patent. So there was no adjudication. Now, my lord, kindly, my lord, considers that in light of Bengal Club para 48. And now let us consider, my lord, let us also consider this. I have, let us say I had annexed it, the judge saw it. But would it have made any difference on the point that after the appeal court has held like this? It's not a judgment. Now, my lord, next, if this is to be now distinguished, my lord, then, my lord, Jitesh Pandey remains. My lord, it is not that Order 39 Rule 4 is Oshios. Cannot be. This is, my lord, an exception. With humility, I am saying this, my lord. Followed definitely, but it's an exception. My learned friends will have to show first that why you're going to say that this, if shown, is a suppression. I suppressed it to that so that I could get an order.
No, Mr. Banerjee said something. See, Mr. Rai, we can distinguish between two scenarios. One is that some new documents are produced which require a prima facie, at least, if you may say, adjudication or adverting to.
That's sort of
which are separate documents, suppose accounts or something else, which are not at all a part of the record.
Yes, yes.
Or in the do not fall within the chain of events which lead to your cause of action. But these, he argued that these were within your knowledge, and he's relying on certified copies of orders and applications.
And I'm also not disputing that. I am saying for that list.
So these are not new documents in that sense.
No,
you were aware.
But I'm not saying that.
And these are public in the sense.
I'm not taking that point, Malad. That he cannot say that I have suppressed it. I'm on another other point. Suppression has to be something which, if suppressed, by doing that, I have procured that order.
Yes.
That kind of a document, yes, Malad, with humility, I say the appeal court must see. That is Bengal.
Yes.
But is this document, Malad,
to be a material suppression?
Material. That is what I'm on.
Definitely, it has.
But is this a material fact? Considers the plain and the case which is here before this court. And if they had taken the point, I would have come back on a reply also saying that you cannot prevent me from getting an order from each court on a different footing. Here they are saying you cannot get an injunction. Probate court has no right.
But where do we get that they opposed on the ground that...
that is what I'm saying, Malad. That should be a point of affidavits.
No, we don't know what stand they took there. You said
I can get the affidavit and show it.
Their affidavit in their
affidavit
they have taken
it is there.
That in the probate court this can
It is there. It is not maintainable.
Argued to the contrary that it is settled that.
Malad, that is why I said, Malad, these questions then become questions of fact, Malad. They should go and file an opposition. Even
they have filed an affidavit there.
Sorry, Malad.
They have filed an affidavit. Where
sorry, Malad. So sorry. Yes, Malad. I said, hey, Malad.
Even did not notice the. So, but whatever.
Malad, they have filed.
They have taken this.
It's ready for hearing. That's why.
Probate court cannot grant.
Yes,
very good, very good.
I just. And also they have taken this point, Malad, that company.
That was.
Companies' properties cannot be a part of the affidavit assets. That point also they have taken there.
Yes, but that does not.
Because I've pursued that prayer here.
Yes.
In this suit. On that ground, your lordship kindly now compares, Malad, whether the prayers here and there, Malad, would have the same effect. It wouldn't, because orders Mr. Thakkar wouldn't be here.
His client.
You are my.
I'm my parent, but
Malad, very simple, Malad. Very simple. Mr. Thakkar is not a party in that probate proceeding.
Thank God, yes.
So, Malad.
We thought you were putting him on a higher pedestal than Mr. Banerjee. But he has come in the meantime. Yes. So if it's on their clients, then it's all right.
Malad, obviously, Malad.
Not obvious.
No, Malad. These are.
So you take a specific point that Pawan Todi took this point in his affidavit that probate court does not have the power to grant injunction.
I'm just reading.
Yes, we are repeating because we want to be clear on that also. But they're making a contrary argument there, one of their contrary arguments.
I'll just get back to it.
Since you are being, advertised.
But a submission was made, I'm sure. I'm just trying to get that from the affidavit. Submission was made, I'm
When you
sure.
get it, just
But obviously, we are not bound by the submissions, so we try and just.
no, not that. But this is also on. What should you say? Not issue stable in a sense, but you cannot make contrary arguments. We'll consider that.
But I'm not on that also.
The structure of the language we'll consider later.
Yes, that is the point today which I'm trying to make out is are the two
put it across to Mr. Banerjee so that he can reply in his reply.
Yes,
No, because if they had argued in the other matter, probate proceeding, that the probate court does not have jurisdiction to grant injunction.
Yes, on these properties. That's
Here
what I
they
said.
then cannot argue the contrary, saying that this could have been asked before the probate.
Malat,
That is one of their arguments.
specifically, first point which they had argued was these are properties of the company.
Correct.
Probate court has no jurisdiction.
Because
These couldn't have been included in the affidavit of assets. Therefore, this court has no jurisdiction over these properties. I'm sure Mr. Banerjee will support me in this. This was
Absolutely. Same stand we are taking now also. You are claiming through the will again. I have to take the same stand.
I'm not claiming through the will. That is
That's
what
your
my
first
stand
paragraph.
is. No. Malat, my first paragraph is section 211.
No, they took a point that probate court cannot grant injunction, does not have jurisdiction because properties belong to the company. That they are also arguing here.
No. Malat,
what is the distinction?
The distinction is, Malat, here I am saying that I am trying to safeguard the asset of the testator. How? Because I'm.
How you implicate the companies and ask for this injunction.
Yes, and also the 2019 I cannot challenge.
But the other point remains.
I cannot challenge here, Malat.
Yes.
So that is the reason, Malat. And on that ground, I'm only humbly submitting, Malat. Is that a suppression? And Malat kindly, Malat takes the plaint once, Malat. Malat, I have disclosed this contentious cause. It is there. I've said everything. And Malat, I've also read the orders, Malat, which were a part of Mr. Banerjee's.
Yes, he also plays those.
Yes, so Malat, the question of any per se suppression, Malat, because Malat, no list was decided, no rights were decided. Now, Malat, may I just take your lordship, Malat? First, through the plaint, just to show I'm not the entire plaint, only the cause of action. Then I will show, Malat, the memorandum of 2009 and how it is being, Malat, denigrated, if I say so, by the 2019 agreement.
You have to deal with Mr. Thakkar's arguments also.
Malat, the property, the 25%.
Yes.
12.5%.
But first of all, Malat, this RERA and everything, Malat, was not before the trial court. And the only thing which is saying, Malat, is about the completion certificate that I had mentioned.
Yes.
Now, Malat kindly appreciates. But may I finish with this and then I'll take over Mr. Thakkar.
Better.
Malat, very
No,
quickly.
Mr. Banerjee also took a cardinal point, a fundamental point that how could an asset belong to a property be an asset of a company and simultaneously be the property of the testator?
Malat, that has to be decided. Why I say so?
No.
I'll point out.
Especially even.
I'll point out. No, Malat, if the company itself has decided and entered into that agreement.
2009.
Yes. Then that is prima facie, with humility, I say.
So the company itself admits that the property
are joint 25, 50, 25. They are parties to that as confirming parties.
So therefore, they are co-owners in the assets also.
Yes.
25% belongs to NK and belong to
that is
NL or NK. And very
now that is what I'm saying, Mala. That is the prima facie case. Now that has to be decided. But will this be
not a question of shareholders claiming an
no?
Right
That's why I wanted to show the agreement. I'll just show.
Yes.
But first, when it kindly comes to the plaint once, Mala. The plaint. Mala, your lordship is having.
We are having both, in fact, whichever.
Then, Mala, I'll take your lordship to the Akshay in my
yes.
brief, Mala.
Which page? Volume 3.
Page 170. volume 4, volume 2, sorry.
Yes.
Malad will kindly see that at the very beginning, Malad, what Mr. Banerjee was saying, that yes, I have said I'm the executor because I draw that from section 211 of the Indian Succession Act. Now, Malad kindly straight away sees, Malad, everything is written there, Malad, about how this went on. Your Lordship will first see para 13, which is at page 178. During the lifetime of Nadlal Todi, dispute arose between Pawan Todi and Rajkumar Todi with regard to various assets. To put an end, the memorandum of recording oral family settlement dated 28th of 2009 was executed. Then your Lordship will kindly see 14, that settlement is still binding and always binding. Now that is one of the issue in the suit also. Because if it was not binding, then 2019 might survive. Then Malad kindly sees, here it is said in terms of the Malad page 179, the assets of the family were distributed in the following ratio 25, 50, 25. And Malad, it has been narrated.
By NL group, you mean the
Nandalal Todi, Malad, that's the test return.
No, group means the companies as well as the persons, the natural persons.
No, Malad, there were 3 groups. NL.
All individuals, I mean, natural persons.
Yes, individuals, but involving all Malad,
shares in
co-personers and Malad.
No, that is different, but
Yes.
all individuals, human beings.
Yes, but
juristic entities.
Juristic entities are also parties as confirming parties.
That's different.
And they include themselves in that, saying that we'll be bound by this.
All right.
I'll take your Lordship to the agreement, Malad.
That is what we fear the most. No, you have to. You have to.
Malad,
You have to.
I don't know, Malad, if because.
No, you have to.
Kindly sees now. Para 15, Malad. There was another memorandum of oral settlement, Malad. That was a supplemental. There were 2 supplemental agreements by which, Malad, there were divisions. Malad, kindly sees para 18, Malad.
Yes.
This is with Tivoli Park apartment, Malad. The shareholding was decided to be 23.54% in Tivoli Park apartment. In the ratio 25, 50, 25. Which your Lordship will find in 2019, it should reduced by the agreement of NL, Pawan and Raj.
Without the others being parties.
Yes. Then Malad kindly sees para 20, Malad kindly keeps note of that, Malad. There was a schedule, Malad, which required affirmative votes for the change of structure of any of these companies. Now, Malad, this company suddenly changed into a LLP and now they are saying you're not a party. But the company records it.
Yes. LLP inherits whatever
the company had.
But these had outsider shareholders also. Not only the family.
The property.
The companies. The companies had shareholders outside the family also.
Well, no, these companies, I don't think so.
50%.
No, 50%. 50% the property. The property, Malad, there, Malad, Akshay held 50%.
No. Actually, no.
All right, whatever.
I'll read the settlement.
You can't bear the tension. Let us read the settlement.
Yes, and then let me go there. Let me go there. No, Malad, kindly.
Is this?
Malad, kindly no. Malad, I'll just read 2 more paragraphs and then I'll take
is
it.
killing us. Every paragraph you are saying, now I'm reading and you are giving the next consecutive number.
Malad, kindly keeps para 36 in light.
36?
Of the plaint.
Yes. What do you do
Because
with that?
Malad wants to go to the...
No, we'll keep that open.
No, just keeps note of that, Malad. What is the cause of action? And then Malad 37.
Right. The violation of 2009 and the supplemental agreements is the plinth of this.
Plinth of that is it.
Right.
Then, my lord, let me take your lordship to and takes it that there are pleadings to that effect, my lord. Now, my lord, kindly comes to the my lord, the memorandum. The memorandum of the family settlement of 2009, my lord, is at page 596, volume 4 of the Akshay Vinmay, my lord.
596. Right.
This annexure I, my lord.
Volume 4.
Five.
5.
Volume 5, my lord. Oh, sorry, I said
Volume 4 ends with 595.
Sorry, my lord.
কি দেখাচ্ছে সেটেলমেন্ট হ্যাঁ
Yes.
207 আছে ওটা আমাদের
Oh, okay. And kindly, lordship, and kindly sees the parties will be important, so I'm just placing that, my lord. 2009 between one Nandalal Todi, Shanti Devi Todi, both is and such, and their daughter Shushma Bajoria. Shushma Bajoria is my mother.
All right.
Collectively referred to as the NL group. So this is the NL group.
You are appearing for what is your name?
I'm Neeraj.
Neeraj. All right.
Then, my lord, to deem to mean and include each of their respective heirs, legal representatives, executors, administrators, and assigns on the first part. So, first part is NL, second part is, my lord, Pawan Todi. And Renu Todi, Rishi Todi. Well, it is Pawan Todi's group, my lord, as such. That is the second part. And then your lordship will see Rajkumar Todi and others, my lord. That's the third part.
Right.
And my lord, there is Ace Impex Private Limited. It's another company.
Oh.
Then, my lord, 2, Akshay Vinmay Private Limited. It's a party, my lord. And there are, my lord, another party, my lord.
What are they described as confirming parties or?
Confirming. Fourth part.
Very well. Yes.
Fourth.
All right. Very well.
Now, my lord, kindly sees recital, my lord, at 598, recital C. The Todi family companies and partnership firms were subject matter of this settlement are mentioned in Annexure A, wherein Todi family members are holding shares, interests, are collectively referred to as the Todi family companies and firms.
All these companies are defendants in your present suit.
Well, not all.
Substantially.
Not all, but the ones required. Under the 2019 settlement, whatever has been given to whoever,
those obvious.
That are made parties.
But they are all parties to this.
Yes. Well, kindly see Schedule A.
No, what we mean to say, Mr. Rai, is that
whether all the defendants are parties to this settlement.
They are.
Malad,
or where?
I will just check. I'll just check that one. I'm not too sure about all the companies. Malad, huh? No, no. Developer ke party kora
selectively party.
Malad, certain third parties have been made parties because by 2019 agreement, Malad, those have been dealt with. So
it means there have been certain rights have been created.
Yes,
dealt with in their favors.
In their favors. There, as I can say, Malad, with Akshay Vinmay, Malad, there are developers who have been made parties to the suit.
Because they dealt with the property in their favor.
Yes. Now, Malad, kindly take 618. I'm just straight away, just serial number 3, Akshay Vinmay. So, Malad, they are themselves, Malad. It is agreed that this is the company of the family company. Then, Malad, kindly comes.
Some functionary of Akshay has also signed. He's a signature.
Sorry, Malad.
Any of the functionaries of Akshay has also signed, is a signatory.
Yes, yes, Malad. They were family members, Malad. They signed those. Akshay ne bolte, "Ek mujhe nahi to direct picture mila."
In their individual capacity, yes.
It's 617, my lord, a director has signed as a director at 617.
Thank you. Thank you very much.
Grateful.
Right. Right.
Now, Malad, kindly please, just Malad, Malad, D, recital D talks about the differences between the parties, and then Malad kindly sees 3 in recital D, Malad, Roman 3. It is further confirmed, recorded, and declared that in pursuance of family settlement, all the assets and properties have been allotted in the ratio of such and such in the manner hereinafter recorded. Then various immovable properties have been allocated is for interest to the various toady families in the manners hereinafter appearing. Now, 5. It is important that certain properties and or interest in certain properties and assets which are held through the various companies as per Annexure E, which companies, including the conferring parties 1 and 2 in this agreement, shall always be held jointly by NL, PK, and RK as mentioned in Annexure E. Now, my lord, your lordship would kindly see Annexure E. This is, my lord, at page, my lord, 625. 625, my lord.
Yes.
List of companies and the properties to remain joint. Kindly see, my lord, for this purpose. This is now for Mr. Thakkar, my lord. 12B Belagata Road, serial number 3. Akshay Vinimay Private Limited. Todi family ownership 50%.
Todi family ownership? Yes, yes.
And my lord, NL Group 25, 50, 25. যাবো এখন তো আমি তো ছুটি দিচ্ছি আমার সারাদিন নষ্ট করেছো আমি ছেড়ে দেবো
We don't understand this. 2D family 50% and the rest 50%.
No.
What is this breakup? This breakup is of 100%.
has a right of 50% in that property.
All right.
And the breakup, as I said, Malad,
So the breakup gives more to NL, PK, and RK. All are 2Ds.
50%, 25, 50, 25 of the 50%.
Of the 50%.
It's mentioned, Malad. I'll
just allotment to each group. Very
yes.
Very well. As Mr. Thakkar also said, the 12.5.
Yes, yes.
Very well.
Now, Malad kindly sees.
You are trying to protect NL's properties.
NL's.
Right.
Sorry. And it just gives me 1 minute. And this is one thing which sometimes happens with our Malad, the new briefs which we hold, Malad.
No, quite obviously.
They suddenly.
No difficulty. Me.
No, happy. Now, Malad kindly sees, Malad, the first few Malad clauses, Malad, are giving Malad each of the 3. Sorry.
But I mean, this is a peculiar sort of an arrangement. I mean, if the company is the exclusive owner of the owner company is the asset of the company, then
yes.
Then how?
But the company becomes a party to it and says yes, it will be dealt in this fashion.
Contract contrary to law.
No, it's not.
Well, let the company agreeing.
Assets of company being agreed to be part of, be owned by some person.
And it says that the company is a family company. So they are saying that the family is holding through a company.
But then you say 50%, the ownership is 50%.
Yes.
It's not entirely a family.
Not entirely.
The other shareholders are not parties.
They are not parties.
At best, estable.
Well, I am only saying, Malad,
but
you
have the law.
Malad, today, Malad, I am at this ad interim stage, Malad, where
maybe
that is what I am on, Malad.
Premature to very well. Let us.
Then, Malad kindly sees. Kindly comes to Malad 10.
10.
Oh, sorry.
You have gone back to the recitals.
Not the recital, the clauses, my lord. But because I showed annexure E, that's why I refer to annexure E, my lord, joint holding.
There's no 10. Roman 9 is the last.
Page 607, my lord.
Achha.
Joint holding.
Alright.
The parties amongst themselves had agreed that some of the companies forming part of Todi family and firms and or properties held by such companies that will appear from annexure E shall be held by the Todi family members jointly, whereby NL and the ratio is given 1:2:1 respectively, unless mentioned otherwise in annexure E, also detailed in annexure E here too, and the necessary transfer to reflect the same has already been carried out. Then, my lord, kindly comes to my lord 10.7. 609. The properties belonging to confirming parties 1 and 2 will be taken up for joint development only in such manner as may be mutually agreed by all the three groups.
You are surprised that no mismanagement action by the other shareholders is on the anvil.
Well, that is now they have become a.
Either of you will set them up.
No, now they have become a. Now one of them has sought to become a LLP.
Yes.
Have been thrown out.
Right.
Now, kindly see. Upon sale, development of the sorry, 10.8. Oh, sorry, 10.7. All the companies which form part of the annexure will be treated as party to the settlement, and the company shall be bound by the terms of the family settlement, both as shareholders of other Todi family companies and or confirming parties of Todi family settlement. Then, upon sale development of the said joint properties as mentioned in annexure E, gross profit shall be computed and arrived at, after which the said Rishi, son of Pawan Todi, shall be paid a sum equivalent to 4% of the gross sales, and only after such deduction the net profit shall be arrived at, which in turn it shall be divided amongst the three groups above named in the proportion stated above. Now, my lord kindly considers this. There has been nothing which has come to the NL group. In this backdrop, my lord, I have sought for an injunction of the property because I am not getting, and I have pleaded fraud. In the case of Order 39 Rule 1B, I pleaded fraud. This is the fraudulent way they are transferring. That is why I sought an injunction on the property. Then, my lord kindly sees. My lord will kindly see 10.9. My lord at page 610. My lord.
609. 10.9.
I'm taking a lordship to 610.
Very good. Yes.
At 10.9.
Yes.
This is annexure F.
Right.
Is not applicable in any group defaults, and this clause is enforced by the other groups. However, it is mutually agreed the aforementioned default means will given a grace period of 15 days from the expiry. This is about shares. No, why I'm saying this? Annexure F, my lord, talks about, my lord, affirmative votes of NL and or NL and RK group to any changes, and kindly comes to annexure F, my lord, once.
So that is also part of the fraud that was not done.
Yes.
What is F?
Yes, madam, just kindly. How many come? 626. 626. Yes. 626. Affirmative rights of RK and or NL and RK group. Because that's it, because Pawan was supposed to do it, Rishi Todi would get 4%. But if any change happens, then it has to be affirmed by RK and NL. And therein, my lord, I have said that you couldn't have made these changes of this settlement also in 2019, removing me and both of you agreeing and just doing away with that.
Right.
So, my lord, this was the agreement between the parties. Now, my lord, straight away comes to the, well, there have been other agreements also where other companies have also been included. I'm not going into that first. Let me show the agreement of 2019 first. next is, this would be at page 716, volume 6.
Yes, got it.
Your Lordship will see that NL Group is not a party to this. And why this suit has been filed, my lord, I'll straight away take your Lordship there, my lord. And this talks about development agreements in respect of the properties which are mentioned in the memorandum of 2009. Now what they do, my lord? Get away, my lord. Just give me a moment.
But even Akshay is excluded in this.
Yes. My lord, because, my lord, Akshay is developing that property. That is what I'm on, my lord. The properties are there. They are making an applicable settlement between themselves. And I just show that to my lord. Just give me a moment, my lord. Yes. My lord, kindly takes page 731 first. Clause 2.2.5. Each of the party, sorry, man.
Yes.
Each of the parties stroke individuals comprising the first party. So this is Pawan and
Raj.
Raj.
This is Raj, yes.
An amalgam further confirm covenant undertake as follows. With an undertaking not to dispute, challenge and or make up, set up, raise, initiate any claim, demand, action contrary to the same. The under noted on any ground whatsoever, howsoever. Now kindly sees B. That none of the parties, individuals comprising the first parties
Amalgam's
have.
director is Dhruv Todi, son of Rajkumar.
Yes, madam. Now that
This is
none
between
of
the Ravi group, the Raj group.
yes, Raj group.
Yes.
Now, my lord, B. None of the parties, individuals comprising the first parties have as on the date of signing this instant memorandum.
C.
C.
This C.
No, B.
B. Yes, B also same. Yes.
So sorry, it starts the same. Yes.
Yes, yes.
On any ground whatsoever, howsoever, any nature, manner, or right, title, interest over any of the SP entities and or the respective share, assets, and properties of each of the SP entities, including but not limited to the SP entities created and or incorporated or formed by
SP entities.
My lord, SP, my lord,
what is the SP?
My lord, SP is, my lord,
Mr. Thakkar or Mr. Banerjee, what is SP?
Not party.
That was a good one, yes.
Second party, sir.
Us. Right. Very good.
Second party, most of it.
Second party.
Sir, page 724. .5, my lord. 3. Any of the firms, partnership, companies, limited liability, entities, associates, HUF, trusts, and everything, owned under controlled and managed and operated by any and or some and or all of the parties individuals comprising the second party,
Senate, yes. Second party
whether
is
individually,
SPL.
independently, or jointly, or collectively, or severally, including but not limited to.
Let us come back to see that page 732. This is for the
Comprising
purpose of
second parties under each of the family settlement agreements. So he talks about 2009. And now it is specifically mentioned in that clause which I was showing your lordship, my lord.
that is very specific.
Yes.
13 March 2019.
So, my lord, this is where the suit is initiated. And I'm sure my learned friends will be in a position to explain on affidavits as to why they did this, how they did this. But on a prima facie, my lord, your lordship will find that this 2019 agreement is affecting the 2009 agreement. Now, my lord, will kindly see why I say that these properties are being dealt with, my lord.
But this binds the parties to this agreement. Interstate the parties to this agreement.
Yes, my lord.
The language is none of the parties comprising the first parties here have as on the date shall make up, claim, set up.
Contrary to the 2008 agreement. But my lord, it tantamounts, my lord, to a change of the 2009 agreement, which they had themselves in the 2009 agreement. They had said that there will no change. But I'll just show that clause, my lord.
What was the changes?
It kindly comes, my lord.
Yes.
It comes from, my lord, 2.3, my lord. Calcutta road property.
Yes.
Municipal premises number 12B is presently owned by, well, it's 736, sorry.
Yes, yes. But,
having its register office and such, of which presently one of the first parties, namely Dhruv Story, is a designated partner holding a stake of 12.5%. In terms of the memorandum of recording, settlement is agreed. Entirety of the said stake, shares, rights, interests are held by the said Dhruv Story in AV LLP shall absolutely vest in and would belong to be transferred to such persons as may be identified by the second parties. So what happens? Dhruv holds 12.5% that is now shifted to Raj Todi.
Yes.
The ratio change. No, Malak, the ratio changes.
That is interstate them.
Malak, the
event that 24.
Malak, what they have said that NL is not a party at all. They are saying they are not partners.
Do they deal with the entire 50%? If they deal with 25%, then it's fine.
No, Malak.
Because 12.5 in any event they had, each of them.
Malak, they had, but Malak first comes to Malak, just Malak kindly comes back to the settlement of 2009 once.
Yes,
Malak.
yes, yes.
I will kindly take
625.
Yes, Malak.
PK in any event had 50.
Yes, yes, but I am saying now
RK
they
had
could have
25.
changed the structure in any way under the memorandum of agreement. It kindly comes straight to
if they cover more than between themselves, if they cover more than 75%, then you can have a.
No, Malak, I am only on a simple point.
You have 25, they have 50-25.
Yes.
So they have 75. So if they operate within that 75.
Malak, kindly appreciates, Malak. Today, what are they saying? They are saying, I am not even a party to that 12B Belagata property. They are saying, I am not a partner.
They say that?
Yes, they did say that.
What is that?
Akshay Vinmay just now said that.
No, they said that you are not a partner in Akshay.
Yes.
May not be.
And Malak,
your claim is not on the basis of being a partner or anything.
My claim is that it is a Todi property.
Your claim is in 50% of that property.
50% or 25% in the property.
Yes.
Malak, today my suit is that you couldn't have entered into this settlement without me being there. Because Malak, the memorandum of settlement,
if they remain within the framework of their own shares, and it's an inter-se adjustment, we may say.
My lord,
And
kindly.
you need not be made a party or be.
No, my lord, 14.6 of the 2009 agreement, my lord,
Yes.
specifies that no one will change the nature of the settlement. Kindly see 14.6, my lord, this is page 613. None of the groups here to will raise any further point and or dispute in respect of account valuation, allocation or allotment. Net one, that arrangement arrived as a recorded in these presence is accepted by all the three groups here to and its final conclusion binding on all the groups.
600?
613, my lord. 14.6.
Yes. Yes. No, none of the groups here too will raise any further point and or dispute in respect of accounts, valuation, allocation,
And
allotment.
arrangement.
So they're not raising a dispute regarding the arrangement.
But they're changing the arrangement, my lord.
Acha, very well. You say this covers also inter-se.
Yes. But it kindly appreciates it's Nandalal Todi's properties.
25% is Nandalal too.
Original, my lord, that was NL's properties, everything.
Forget. This is not
That was
sentiment.
divided. That's also stated in the 2009.
It was Nandalal.
Yes. So after this agreement, it was decided that this will be the way it will be held. I'm on a prima facie point at this moment. This is what was stated. They were trying to change it. And not one property, all four.
They don't exactly say that they will not change it. Please read 14.6, Mr. Rai.
My lord.
None of the groups
Here too will raise any further point and or dispute in respect of accounts, valuation, allocation or allotment and net worth and the arrangement arrived at as recorded in these presents
read on.
Is accepted by all these groups hereby and a final conclusion binding on all the groups.
Up to that, they agree to this arrangement. These are our respective shares. We accept, conclusive, cannot reopen this. But from then on, they don't bind themselves to any further arrangement.
They themselves have said
accept
so.
that the PK owns 50, RK owns 25. We accept this, and you own 25.
Malat, in
that does not preclude them from making any inter-se change between their shares.
Malat, any changes have to be made by all the three groups. It cannot be between both of them.
No, it was accept the arrangement as standing crystallized in the 2009 agreement, Mr. Rai, are accepted by all. So on that is the cut-off date. As on today, this 2009 gives us these rights. We accept it. We move forward.
Malat, that is what Malat. If they move forward,
yes.
Malat, then they would.
After that, there is no further bar.
Malat, I am saying by this agreement they have put me outside.
If they took out your 25% also and
they are not even.
That,
they are not saying that I'm a partner now. I do not have anything. That's what they're saying. That's what Mr. Thakkar just said. That
forget Mr. Thakkar. See the document.
This is Akshay Vinmay, which has been transferred into a company.
The document.
Yes.
Documentary evidence prevails over.
Obviously, Malat, this 613 is binding.
Yes.
That is why
he said you are not a partner. That is something else.
If I'm not a partner, I cannot have anything in a firm, Malat. I won't get a profit.
Even on the date of the 2009 agreement, you could not have what you had. None of the tourists could. If the property was owned by by Akshay, none of you could have anything. None of the tourists.
Malat, again, Malat.
Forget that.
Malat, again,
Malat, agreed, today, Akshay has signed, so it's fine.
Yes. So today, Malat, if they say that I have 25% in the...
How do they take away anything which was given? You were given 25%, they agree. In 2009, they say, we agree to whatever allocation has been made to each of us. So you get 25, one of them gets 25,
let us
gets
see
50.
The 2019 agreement.
Let us see any change. Let us see usurpation of your share.
Yes, may I just take your lordship to...
If they allocate the entire 100%, the entire 50% among themselves, we can understand.
Malat, this document has been filed to set at rest the suit filed by Raj Todi
against
Pawan. For specific purpose, the memorandum.
Their shares.
Now, Malat kindly sees they are saying that none of the parties will be bound by the memorandum of settlement of 2009 anymore. And this will prevail.
That portion, exact language. Yes, language is very vital, Mr. Rai. Very vital.
my lord, kindly just once, my lord, comes to
understanding করে নিয়েছি ওটা ইংলিশ শেয়ারটা
my lord, kindly comes to my lord that clause, my lord. Huh? 2.3. Well, may I just read this? Municipal premises 12B, presently owned by Akshay Vinmay LLP, a limited liability partnership. So, my lord, the ownership has now become that of Akshay Vinmay LLP. Having its registered office at Tori, whatever it is, my lord, one of the first parties herein is a designated partner holding a stake of 12.5% therein.
This is a son of Raj.
Dhruv, my lord, yes.
Dhruv is son of Raj. Yes.
Yes, my lord. In terms of this memorandum recording settlement, it has been agreed that the entirety of the said stake shares rights held by Dhruv in AV LLP shall absolutely vest in and or belong to and or be transferred in favor of such persons as may be identified by the second parties, including but not limited to any of the parties, individuals comprising the second parties, and or to lessee number 2. First, this company was always to remain as a joint family company. In the 2009, it is mentioned specifically.
Always to remain where?
That is there.
That crystallized the rights as on that date. But always to remain future fetter, where is that?
Malad, this joint holding, Malad, it said that these companies will remain joint.
What is that? Will remain.
Malad, I'll just show that.
Shows that portion.
Huh. It is, Malad, 10. The parties amongst, sorry, page 607, Malad.
607. Already, yes. Joint holding.
Yes. The parties amongst themselves have agreed that some of the companies forming part of the Toti family, that is Annexure E,
shall be held
by the Toti family members jointly. Here they're trying to also say whomever I want to give, I will give. And not only there, Malad, it's been recorded twice over, Malad.
Unless mentioned otherwise in Annexure E.
2009.
And I've shown Annexure E, Malad.
Yes, you have.
Now, Malad, let us come back to that. Malad, I am only on the point, Malad, today we are at the ad interim stage. Now, Malad, my learned friends are saying a lot of things. First, they are saying that I am not a partner. Then they are saying that this settlement, Malad, they are adhering to this settlement. They are trying to safeguard this settlement. I think this settlement talks about the memorandum of 2009. He couldn't have dealt with any joint family properties. And Malad will not only that, Malad, your lordship will find all the properties which is Annexure E, Malad, have been dealt with in this 2019 agreement.
But in terms of the 2019 agreement, also it remains joint between the Todi family or given to outside.
But outside, I pointed it out to any persons identified by the second party.
Yes.
Page 216.
Right.
Malad, very interesting, Malad. I'll point out why, Malad. This will is of 2018. And in 2019, this agreement suddenly comes up. Because Raj was disputing Pawan. And then both of them became together. And therefore, the probate is now challenging that the affidavit assets are in excess to what NL has. And this is one of the document. And I cannot challenge it before the probate court, this document.
No, definitely not.
So this is what I'm trying to submit before your lordship,
The texture of your prayer of injunction, although the relief is same, but it's different because
the cause of action is different.
Cause of action is different, and it's premised on yes, cause of action basically.
And it emanates from the 19 emanates from the 19 agreement. I have made this application as an executor.
And you have sought this injunction in a sense irrespective of the will. Irrespective of the will.
I cannot say that.
Cannot say that.
On the basis of the contents of the will, but to the extent that I am an executor.
No, irrespective of the will means yes. No, your source of locus is being an executor. Irrespective of the will means the premise of, I mean, the contents of the will. Very well, if you put it that way. That's a better way to put it.
Yes, because I draw my.
That's a better way to put it. Yes, the contents of the will.
Yes.
Or the effect of the will.
Yes. They are saying the will.
Remain an executor even if the will is not probated.
Not
to be more precise, irrespective of probate being granted.
Yes, whether I could have.
Unless its very existence is negated by some court.
That has not yet been done.
No, that obviously it's premature to say that. So you are an executor in that. That's evident from the will itself.
Yes, that is not disputed.
Even
they might have disputed the will, that whatever it is, that the will is not proper and whatever it is. But their main dispute is the affidavit of assets.
So your locus comes from the will, but your cause of action for this injunction comes from the 2019 read with 2009 document.
Yes.
Very good.
That is my case, my lord. Now, my lord, and my lord, I have specifically pleaded fraud.
Yes.
By all of them, the parties to this suit, saying that the intent was to defeat my rights or the testator's rights under the 2009 agreement.
Yes.
And my lord will also, my lord, because I did not take your lordship through the entirety of the pleadings, my lord, the suit which was being settled, the 2018 suit, Raj and
that is not a part of your pleadings in the trial.
Part of my pleading.
Yes, there.
There, my lord, this settlement was made.
Yes.
But again, that was also to my exclusion. And my lord,
suit, they did not have a cause of action against you, might be.
And I was made a party.
So then not to your exclusion. If your party, how
I was not a big person. I mean, 2018 suit, they settled by this.
They had a dispute, they settled by
this. They settled by doing this. Now, my lord, may I just turn to Mr. Thakkar's argument. Now, my lord, with the company's part, my lord, I am saying that since the company is a party, my lord, they have admitted to the settlement and they have admitted to be bound by the settlement, my lord, to come and say that you cannot take an injunction against the company, my lord, may not be correct, because I am trying to enforce the 2009 agreement by asking for delivery upon cancellation of the 2019 agreement.
So once it's seen that this Akshay Vinay was a party to the 2009, then the rest follows your other arguments.
Yes. And my lord, for the prima facie case, my lord, I say, my lord, whatever now Mr. Banerjee and Mr. Thakkar is trying to say, my lord, yes, they will have a right, my lord, to put in an opposition and, my lord, fight it out. No problem about that. I am ready to fight. I will also have to fight, my lord. But the point is, have I suppressed? You have not gone to the lower court. You have rather made an application objecting to my extension.
Now there is no lower court to go to.
Trial court.
Trial court.
Trial court.
Trial
Yes.
court. Sorry.
So very well, understood. So they
trial
did not
court.
go there. They are coming here for the first time disclosing this document.
Yes.
They can fight out in a 39-4 or objection.
They did not file a 39-4.
No, they did not. You are saying that
yes.
they can.
When
at the
time of extension also they did not file an order 39 rule for saying that I have suppressed.
This order, oh yes, it was extended. Started with that.
Extended. And here is the order, if your lordship wants, I can hand it over.
কপি দেবেন
হ্যাঁ দিচ্ছি দিচ্ছি তোরা তো জানবি তোরা তো কন্টেস্ট করছিস আমাকে নিয়ে যায়নি
আমাকেও নিয়ে যায়নি
কত আমাকে দেবে একটা আমার তো আমি তো জানি না আরে এটা পড়ি
What is this? This is a striking out application.
yes kindly see the second page. The bold part, they had objected on the ground of pendency of appeal for the extension.
They took further time for WS and W.
WS and W. No, no, এটা তো মানছিস
Whoever's phone is vibrating near the microphone, please. Must be yours. As usual. As usual. Incorrigible. You're incorrigible.
Because of my whatever.
What?
I touched the wooden table, therefore
What touched the wood?
that was resonating my stomach. So it was resonating,
Be very specific, clear. There should be no ambiguity in a legal.
I'll if I ever have the chance, I can discuss this later, but let me come back to the matter.
Not clear.
So very well. So they did
So
not
now,
file their written objection or
So now, Mr. Thakkar, first of all,
don't be so ominous. Don't sound.
He's trying to scare me, my lord.
Yes,
Unfair
Mr. Thakkar.
I can never scare him.
Thakkar with a stress on the K. Yes. Yes. He doesn't stand a chance physically. Apart from escaping, maybe he'll be much better.
But Mr. Thakkar has put on some weight. ওই রকম
1% and 2% out of 100 is minimal.
Everyone tells me the same thing. If I lose a kilo,
When
they said.
comparing with 100, 1 and 2 are.
But I also hear the same thing. If I lose a kilo, they said out of the sea only one bucket. And look who's talking. Look who's talking.
Some people go for morning walks in the morning and they have a morning walk and then have kochuri and all. Yes. Right. Yes.
Now,
So whatever Mr. Thakkar, deal with him quickly.
Very quickly,
Yes, dispose him off.
No.
Rather his argument.
Mr. Thakkar today has come up before a lordship. RERA, taken the point of RERA.
Yes.
That he could have taken before the trial court, not any kind of suppression. Because I have said completion certificate has been obtained.
Yes.
Now, RERA, as it fell from your lordship also, there are penalties which can be imposed.
Yes.
And it is to be adjudicated by.
No, not that. He says that this injunction will, put him to the peril of those penal action by his.
By RERA authorities.
RERA authorities.
That has not come up as yet. Completion certificate. As far as now sought to get from the internet, the completion certificate has been in somewhere in May 2025.
3 months.
So within 3 months, they are already in violation. Why are they completing against me? So whether they're in violation or not, whether that is a ground, that should be before the trial court.
Another point was that this 25% out of you own NL own 25% out of 50% of the shares in.
So the monetary value, that's what he's saying.
Not assets.
That is what he's saying, monetary value.
Can you get an injunction on the assets?
And I said order 39 rule 1B. On that basis, I'm asking for an injunction, because they have caused fraud on me, but they are not giving me my share.
No, he says that you had a share not in the assets but in the company. That's his submission.
But I have read 2009.
But that annexures, those annexures say that in the assets also.
In the assets.
Annexure E probably, E or F.
Annexure E.
assets. Another thing is that from his these current returns, which you have not placed, those are public records, he said. The 2009 that agreement was not acted upon. It's apparent, Mr. Thakkar says.
Malad, that is,
Because
kindly sees, first of all, Malad, I take this point, Malad, 2009 returns, they were not before the trial court, Malad.
That's there.
And Malad, that they should file, Malad, it is not a question of suppression. Just because it's available on the internet, on the web, Malad, it does not mean that I have suppressed. That's not a material fact for me. Then, Malad, there would be nothing left for the suit. And now let us take, Malad, whatever. And Malad, that it was in May 14, 2025, completion certificate was issued. It is paragraph 12 of the appeal of Mr. Thakkar.
That is
11. No?
59 or 64?
APOT?
No, his is 59.
His is 59.
Very good. No, in somewhere you have also admitted about that completion certificate in your plaint or something.
Yes, yes, I have. I came to know completion certificate is granted, Malad.
Very good.
And if completion certificate is not granted, then Malad, the threat of disposing of flats would not arise.
These are the three primary arguments made by him, if you recollect properly.
And Malad, he was referring to these returns and he did say that I was not a partner in this. Malad, let him say that before the trial court. I will deal with it. But today kindly appreciates Malad, even if Malad, they have never saying, Malad, your lordship,
you may have a counter argument that you not being made a partner in the LLP after the conversion is itself a violation of 2009 also.
That is what the Annex Sheriff affirmative. Malad, that is
Maybe
my
a counter argument.
And that is also my pleading, Malad, in the suit. Your lordship will find the pleading there.
But you are not brought in the...
Yes, because it is contrary to the affirmative
affirmative rights, yes.
Now, Malad, what a court judgment is exactly. Malad, unreported Calcutta, Malad, your lordship's...
Apart from Bengal Club, which was cited by Mr. Banerjee, Mr.
But I've already dealt with Bengal Club, Malad. If your lordship, Malad, wants me, I can. But I'm saying that it's not...
No, the other judgment is Bacha Gazdar and another judgment of our court relying on that.
Yes, Malad. Malad, I am not saying, Malad, I'm not, I'm not joining issue with that proposition. But I'm saying the company is a party.
2009, yes. Very good. So this is all.
Malad, if your lordship permits, Malad, I was relying on Malad Jitesh Pandey, Malad.
How can you?
Malad, again, Malad, I say, Malad, what has been stated is the general proposition.
See if it does not fall within that palpable zone.
Palpable zone of knowingly suppressing material fact.
Then Jitesh Pandey should operate.
Should apply.
Interesting argument. Cite.
Or else, Malad, well, kindly, Malad, your lordship will also have to give effect to Order 39 Rule 4.
That has been dealt with in Bengal Club, has dealt with everything. That is a disease. Jitesh Pandey, Order 39 was not dealt with.
No,
Malad, could have been.
Malad, kindly see Bengal Club, Malad.
Must have been here.
Let us go through Bengal Club.
Order 41-33 was relied on. Order 41-27 was one of the considerations. Order 41, that was countered by Order 41-33. See, Mr. Rai, let us be very candid. Even if you don't agree with this judgment, we are bound by it.
I know, but again, I'm trying to distinguish this judgment.
Some decorum in judicial
law. No, I know, Malad, I'm not saying that. I'm saying...
Cannot just, for the sake of it, we can't say, no, I rely on Jitesh Pandey in the teeth of this judgment. We cannot do that.
Malad, division bench has also Malad, followed Jitesh Pandey. But the point is, Malad, yes, don't talk about it.
Bengal Club has not followed Jitesh Pandey.
No, other division bench later on, Malad, not cited, Bengal Club not cited, have followed Jitesh.
The other one cited by them?
No. There are judgments.
Whatever you cite, cause.
But my lord, first, my lord.
But then the subsequent judgments are par inquiry. I mean, Bengal Club is not taken to.
But first, I want to, here, Jitesh Pandey, if your lordship kindly sees in Bengal Club,
Bengal Club dilute করে দিয়েছে 3944 scope to read 4133
kindly reads
final decree against
paragraph, sorry.
Actually 4133 scope is, I mean, more linked with final decree appeals against final decree, because the language is also that.
Kindly
but that's binding. Yes, let us not reopen this.
No, 43, kindly see 43(1) of
43?
Bengal Club, para 43.
Yes.
Having regard to the importance of pleadings at this stage, if the appellate can establish with the appeal court that the pleadings in the court below do not follow the aforesaid standard, in our consideration, he is under no obligation imposed by any law to accept the pleadings of his opponent in the trial court as true and correct. Well, if the principles of Jitesh Pandey are accepted, then apart from that fact, they'll have the effect of certifying the right of appeal. This is only in that part of it, that the pleadings in the court below do not follow the aforesaid standard. That my pleading
before Bengal Club, it was a settled position that the
everything
appeal is a continuation of that. I mean, appeal is like a pyramid. I mean, it is restricted to the original jurisdiction.
Absolutely.
So if the original court was bound by, has to take as sacrosanct the plain pleadings, injunction application pleadings, and on the basis of that, whether he is entitled to injunction.
Absolutely.
That has been diluted. That has been expanded by Bengal Club.
What is Bengal Club diluting? Has Bengal Club said Jitesh is absolutely wrong? It is saying, kindly see, it
has not said absolutely.
No, cannot. Then order 39 rule 4 will go.
Said, but otherwise, it has been held to be wrong.
No, kindly sees. That is what I'm trying to say. Kindly sees this. Having regard to the importance of pleadings at this stage, if the appellant can establish before the appeal court, this needs to be done. Then only the order 39 rule 4, as Jitesh Pandey has said, is not binding.
So the pleadings have to be otherwise deceptive and dishonest.
That is what I'm saying, my lord, and that has also been followed in, my lord, paragraph 48, the first sentence.
Everything was known to you. You have suppressed facts known to you, but whether that was of material facts. Non-disclosure need not be suppression.
My lord, what it says, suppression of facts unknowingly. My lord, I would have to know that this fact I have suppressed for the purpose of
knowingly is relating to the facts. You did not know of the facts.
No, I thought it was a suppression. But whichever way it goes, I thought that it was a suppression, that I knowingly suppressed the fact, because it becomes a part of the pleading then.
Facts have been proven to such an extent that the real state of affairs are not disclosed.
Not disclosed.
Clear
real state of
candor on the part of the plaintiff. So it has to match that standard.
That standard.
Very well.
Or else Jitesh Pandey, then order 39 rule 4, there will be nothing left of it.
Nothing left in the injunction application itself. Not why order 39 rule 4?
Yes, because no. Then everything can be before the appeal court. Everything before your lordship's court. Faster, I suppose.
In fact, that is one of the reasons we don't normally call for affidavits at the ad interim stage in the appeal.
But my lord, here what has happened, before your lordship calls for any affidavits, my lord, they have disclosed their defense in their state petition.
They are the appellant.
So they have disclosed them. So my lord,
whatever they like.
That is why, my lord, I am taking the point, my lord. 2 points. One, can they take, my lord, here it's a different thing, not suppression of fact. Whether they are bound by the pleadings, or your lordship will be required to look into their RERA certificate, incorporation, emails of customers.
Not RERA certificate. Mr. Thakkar is saying
the point of RERA.
The point of RERA in the sense that they're prejudiced. How they'll be prejudiced by this injunction order.
Well, yes.
Absolutely. That also the balance of convenience. He's on the balance of
convenience. But my lord, at that point of time, kindly appreciates, my lord.
So you say that
RERA is not my lookout.
No, not only that, you said also that balance already tilted after expiry of 3 months from May.
That is obvious.
Your injunction came.
Your injunction petition only says. So this is basically an afterthought trying to get something out of this appeal. Maybe that would also, if any action is taken by RERA, then they can say something out of this court's order. I don't know.
Point to you, yes.
Sorry,
they can point at you.
Yes, that they can. And they'll get extensions, my lord. So, my lord, that is what I'm on. So, my lord, Jitesh Pandey, my lord, kindly, my lord, it shouldn't be that it is.
Side Jitesh Pandey,
Yes,
whatever you have to side.
এটা তো বলছি পারি কি বলছি
ওটা ফ্যাক্টরি 30 অসম্ভব হলো 4 ডিগ্রি পাস করেনি সেটাও পাস করতে পারবে না
কি হচ্ছে
In fact, order for 33, I mean, if applied to at the addendum stage, we don't know.
This will be the Japanese court, man.
Why Japanese courts do?
And the first day, they from the plane to the end, appeal, everything one day.
To the appeal?
Yes, they do it in one day.
No, don't. You're taking undue advantage of the fact that we don't know anything about Japanese.
But I'm not making that as a submission in this proceeding, my lord. Something of that sort happened to me.
Up to the appeal, it happened to you in Japan.
I was told file immediately. I said it will take a lot of time.
You went to Japan to?
No, not for that. Something happened there, my lord, for which I was required that I might approach the court. So I said, what will I do approaching the court against a hotel, my lord? They said, no, it's not a problem. We finish it one day. So I was completely astounded.
Must have been some advocate like
me.
Not like, obviously not like you. There are several advocates here who also give you the same assurance.
The Japanese are more known for their honor. So I don't know whether they would. Whatever it is, just a passing comment. Just a
appeal application Japanese. What else? Suit and appeal in a day.
Man, kindly see paragraph 16.
No, order 41 to 33 empowers the court to pass any other or further decree. Irrespective of irrespective of any challenge.
Yes.
Other or further degree is much more wider than.
Yes.
I mean, then in sitting in appeal over ad interim order, I can
pass the decree.
Pass the decree. Why not the degree?
Then, my lord, rest of the CPC chapters, my lord. Just you file it there and bring it before your lordship. Well, we'll be the happiest. I'm sure, my lord. I'll be the happiest.
You.
Obviously, my lord. We'll have so many matters before. Yes, one matter is good enough. Every day. My para 16.
Yes. But Jitesh Pandey was a learned of a learned single judge.
Single judge in revision, my lord. In 227.
227, yes, but single judge division bench in any event previous over.
No, I do not say that, my lord. I am saying
Jitesh Pandey was considered.
Yes, it was considered. I am saying Jitesh Pandey was also shown before that bench, my lord, the division bench, where it was found that
it would look very odd. The difficulties, I mean, if we differ with Bengal Club.
I know, for more reasons than one.
Particularly for one reason. Embarrassing for one reason.
No, I understand, man.
That is the only reason. Otherwise, we'll ask Mr. Banerjee why you should not differ from Bengal Club also.
Jitesh Pandey to the extent of
the order for 33 applicability is. Anyway, very good. Jitesh Pandey, para 16.
16?
Give us the paragraphs.
Yes, man. 16 main is well at 17. Sorry, second time for any of this.
It would be better if the judges were reversed. We could have easily. Yes.
Malad, kindly see 17, Malad.
17, yes.
Prepared to accept all the statements when the application of temporaneous is true, should persuade the appellate court, even if the allegations of the other side are true, the trial court ought not to have granted ad interim. But without showing cause as ordered by the trial judge or without filing any application, the order 3 Rule 4, in defense with the appellate court for the first time. Such procedure will be against the scheme of Order 39. Similarly, in such an appeal, the scope of investigation is very limited. Appellate court will only consider whether, on the basis of the materials on record, learned trial was justified in granting an ad interim order of injunction. This court is quite conscious of the provisions contained in Order 43 Rule 2, which says the rules of Order 41 shall apply so far as may be applicable. My lord, Order 41 rule be made applicable, provided, of course, the conditions mentioned therein are present. In such a case, the provisions contained in Order 41 Rules 28 or 29 are to be complied with.
These principles are very well settled. He must be, but if he decides to choose the above mentioned remedy, that is appeal,
yes,
over 39(4), he must be prepared to accept all statements made in the application for injunction to be true.
True.
And he should persuade the appellate court that even if the allegations are true, trial court ought not to have granted.
That is the case.
Is well settled.
Well settled.
That is probably the division bench proceeded on the last sentence. I mean the second last. Similarly, in such an appeal, the scope of investigation is very limited. Probably the division, apparently the division bench was irked with that last portion. That scope of appeal
cannot be limited.
Investigation in appeal cannot be limited. Appellate court will consider whether it went overboard. We have to consider that.
That is why I am saying, my lord,
this is the law we have known all along, even outside our chamber.
And I say, my lord, Bengal Club has been qualified by the division bench. It has, my lord, that is what I am saying. My lord, kindly read 43.
You were saying but not citing.
43, my lord. Bengal Club itself. But kindly read para 43 once, my lord.
Obviously, the foundational parameters have to be satisfied. There has to be a suppression of material facts in the first place. That is there. Nobody disputes that.
It's on the pleadings.
It's on the pleading. Yes.
On the pleadings, well, kindly sees 43.
Please come to 43.
Well, then again I say, Malad.
No, pleadings do not follow that standard, the aforesaid standard. Aforesaid standard being that, just see the para 38 onwards.
38 onwards, yes.
We have read from para 38 onwards, in fact.
Malad, such pleadings are clear, complete and candid.
Yes.
Malad, just para 38.
Because at that stage, there is no contested hearing. Therefore, party making the prayer must plead the entire facts of the case.
Yes.
So that is the standard which has to be followed.
So if I have pleaded that,
you say your entire facts have been there. German facts have been pleaded. You need not have pleaded the returns, current returns or all those things.
No.
And even the probate, because that was on a different footing.
Different footing. I have pleaded the probate.
You have pleaded.
I have not pleaded the refusal of an injunction.
Refusal of an injunction was not pleaded by.
That is what they say.
Yes. Right.
On that basis, then nothing will remain for Order 39 Rule 4.
Yes, anything else?
What 2007 to 2009. Vijay Kajaria. Embarrassments galore. Not always on your lordship.
Understood. Someone is. Thank God. Now it's balanced. You cite. Give them the citation.
Well, give him a copy. কপিটা নেই দাদা অ্যাকচুয়ালি
আমার নিয়ে নেবে
আমি আবার ফেরত দিচ্ছি
আগেরটাও দিলেন এটাও
আগেরটা দাও আগেরটা
previous one
জিতেশ পান্ডে
and for Mr. Thakkar also another
He's discounted.
You're taking utterly but he's dealing with you now. It's declared that now about Mr. Thakkar.
Four copies এতগুলো জজ
you should insist on a copy.
Ramalat will kindly come.
Revision application. Airdrop
No, you give them the citation there. That will suffice. Jitesh Pandey is Mr. Thakkar. This is 1999 SCC Online Cal. 1999 SCC Online Cal 460. That is Jitesh Pandey. And the present judgment is the last one is 2009 SCC Online Cal 2241. 2009 Cal 2241. Yes. Yes, sir. In this judgment, Bengal Club has been distinguished.
No. This is on a different point, Malad, because Jitesh Pandey has other parts of it also, Malad.
Yes.
Where, Malad, discretionary orders which have been passed, and unless it's not plausible, perverse, Malad, should not be touched by the appeal court. Kindly sees, Malad, this is internal page 10, Malad. And it will be on the top, Malad.
Yes.
After, Malad, just in the middle, Malad, the fourth paragraph. After considering the facts and circumstances of this case, and after analyzing those facts and the decision cited before us, we found that this scope of appeal is very limited. We accept that the facts which have been stated in the plaint and the petition have to be taken as true and correct. At this stage, after following the decisions of the division bench of
This was an appeal against ad interim.
Yes.
Yes.
Muktakeshi Daw and Jitesh Pandey, an in-time spectrum. We accept the contention of Mr. That when a discretionary order has been passed by the court, the said order cannot be set aside when such order is being passed, when the trial court applies the discretion without acting unreasonably or capriciously, or taking into account all the relevant facts of the case. Therefore, we do not find any reason to interfere with the order and furthermore the company, the nature of family concern or not. So, two things, discretionary order, unless palpably wrong, at the ad interim stage of appeal, should not be, otherwise,
Jitesh Pandey, there was a division bench also.
No, Malat. Because
it refers to division bench.
No, I'll just take your lordship. This Jitesh Pandey is
different Jitesh.
Yes, it is 2000 volume 2 CHN 856. Unmilota Cinema. That is at page 8 of this judgment. The one which I had shown, that has been referred by this division bench. Page 8,
Yes, it's the same one. Yes. But Bengal Club was not cited.
Bengal Club was not cited. That's why I say, Bengal Club again, I am saying, it's in the peculiar facts of that case and specific, parameters. I don't know. What are the standard principle? And
Yes.
There are documents which also will show that NL during his lifetime, NL Todi had during his lifetime filed affidavits before the courts saying that 2009 was given effect to.
We cannot go into
So that that is too much in depth. I don't think that needs to be looked into at this moment. Those are my submissions.
In the same order. Yes. Yes, Mr. Banerjee, you want to add?
I had his argument on Bengal Club. I wanted your lordship to reconsider Bengal Club. Kindly permit me, my lord. If your lordship, if
that is
there is any difficulty, my lord will say I will not make that argument.
No difficulty.
Then
Sitting
as far
on the
as
chair, nothing personal.
As far as the Bengal Club is concerned, there is a serious problem. There are two limbs of per infuria.
Manager, please take your seat because this is
Right. There are two
we were apprehending this for months, years.
Because this has to come.
Sometimes Bengal Club, if someone takes this point.
This has to be now settled because what
once I cited a judgment before Justice Ajayanath Rai. His lordship, unlike himself, eagerly took the judgment. Yes, we were waiting for that judgment to distinguish. Remember that vividly. Strike rate before his lordship was 0.
Yes.
not because he had any dislike for it.
No.
The matters were such.
Yeah.
But I remember that vividly. I cited a judgment. I was elated. Yes, we are waiting for the judgment to distinguish. Yes. So why on what ground?
Yes, only one.
Please no, you remain.
Just come.
Just is all right. Yes.
5 minutes.
No, he moves very slowly. His 5 minutes.
No, yes, sir, please. Yes.
Only one thing on Bengal Club. Please have a look at the Bengal Club judgment and the.
Yes, we have seen it.
There are just 4 principles, my lord, of 16 to 18. I'm supporting. I did not make any submissions on facts. They have been elaborately made. I don't want to waste your lordship's time, my lord, by repeating them. But on Bengal Club, my lord, I have one serious. Kindly have a look at Jitesh for a second.
Yes.
She has no locus. 17 and 18 building. কি বলি কার হয়ে আছো কার হয়ে ষোলো টু আট হ্যাঁ আরে নামগুলো বল না দুটো appeal না কার appeal 16 থেকে বলছিস সেটা তো বল।
Paragraph 17. May I just place paragraph 17 just once of Bengal Club to show that there is there is a ratio emanating from here. And then, Lord, I'll make my submissions on ratio very beneficiary. Please come to me, Lord, paragraph 17.
Yes.
In my view, a person agreed by an identity.
Paragraph 17 is not telling.
Oh, Lordship's para and my para.
Bengal Club. The Bengal Club.
Oh, no,
You're referring to Jitesh?
Jitesh.
Sorry.
Jitesh.
Yes, yes. Para 17. Para 17, which was placed.
Yes. In my view, a person agreed by an identity order of injunction. In my view, a person agreed by an
We
identity
know
order.
these principles, Mr. So, three possible recourses: 39(4), written objection, or appeal.
Now, if
one chooses appeal, then he has to accept whatever is there in the application.
But without showing cause as ordered by the trial judge or without filing any application under Order 39, Rule 4 of the Code, that's slightly down in the paragraph. The aggrieved person cannot insist on showing cause or placing his defense before the appellate court for the first time. This is the ratio. Such procedure will be against the scheme of Order 39 of the Code. Ratio again. Similarly, in such an appeal, the scope of investigation is very limited. The appellate court will only consider whether on the basis of the materials on record, the learned trial judge was justified in granting an ad interim order of injunction. All these forms part of the reasoning of the honorable judge. Two things, my lord, I am submitting here. Number one, according to me,
no, 4127 was also crossing our minds. That has also been dealt with here in the next paragraph. Therefore,
Yes.
an appropriate provision contained in 4127 may be made applicable.
This court is quite conscious, and that's what I'm trying to come to.
Yes.
This court is quite conscious of the provisions contained in Order 43, Rule 2 of the Code, which says that rules of Order 41 shall apply so far as may be to a miscellaneous appeal under 43. Therefore, in an appropriate case, the provision contained in Order 41, Rule 27 may be made applicable, provided, of course, the conditions mentioned therein are present. And in such a case, the provision contained in Order 41, Rules 28 or 29 are to be complied with. At any rate, in the case at hand, the learned appellate court
That is in the facts.
Please have a look at 28 and 29,
Yes.
just one. Not for my satisfaction. Software. So today or tomorrow, Miller, this has to be revisited. Why not today? Please see, my lord, Code of Civil Procedure, Order 41, Rule 27. Will not waste your lordship's time with 27. Only that 27(1), Order 41, Rule 27, Sub-Rule 2, wherever additional evidence is allowed to be produced by an appellate court, the court shall record the reason for its admission. So this it's an obligation cast on the court. Now, my lord, 28. Mode of taking additional evidence.
Yes.
Wherever additional evidence is allowed to be produced, the appellate court may either take such evidence or direct the court from whose decree the appeal is preferred or any other subordinate court to take such evidence and to send it when taken to the appellate court. Points to be defined and recorded. Where additional evidence is directed or allowed to be taken, the appellate court shall specify the points to which the evidence is to be confined and record on its proceedings the points so specified. So subject to 28 and 29, if they are exercised, 21, Order 41, Rule 27 is there. This is, my lord, a judgment delivered under Article 227. Under Article 227 in our court, it is part of the revisional jurisdiction where at the material point of time, any court which
115.
Oh, 115. This is 115, so that argument goes. Now, my lord, kindly has a look, my lord, at the division bench judgments which follow Jitesh. What I am saying is Jitesh Pandey therefore has been followed by division benches.
But
And the per interim test will come in later. Later. Please bear with me.
If they did not consider Bengal Club, has to be part.
This is, my lord, the two judgments which I had cited, my lord.
So this was cited by Mr.
Yes. So
don't repeat.
So I'm not repeating. Yes. Now, my lord,
Anindita, এটা
what
ফেরত
is
দিয়ে
the
দিন।
effect? Yes. What is the effect of this? The effect of this is
Yes.
one has to now construe to see what Bengal Club actually does. My lord, there are four basic rules of precedent which we all know, for which judgments galore can be cited, but I'm for the time being, my lord, restraining myself from doing so. Number one, a judgment is a precedent for what it actually decides and not what can be logically concluded therefrom. Number two, it is the reasons which operate as the precedent and not the conclusion. And number three, per inquiriam does not only take place if there is non-noticing of a statutory provision or a higher or coordinate bench judgment, but if after noticing it, it passes, the bench passes an order which cannot be reconciled with that judgment or
But
that
this is
provision.
not a higher or co-equal bench. This is a single judge decision.
Okay, so the
That
honorable
principle
division
does
bench
not
was not bound, but statutorily, if the provisions of the statute,
that would be a very tall order. I mean, statute has been interpreted here by the court.
kindly see, Milord, whether it has been interpreted.
Order
Please,
41 33
please,
has been taken
please
note
bear
of.
with me, Milord, when I take your
39.4 has not been, in so many words, has not.
kindly see what has been interpreted, and perhaps my lord will see what comes are only findings, what comes are only final outcomes, but not too much of reasoning. I'll show you, lordship, why. My lord, the reasons, what are reasons? In my opinion, this appeal is allowed and entitled to be allowed.
It's a dangerous trend, Mr. Banerjee. If you start distinguishing judgments, coordinate bench judgments on that ground.
No, but if your lordship doubts the ratio of that judgment, after seeing that that ratio does not exactly say.
Certainty, uniformity are also cardinal
principles, but of the ratio. My lord, but of the ratio. Please not. Now the Supreme Court is very clear on that, and we were always clear from the beginning. As far as our court is concerned, it has always been said that it is the reasoning which binds the court.
Yes.
It's not the conclusion. If my lord, in a given case, my lord doesn't entertain an order 41 rule appeal against an ad interim order of injunction, I can't cite that against Mr. Ratnakar Banerjee today and say, therefore, my lord's bench had held that
that proposition has to be argued and decided.
Decided, and reasons have to be given. Now, my lord, kindly.
The ratio, that reasons means ratio.
Yes, and that ratio is what is binding. Now, please see what the ratio is. If there are gaps in the ratio, please do not logically infer anything from there. Now, my lord, kindly see.
Difficulty, Mr. Banerjee, we are being very candid. If we refer it to a larger bench, anyways, leave it.
No, I can understand.
You argue. Yes. Argue. Continue. Yes. You cannot spell it out.
No, I can understand. But
let us continue. Yes. No. You. Whatever has to be done has to be done. Yes.
I may do it in some other case.
No, don't. Oh, you won't get any other. Argue.
Lord,
so which paragraph?
Yes, please have a look. Paragraph 28.
28.
Yeah. Onwards.
That was it.
Court is considering Muktokeshi and Jitesh.
Your exponent numbers which to which?
16 to 18. In this appeal.
Yes. In 59.
In the first one. Yes, in the Akshay Venu.
Akshay Venu, very good. Yes.
Oh, Akshar, I am 14 to 16.
14 to 16.
And in the other appeal, I am 16 to 18. I'll tell you, lordship, the other appeal. So 14 to 16 in Akshar.
Yes.
Lord, paragraph 26. It may also be noted in this connection, just 26. It may also be noted in this connection that a subsequent division bench judgment of this court in the case of Supratik Ghosh versus Pasari Housing Development, reported in 2000, volume 3, CLT 97, following the aforesaid pronouncements in Chadda and Morgan Stanley, held that the recording of grievances is mandatory if any ex parte administrative order of injunction is passed. Without recording such reasons, that order becomes null and void, and as the court lacks inherent jurisdiction to pass such orders without recording reasons. Observations to that effect are set out. Now, my lord, kindly come to 27. Of course, the attention of the division bench in Supratik Ghosh was not drawn to the earlier division bench judgment of this court in Muktokeshi. This court is in respectful agreement with the aforesaid pronouncement in Supratik Ghosh and cannot follow the contrary pronouncement by another bench in the case of Muktokeshi, AIR 1988, Calcutta 25, in view of the Supreme Court's judgment and the provision of Article 141 of the Constitution. In Muktokeshi, the learned judges, apart from deciding 2 points mentioned above, made a passing observation in paragraph 6 on which reliance was placed by learned counsel. Those observations are: the defendant has not as yet filed his show cause against the plaintiff's application for injunction, and therefore at this stage, all the statements made in the application will have to be accepted as true modo et forma. Relying on these observations, the learned counsel submits that at this stage, the court shall confine itself only to the averments made in the injunction petition before the court below and ignore the supplementary affidavit. This court is of the view that this observation made in paragraph 6 do not form any part of the ratio of the judgment in Muktokeshi, as the ratio of the said judgment has already been indicated. Apart from that, the purport of the observation in para 6 has become a little complicated in view of the use of the Latin expression modo et forma. The aforesaid Latin expression has been explained in Black's Law Dictionary 5th edition as follows: modo et forma, in manner and form. Words used in the old Latin forms of pleadings by way of traverse and literally translated in the modern precedents, importing that the party traversing denies the allegation of the other party, not only in its general effect, but in the exact manner and form which it is made. Wharton's Law Lexicon 14th edition explains the said expression as follows: modo et forma, in manner and form, a phrase formerly used in pleading. It was the nature of a traverse to deny the matter of fact in the adverse pleading in the manner and form in which it was alleged, and therefore to put the opposite party to prove it to be true in manner and form as well as in general effect. From these textbooks, it is clear that the said expression is used to explain the mode of traversing pleading of the opponent, and it has been stated that if such pleading is to be so traversed, the party traversing it is to deny the allegation of the other party, not only in its general effect, but in the exact manner and form in which it is made. Therefore, the proper meaning of the said expression can only be appreciated in the context of traversing the pleading and not while accepting it. But unfortunately, the said expression, the way it has been used in paragraph 6 in Muktokeshi, does not convey that meaning. Be that as it may, since the observations in paragraph 6 in Muktokeshi quoted above are without any argument and without reason, they do not form part of the ratio and are to be regarded as passing sub silentio. The apex court in Delhi Municipal Corporation versus Gundam Kaur held mere casual expressions carry no weight at all. Not every passing expression of a judge, however eminent, can be treated as an ex cathedra statement having the weight of authority. Please pause here for a moment. This was very much part of the Muktokeshi ratio. What I'm going at is a very subtle difference, but the difference is there. Please have a look at Muktokeshi.
That is M. Bhattacharya division bench. That's M. Bhattacharya's division bench.
Yeah, 1988 Calcutta 25.
25.
But saying that, now, my lord, what is being stated is the portion that has been accepted or quoted from Muktokeshi, para 29, go back please again, my lord, para 29 of this.
Yes.
The defendant has not as yet filed his show cause against the plaintiff's application for injunction, and therefore at this stage, all the statements made in the application will have to be accepted as true modo et forma. Let's delete modo et forma because the Honorable Division Bench finds, this Honorable Division Bench finds that modo et forma was not a proper expression to be used there. Modo et forma speaks of when you are dealing, you deal with the entirety in general cause, and therefore you shouldn't be using that phrase there. Let's delete that phrase. If we delete that phrase and you make meaning of the sentence, what comes is defendant has not yet filed his show cause against the plaintiff's application for injunction. So he's chosen one of the three reliefs that is coming up in appeal, and therefore at this stage, all the statements made in the application will have to be accepted as true. This is a statement, this is a reason, it's a statement of law. I'm asking myself with great respect, one cannot say, my lord, that this is not a ratio of Muktokeshi. Muktokeshi's ratio has been misconstrued while trying to read down Muktokeshi. Muktokeshi has been read down in a different manner. Jitesh in a different manner. Jitesh for 115. Had Jitesh been 227, then my argument would have been different because it's a constitutional court. Single judge takes up 227. I can show you lordship precedents to show that it is equal to a division bench's judgment sitting in civil jurisdiction. but then that's neither here nor there now. But for this, please, my lord, consider Gurnam Kaur's
The judgment which you decide to establish that was passed by the same bench.
no adventurous. Saurav Ganguly cover drive. That was one of the parting expressions in the Saurav Ganguly matter. We like it when he cover drives, but here in PIL jurisdiction, he has sneaked the ball. But coming back here, my lord, kindly see, if a portion of the ratio is not considered to be a part of the ratio, by treating that as a passing observation, then that would not be enough ground for the court to itself depart from what has been stated in that quoted portion. Now, my lord, I just wish I could show Muktokeshi. Muktokeshi, my lord, the device call. May I show you, Lordship, Lord, the portion on which it has been. Kindly give me a second before this boots up, no? Because this is important. Paragraph 6 is wholly part of the ratio. Please have a look at paragraph 6. May I hand up just one copy, my lord, please, if your lordship can just. I'm sending the other copies also. AI 88. Please have a look at paragraph 6. Please be satisfied when I submit, when I place paragraph 6, that this is squarely part of the ratio. Please see, my lord, the first paragraph, which sets the tone of what would be the question answered. What's the tone? The impugned order of ad interim ex parte injunction has been assailed by Mr. Roy Choudhury, learned counsel for the appellants, on more grounds than one, but none appears to be of that substance to warrant our intervention in this appeal. So that ad interim order of injunction was appealed from, and in that appeal, all grounds were taken which are discussed, and the court found that there is no reason for the appellate court to interfere. Now, in this broad context, please come to paragraph 6. Is it not part of the ratio? I'm asking myself. Please come to paragraph 6. On the merits also, we are satisfied that the trial judge was justified in making the impugned order of injunction. The defendant has not as yet filed his show cause against the plaintiff's application for injunction, and therefore at this stage, all the statements made in the application will have to be accepted as true. Please delete modo et forma. And when so taken, the allegations in our view make out a case for ad interim injunction. As and when such show cause would be filed by the defendant and the plaintiff's application for injunction would be taken up for final hearing, the learned trial judge would obviously consider such show cause and all such materials as would then be available to him, and would come to his own finding as to whether a case for temporary injunction till the disposal of the suit has or has not been made out, and he should do so being wholly uninfluenced by any observation made by us herein. As is well known, findings are right, etc. The portion that I have quoted to your lordship, Lord, this, in my reciprocal submission, squarely part of the ratio. Now comes the second per incuriam principle. Per incuriam has two limbs. First is an obvious limb. What is the limb? If you pass an order in ignorance of a judgment made by a coordinate or superior court, or in ignorance of a statutory or constitutional provision, it's per incuriam. The second is, if you consider a coordinate bench's judgment, but while considering it and answering it, you pass an order which cannot be reconciled with the provisions of law, then it's also per incuriam. I'll use the exact language. This I found while arguing another matter in MP Singh. The second part of per incuriam, frankly speaking, most of us don't argue too much in court nowadays. Just two judgments, my lord, I am placing before your lordship.
But Mr. Banerjee, this para 6 contain two parts. One is that recording of reasons under Order 13 Rule 3, that the provision, that scope. And the other is that the allegations have to be taken as sacrosanct.
Yes.
Regarding this Order 39, because Supratik Ghosh was accepted and Mukta Keshida was deferred from. So this deferred, the division bench deferred on the Order 39 Rule 3 part. It says that it lacks inherent jurisdiction. So it becomes void.
And I am on the first part. I'm on the other part. There is no difference even.
That part was never distinguished even in Bengal Club probably.
No, but see, kindly see, my lord.
Because here,
yes, I can understand what your lordship is saying. Yeah.
Because the consideration of Muktakesh and Supratik
was assignment of reasons.
Yes.
Assignment of reasons.
Yes.
So what is it saying? This court is of the view that this observation made in paragraph 6 do not form any part of the ratio.
It says that I agree with Supratik Ghosh.
No, it's quoting that part which I am referring.
Yes, exactly. This is we cannot also understand this. I mean, here Supratik Ghosh is
Supratik Ghosh.
Not that Supratik Ghosh is relied on by the division bench, saying that we bank on Supratik Ghosh, don't agree with Muktakeshi. Supratik Ghosh and Muktakeshi difference was entirely on recording of reasons Order 13 Rule 3. But then this division bench proceeds to on a different plane.
Different plane quotes a portion which is a ratio on a different proposition.
Yes.
Different part of the
That
ratio.
is, we are wondering that.
And it can't be reconciled. And this squarely hits me.
No, Supratik Ghosh, that reliance on Supratik Ghosh.
For the purpose of reasons part, I can understand.
That para 28 probably.
Yes.
29 something else begins.
Yes. Please see now. In Muktakeshi, the learned judges, apart from deciding 2 points mentioned above.
So those points are over.
Yes. Those points are over. Made a passing observation.
That is where you are arguing.
This is where I'm arguing. And in my humble submission, this is not a passing observation. It answers directly the question framed in paragraph 1.
Does it?
Yes.
This was not specifically argued.
No, but once I am at this stage, I will have to consider not specifically not argued would be cases like where there is a single line reference without any context to the particular legal proposition at hand. There I say, I wish this had been done. Those kinds of things are stray observations. These are, my lord, with great respect, this is a part of the ratio of his lordship. Clearly thought of ratio of a division bench, saying that at this stage he is not gone in for show cause and therefore we must accept.
But the first paragraph says that because Mr. Rajchodhuri's arguments were not accepted. So then we have to consider what arguments were made by Mr.
Yes, please see.
First argument was on this 39.3.
Yes.
Second is
Bengal Club. Kindly bear with me.
In para 2, if you Muktakeshi para 2.
Sorry. Para 2. Yes. So para 2 is now what Mr. Rajchodhuri submits. So first part is under provisions of 39 Rule 3, a court can grant ex parte ad interim before serving notice. When it is satisfied, shall record the reasons object of granting delay. Mr. Rajchodhuri has accordingly urged impugned order of ex parte injunction is bad, as no such opinion or any reason therefore has been recorded by the trial judge. It is true that the relevant proviso to Rule 3 as inserted by the Amendment Act of 1976 mandates recording of such reasons, and that for good reasons. Firstly, such recording of reasons would to borrow from the old Privy Council decision in Ganga Govind Mundal 1867 so-and-so, operate as a check against a too easy granting of an ex parte injunction and may inspire confidence and disarm objection. And secondly, since an appeal lies against such ex parte order of injunction, such record of reasons would go a very long way to help the appellate court to ascertain as to whether the discretion exercised under the rule to grant ex parte injunction has been properly exercised. But even then, we are inclined to think that the mandate in the proviso to Rule 3 to record reasons is not that mandatory to warrant reversal of an order solely on the ground of omission to record reasons. If there are materials on record to show that there were good reasons to pass an ex parte injunction order, the court cannot be set at naught solely on the ground that the court, while making the order, did not record the reasons for proceeding ex parte.
This argument was not made by either of the parties. The court, for the first time, this Muktakeshi division bench in para 6 says on the merits also we are satisfied the trial judge and then proceeds to hold these.
But then after that, if your lordship kindly see paragraph,
This was the law was laid down. The law was stated to be that, but it was not argued or adjudicated upon. I mean, this proposition was not argued by any party or adjudicated upon as such. Apparently, the court said that that is the law.
Court said that that is the law.
Suppose we today say that this is the law, but if there is no argument on that from both sides and an adjudication, then this judgment cannot operate as a precedent.
Because that part, my lord, what my lord is hinting at is therefore that part would not make part of the ratio of the judgment. Now, to that, my lord, my humble answer is how does one answer to a ratio? How does one call out a ratio from a judgment? Salmon's test is reverse it. If you reverse it and the decision still remains the same, then it's part of the ratio.
In other words, it was essential to lead to the conclusion.
What is the conclusion? What was the court examining? The court was examining the propriety of an ad interim ex parte order of injunction which had been assailed on several grounds, including merits. And therefore, my lord, on 6, he comes to, my lord, this conclusion. What I am trying to say is 6 doesn't really come as an offshoot of a different thought. Please see, my lord, para 1 carefully. I have not spent sleepless nights over it because according to me, after this, according to me, Bengal Club was, permit me to use the expression, but with great respect to their lordships, a bit of an ipse dixit. It was wishful thinking because 4133 being brought to the rescue of a procedural provision at the ad interim stage, according to me, my lord, does not stand the scrutiny of, my lord, law. But before that, before accepting my submissions, even prima facie, my lord, kindly see whether my initial submission is correct. Para 1 requires para 6. If it doesn't, I'm out. Then I'll not waste your lordship's time. Para 1 requires para 6. If it requires it,
we'll consider it, yes.
If it requires it, then para 6 can't be obiter. And passing expression para 6 definitely isn't. What has been quoted out of para 6 is a sumptuous sentence. Even that by itself isn't a passing expression. Para 6 taken as a whole is definitely not a passing observation. Even the portion extracted is not a passing observation. It says on merits at this stage, uses a wrong Latin term. I don't know what the right one would be. Therefore, I'm cutting it off from that sentence. Eo nomine means my name. Ed out or something has come in, which in law means different. So I'm asking myself, I cut it off. And lordship can sever in order to find whether there is any sense or no sense. Even without that, it's absolutely clear.
We even can't understand why Bengal Club said that modo et forma is improper use.
It was proper use.
I mean, modo et forma is as rightly held by the division bench in Bengal Club in manner and form.
So in manner and form, you have to
exact
treat
manner and form
exactly as it is there.
As it is
you have to treat it as true and correct. So
taking that, whether on the basis of those facts,
court would have granted the additive injunction on
that has been the consistent test.
That is and therefore, my lord,
Bengal Club.
Before now, my lord, with Bengal Club, modo et forma is, my lord, 2 definitions, my lord, of modo et forma are taken, which really do not take away from that view. Number 1. Number 2 is, no, my lord, this answers the second test of precedent. That is what I'm saying. Earlier, my lord, in my ignorance, I thought precedent only has 1 limb. Now,
I'm still ignorant. I mean, unless I see the judgment,
the second,
I still think the same. That contrary to existing judgment or
no, there's a second part cannot be reconciled.
I'm still ignorant on that.
Please, Lord, grant me. Because I had come prepared on facts, but Mr. Ray has argued facts extensively. There's no use arguing facts. Lord, the proposition. The proposition is this.
Yes.
A decision or judgment can be per incuriam. This is the second one.
This is from particular judgment.
No, I'm just giving you the proposition, then 2 judgments to follow. This is the proposition. A decision or judgment can be per incuriam if it is not possible to reconcile its ratio with that of a previously pronounced judgment of a co-equal or larger bench, or if the decision of the High Court is not in consonance with the views of the Honorable Supreme Court. Please see 2017 law. Kindly see law 2017-14 SC.
That falls within the previous category.
Yes,
Yes.
but there is. I'll show you. Lord.
Supreme Court is not in consonance, and the entire thing, in fact, it falls within the first category. Then
That is fine.
not a new category.
No, reconcile. There are two categories. You have to reconcile.
Contrary to and cannot be reconciled with a, I mean, in a sense, interchangeable.
Now,
with the previous judgment of coordinate bench or larger, higher strength bench.
My humble submission is reconcile part is a different category. I'll show that, Lord, for your lordship. NPCA, the statutory interpretation. GPC. For that, I am citing Roger Shashua versus Mukesh Sharma, paragraph 42.
Sorry, paragraph 40.
42.
Yes.
In Sandeep Kumar Bafna, the court referred to the Constitution Bench decision in Union of India versus Raghubir Singh and Chandra Prakash versus State of UP, and thereafter expressed his views thus. Paragraph 19 is quoted. It cannot be overemphasized that the discipline demanded by a precedent or the disqualification or diminution of a decision on the application of the per incuriam rule is of great importance, since without it, certainty of law, consistency of rulings, and comity of courts would become a costly casualty. A decision or judgment can be per incuriam any provision in a statute, rule, or regulation which was not brought to the notice of the court. A decision or judgment can also be per incuriam if it is not possible to reconcile its ratio with that of a previously pronounced judgment of a co-equal or larger bench, or if the decision of a high court is not in consonance with the views of this court. It must immediately be clarified that the per incuriam rule is strictly and correctly applicable to the ratio decidendi and not to obiter dicta. It is often encountered in high courts that two or more mutually irreconcilable decisions of the Supreme Court are cited at the bar. We think that the inviolable recourse is to apply the earliest view, as the succeeding ones would fall in the category of per incuriam. Now, the second limb in my reciprocal submission, if the ratio of that decision of the judgment in question of Bengal Club
is not
cannot be reconciled
with what?
With the ratio of the coordinate bench, then it's per incuriam.
Which coordinate bench here?
Muktakeshi. Yes. Muktakeshi para 6. I'll tell you. So you can't wish away a judgment. It's like this. Sometimes, Lord, we have argued this, Lord, almost ad nauseum in our younger days, that the moment you notice a judgment in your judgment, coordinate or higher, but don't say too much about it, or do not appreciate the ratio about it, you can't take that point anymore because you've noticed it. Once you've noticed it, that means that judgment, good, bad, indifferent, has been noticed by the court. However, that's not the law. The law is, if its ratio cannot be reconciled with the ratio of that coordinate bench judgment, then by itself, it's a limb for per incuriam to be held. It's not necessary that that particular coordinate bench judgment was not placed. It would suffice if the ratios can't be reconciled. Now, please have a look at this.
That comes within the broader purview of regular per incuriam. And then it's contrary
it's a
to
second limb. They say it's a second limb. I'll tell you, Lordship. GP Singh shows it's a second limb.
Previous.
GP Singh says it's a different limb. Why they are saying it's a different limb is this: if you miss out, then it's one thing. But even if it is placed and you make short work of it, it's still per incuria. If you make short work of it, what you could have done is, judicial discipline says, if you thought that you don't agree with the
It
ratio,
does not say that. It says only if a decision of a high court is not in consonance. No, sorry. It is not possible to, if it is not possible to reconcile its ratio with that of a previously pronounced judgment of a co-equal or larger bench.
That's the co-equal bench.
Which is also,
that's the
if it's
co-equal
contrary to.
It's a co-equal bench.
If
No,
it's
ratio has to be consistent. Ratio has to be consistent. Otherwise, you have to send it up. That's judicial discipline. You can't say no.
Yes.
So therefore, please apply that now as an additional appendage to this argument. If it is inconsistent with the ratio of an earlier bench judgment, then you are, as a coordinate bench, duty bound to send the matter before the Honorable the Chief Justice for sending it to a larger bench. But if your ratio cannot be reconciled with the ratio of a coordinate bench also, then you have no, then one cannot pass a judgment saying that irrespective of that, my judgment should prevail, number one. Number two, one cannot interpret something which is ex facie not the case. This is also, my lord, a limb of per incuria. What is ex facie not the case? Please see the portion that has been quoted, my lord, that portion of thing that had been quoted, my lord, in paragraph 6.
No, we also don't understand this dwelling so much on modo et forma.
Modo et forma
does not lead to anything.
And because it didn't lead to anything, the next two paragraphs after that, modo et forma goes to sleep, if I might use the expression, with great respect to everyone. Modo et forma doesn't lead us anywhere. Number one, if you interpret modo et forma, it would mean in the manner and form as it is, which makes perfect sense here. Even if it doesn't, what was the honorable bench passing that decision thinking about by saying modo et forma means something different? Does it upset the remaining part of the sentence if you delete
that is what you don't understand. Even if modo et forma was improperly used, then how can that be a ground for saying that that is a bad law?
Therefore, that is what I'm saying. So your decision in Bengal Club cannot be reconciled with the ratio of a previous coordinate bench.
Very good.
If it can't be reconciled, then this becomes per incuriam. Lord, just another judgment, Lord, while on this, I'll just place 2014, volume 16, 623.
You got a copy of that? No.
No, I've got a copy. Anani. Will you give me 10 minutes tomorrow? It's 4:26. So just 10 minutes tomorrow. I'll come back with this. I assure you, Lordship, Lord, this is an established.
How many more judgments will you cite? One.
Maybe 3 or 4, but completely trite on Bengal Club.
Within 10 minutes, Mr. Tomorrow we'll keep it tomorrow. It continues. Hard in part. Since the two appeals arise out of the same order, although by different parties, we take up both the appeals together for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Next para. Since arguable questions of law and fact are involved, the appeals are admitted to be heard on the grounds taken in the memoranda therein. Next para. On consent of the parties, we take up the appeals for hearing along with the connected applications. Next para. Heard in part. List the matter for further hearing tomorrow. Keep it tomorrow, Mr.
Sir, only one request. I don't know how long Mr. Banerjee will take.
10-15 minutes, not more than that. On this point.
Only on that
point. I'll need after that 15 minutes. I have only one matter. Let's fix before.
We'll adjust among ourselves if necessary. Mr. Thakkar will make his submissions and then we'll hear you out. Whichever way.
May I take back the bail, please?
আবার তুমি রিপ্লাই কি আমার